Good morning. Happy Thursday. Here we are at the almost final day of the trial. I will be appearing to you. Actually, I should say good morning and welcome to the Canon Girl Theories. I am Christina, your host, and I am happy that you're here. And welcome to Day Thursday. Wait. Welcome to the day before we see final arguments. Is that better? I'm trying to wake up, y'all. I'm trying to wake up. So yeah, we're at the day of the last day of witnesses. And so yeah, that's where we are. I know that we will be hearing one witness this morning from Johnny Depp and two witnesses apparently that were announced yesterday that come in for the Heard team. So I have been trying to wake myself up and kind of peek at Twitter. AH is back on the stand today. That was confirmed by the DUI guy about an hour ago. So that is what to expect. Y'all, this has been really grueling, I think, on a lot of people. I think most of us, probably any of us that are trying to do this, it's just by the end of the day, man, your eyes are crossed. So yeah, I woke up. It's so funny too, because I woke up yesterday. Let's see, I think I fell asleep about 5 o'clock in the evening. Woke up about 8 and was like, I'm late because your 8 is my 6. Or yeah. Anyway, I just got scared. It said 8:30 and I said, "Oh my God, I'm 2 hours late. I'm 2 hours late." And my family was like, "What is your problem? No, you fell asleep and you woke up." They were like, "You're delirious." I was like, "Yes, I am." So, oh, Laura didn't get to go today. So we're going to take a look at Twitter highlights in just a moment. I have not really been able to catch up with anything because I was so tired yesterday. Plus, I had to take care of business yesterday of my own. And so that's what I kind of did. So I didn't really check anything. I didn't want to kind of really be connected because I had real life stuff to take care of. So I kind of stepped away. I finally was able to get the audio, the Johnny Depp Amber Heard audio done that I was intending to do a few days ago, but it was a very long download. It was terrible. It was like 10 hours. I was like, why is this audio file taking so long? So right now, before I go ahead and include you in Twitter highlights, morning Twitter highlights, I'm actually looking to see what's going on first so I can make sure that I'm pointing out stuff that means something. Let me see. Let's see. There's 35 more. A lot of the tweets started way, way earlier because y'all are 3 hours ahead of me. Yeah. There's a lot going on Twitter, even this morning and yesterday, about how Amber Heard's grin and her facial expression was just unacceptable, which I think is very, very on point for a lot of people. I think her demeanor yesterday was not good. So I did watch the live stream. I watched the after live stream of Legal Bites. I watched the after live stream of Emily D. I watched the after stream of, is it Reichart? Is that what I'm thinking? Reichart Law, which had Andrea Burkhart on there, which was fun because I like her. I discovered her on Christina Pickel's channel, and I didn't know. I thought she had a channel and wasn't sure. So a lot of you, I go audio if you're new and if you're viewing me. I go audio for the first 10 or 15 or 20, maybe 30 minutes to get myself camera ready. And then I go ahead and I share the camera view of me, not to scare too many of you. So yeah, we had a lot of interesting things. I mean, a lot of people were talking about how effective Kate Moss's appearance was. I think so too. I think the short and brief was a good idea. I think, just to confirm that she did not indeed fall down the stair, was pushed down the stairs or kicked or hit or whatever. I would have, I don't know if it matters, but I would have liked to hear her say, when she said I wasn't pushed down the stairs, I wasn't kicked. I would have liked to hear her say I wasn't hit too. Just to kind of throw it out there so that the jury could ponder on that. And it was a 4-year relationship. So, as you guys know, earlier I tried to say I wish Winona Ryder would have been able to speak. Someone did mention that I guess she did offer, but apparently she didn't get accepted or something. I mean, I'm not sure because I'm new to the case. I don't have the deep dive stuff that most people do. So I'm kind of, a new commentator on it. But it would have been nice because Winona Ryder was really in love with him. I never read up though, so I never read up a why Winona Ryder and Johnny Depp did not survive as a relationship, as a long-term relationship since they were engaged. I don't know if him and Kate Moss were engaged. It seems like it seems like most of his relationships were around the 4-year mark until he met Vanessa Parody, I think is her name. But and that was obviously the longest relationship he had with the children and stuff. So that's a good longevity, I think, for anyone to comment. And she already wrote a statement as well, which I thought was good. That may be old news to a lot of you, but for me, it meant a lot. The TMZ guy, I think, was really effective yesterday. I love the way he challenged Elaine. So that was really fun to look at, fun to see. So I'm going to go ahead and share my morning Twitter highlights. I did make myself a cup of coffee. Court should be in session in just a few minutes, so I need to start sharing the screen anyway. So let me go ahead and get to that, and we'll put that side by side so we can check out what's going on. What's going on? Yeah, what's going on? I've got a bit of a lag on my apps. I should have restarted my computer, but I decided not to, which I'm not sure if that was a good idea or not. Okay, so I'm going to share my screen now, and let me add this to everything. So let's add this to the stream. We'll put this up close for now. So we're looking at Twitter highlights right now. Actually, I guess it would be a better view to go ahead and do this. So like I said, this is what I was looking at just now as I was commenting. I went ahead and pinned up my live stream. If you guys want to, it'd be really helpful if you want to share my link on any of your personal socials if anybody wants to chime into these last couple of days of court because they are so important. Like I said, the DIY guy did confirm that Amber Heard will be on the stand. God, they're going to torture us with her again. That's going to be fun. So that's in effect, apparently, and she may be their first witness. There was a lot of talk in the LawTube community that I saw that was talking about, was it really a good idea to put Johnny Depp back on the stand yesterday? I don't, I mean, to me, even after everybody examining those texts, I don't know. Like I said, I didn't really hear. I heard Emily D consider that the text messages were considered that they were not outgoing from Johnny Depp. I think that makes a lot of difference myself, just because even when he was reading them, I think it was a natural reaction that he said, "I didn't write that." Like because you could tell when he was reading when they were actually you could tell when he was reading it that it wasn't his writing. Johnny Depp has a very distinct way of speaking. You know what I mean? Even in his text messages. So for me, it's like I didn't think he wrote it either. Just to say. Let's say good morning to Twitter, shall we? Um, let's say good morning, everybody. Can I say moaning? Tweesters. I call everybody tweesters. That might be kind of silly, but let's see. I guess I could say join me as I live. This is something I should not do on camera, huh? Oops. But the DIY guy is he's putting us, filling us in right now. Okay. Do one more. And then do this is for Johnny Depp, which is trending. Elaine is trending this morning, as you can see on the right there underneath my twister. Let me do Johnny Depp. Oops, I didn't mean to do that. I need a trial. Did I already do that? We'll just go ahead and do it like that and add something. I need to get my coffee. I brewed it, but I was like, oh crap, it's 5:45. It's 5:45. I need to get in there. I was able to sneak in. Oops, I was able to sneak in a shower, which was what am I doing here? I'm trying to do a GIF, but it's not working. Because I got to get my butt up on Sky News, which Sky News is, we're going to be able to see them in a second. I do have it ready. You should be proud. I do have it ready. Mornings, you guys, are just, I'm not a morning person. I'm trying to make myself be a morning person for this trial. I'm really lagging this morning for some reason. Can I just say good morning to the world, please? Computer, will you please let me? I have 3 people watching. Hello, good morning. I am just trying to squeeze in a tweet of good morning, but it's not working. Good morning. Oh, hey, how about, I was going to do Robin Williams, Aladdin. It was so sad when he passed away. I'm really worried about Bruce Willis, you guys. I'm really worried about him. I know he's suffering with this new thing, this new what he has looks a lot like, or resembles. That's funny. Look at that. That's funny. Oh my goodness. These are funny. I guess I could, I never can figure it out. I guess like people like cats. I'm not a cat fan. People like cats, right? Anyway, I'm really worried about Bruce Willis. I saw him. There was an article in I'm going to stick to this one. I like this one. It's speaking to me. I'm not a big GIF person. I've never used those before. Anyway, I'm really worried about Bruce. That's all I'm going to say. Yay. Okay, they're on. So let me bring in, it's kind of perfect timing actually. So let me bring in Court. Let me turn on the sound. Corn is almost in session. We've got about 2 minutes. So, we're on mute until they actually go live. So thank you guys for your patience. I shouldn't have tweeted out loud like that. I should have waited. So my apologies if you were irritated on that. I could see why. So remember, they've got one final witness. Johnny Depp's team has one final witness. Mr. Depp is looking mighty handsome in his, I don't want to say, what color is that? I'm not sure. Sand, maybe? Looks like sand to me, like a sandy brown. I always look at his ties. His ties are usually really nice. So we'll see. Court is getting ready. Oh, I got to change the resolution. Nobody's here to remind me. Let's see. Okay. So, ooh. He always plays reggae in the morning. So they say. I don't know. I haven't been there, but. Good morning, Mr. Depp. Mr. Debonair. Good morning. Good morning. Good morning. He's so sweet. God, that's got to make him feel so good. Just that the public is standing by him. That just has to make him look so. That has to make him feel so good. Aw, I love his voice. Just saying. All right, I'm gonna try 1080p, you guys, today. I'm going to try. I know I'm pushing it. I know I am because my computer, as we've learned, my computer is not necessarily made for that kind of power, but we'll see. We'll see how it works out for me. Ooh, ooh, ooh. I think my sound is a little loud, but let me see. Let me do the mixer. Make sure. Our sounds are pretty good, I think. I don't think we should have any echoes this morning, even with me talking. They boo Amber Heard. Her hair, man. Whoever is doing her hair, she didn't get booed as much as she did yesterday, so that's interesting. So weird.
Do we have any preliminary?
All right, I'm going to mute myself, you guys.
Okay, sure. You want to come forward?
Okay, so I was muting myself, but I guess I don't really need to. Let me get myself situated here so I can have a full screen for you all. So I'm trying 1080p today, just in case you are watching the stream. We're going to see how well it works out for us. We may have to switch to 720. I don't know yet. We'll see. But a lot of times when I watch from my phone, it looks pretty clear and pretty motion. The motion is pretty good. As you can see, though, I tend to have oh no, it's baby Hobbit born. Oh God, you guys, I don't know if I'm going to be able to survive baby Hobbit born. I just don't care for that guy. He came off no one liked him yesterday, which I was so happy to hear because I was like, oh crap. What if I'm saying he's like yucky and everybody likes him? I did not like him. He came off too strong, too arrogant. I didn't think that looked good for their team. Maybe I should just I'm worried about having 1080p, you guys. I don't want a lot of buffering. We're going to stick with 720. I think it's safer. I think it might be better in terms of, saving me from buffering so much. But we'll see. So we shall see. We shall see. All right. So we full screened that. I am going to try to put some makeup on my face here while I'm watching with y'all. I'm going to go get my coffee. Oh, there's baby. Is that baby Hobbit born right there? I don't care for that man. I gotta see what Twitter's saying about him. I don't think he rubbed anybody the right way yesterday. Oh my goodness. Let me go over here on Twitter on this side and see what people are saying. I put up the Twitter. I have the Twitter app open too. I wonder if I can just use that. Let me move this over here. Sorry, you guys. See, whenever I try to... Let me see if I can move this. I can. I don't think I need to use this other one. I think I can use... I just don't know if that's going to help. 1 hour ago. There's lots of tweets going around though. Okay.
All right. Good morning, ladies and gentlemen. All right. Have your seat. All right. Your next witness.
We call Dr. Richard Gilbert, Your Honor.
Dr. Gilbert. Yeah.
Do you solemnly swear or affirm to testify truthfully in this case under penalty of law?
Good morning, sir.
Good morning. Good morning, Dr. Gilbert.
Good morning.
Would you please state your name for the record?
Richard Stephen Gilbert.
And what is your occupation?
I am an orthopedic surgeon and I have a subspecialty training in surgery of the hand and upper extremity.
Dr. Gilbert, where do you work currently?
I currently work in New York and Long Island at Northwell Health.
And you mentioned you have a specialty. Can you tell us a little bit more about what your specialty is?
So after medical school, I trained in orthopedic surgery and I did an orthopedic surgery residency. And for a year thereafter, I did a hand and upper extremity surgery resident fellowship. And so my practice for the past 22 years has been limited to surgery of the hand, wrist, and elbow.
And I think you may have gotten ahead of me there, but how long have you been practicing?
22 years.
What percentage of your practice over the past 22 years has involved surgery?
Approximately 1/3 of my practice.
And other than that 1/3 that involves surgery, what does the rest of your practice entail?
The rest of my practice entails some academic work, but mostly seeing patients in the office, seeing them either pre or post-operatively. A large portion of hand surgeons treat patients non-operatively.
In terms of the surgeries that you do, can you describe for us the types of surgeries that you will perform?
So again, I limit my practice to hand, wrist, and elbow. I would say approximately 75% or so of my practice is limited to the hand itself. And this really varies from anything from conditions like carpal tunnel syndrome to tendonitis to injuries such as amputations, fractures, sharp lacerations, etc.
Over the course of your 22 years of practice, how many surgeries would you estimate you've performed?
I perform about 300 to 400 surgeries a year, so a rough estimate would be approximately 10,000, maybe a little less.
Where are you currently licensed?
In New York.
And how long have you been licensed in New York?
I have been licensed in New York since 1994, so that would be 28 years.
And do you have any certifications?
Yes.
And can you tell us about those?
I am board certified by the American Board of Orthopedic Surgery, and I have a certificate of added qualifications in surgery of the hand from the American Society for Surgery of the Hand.
When did you receive your board certification?
2002.
And can you describe for us what current positions you hold?
I am currently an assistant professor of orthopedic surgery at Northwell Health, and I'm also the president-elect of the New York Society for Surgery of the Hand.
In what professional organizations are you a member?
I'm a member of multiple orthopedic organizations, including the American Board of Orthopedic Surgery, the American Association of Orthopedic Surgery, and the American Society for Surgery of the Hand, as well as the New York Society for Surgery of the Hand.
Have you published any articles in your field?
Yes, I have.
Have you testified as an expert before?
Yes, I have.
Can you ballpark for us how many times?
Certainly less than 10 over the past 22 years.
Your Honor, at this time, we'd like to offer Dr. Gilbert as an expert in the field of orthopedic surgery, specializing in the hand.
All right, any objections?
No objection, Your Honor.
So moved.
So Dr. Gilbert, what work were you asked to do in connection with this case?
So I was asked to review medical records, radiographs, pictures, as well as testimonies and depositions related to Mr. Depp's finger injury.
Okay. And to your understanding, what is Mr. Depp's explanation of how his finger was injured?
He describes that he was in Australia and his right hand was over the side of a bar when a vodka bottle was thrown at his hand, injuring his right middle finger. And he describes that the vodka bottle exploded.
Are you aware of other explanations for that injury?
There have been multiple other explanations, but I think the one that was brought out was by Ms. Hurd, who believed that Mr. Depp was holding a landline and out of anger was punching it against the wall, and this resulted in his right middle finger injury.
Based on your review of the medical records and other documents in connection with Mr. Depp's finger injury, how would you describe the nature of the injury to Mr. Depp's finger?
Well, the nature of the injury was he had what we describe as a comminuted fracture of the distal phalanx, meaning there was a fracture of the tip of the finger, and comminuted meaning that there were multiple pieces. So this is some type of blunt force with a high mechanism of injury. He also sustained loss of the tissue along what's called the ulnar side of the finger towards the little finger. And this appeared, based upon my review of the pictures, to be some type of sharp laceration because it represented a clean edges of the wound.
Can you take a look at Plaintiff's Exhibit 60 and pull up to go to page 3? And Dr. Gillard, are you familiar with this document?
Yes.
And what is it?
So these are two radiographs, x-rays of Mr. Depp's finger, his middle finger.
Okay. Sorry, just to stop you, but Your Honor, may we publish this to the jury as a demonstrative?
Any objection? All right, we'll identify it as 60, page 3, and publish to the jury.
And Dr. Gilbert, sorry to cut you
Oh,
off
that's
there. Can you just tell the jury what we're looking at here in this
we're looking
X-ray?
at two x-rays of Mr. Depp's right middle finger after the injury. And towards the tip of the finger, there's a fracture, again, what I described as a comminuted fracture, meaning there are multiple pieces at the tip. There's also a transverse component to the fracture closer to the joint.
In your view, what types of mechanisms can cause this sort of injury?
So this is a mechanism of injury that has high velocity or force, generally a crush type injury. A simple fall would not result in a comminuted fracture such as is seen in these x-rays.
And we're using the term comminuted fracture. Can we just define that quickly for us?
So again, comminuted, and it's not particular to a finger, is a medical term for a fracture that has multiple fragments.
In your opinion, could this injury have been sustained in the manner Mr. Depp described?
I do believe so.
And how might that work? How might a thrown vodka bottle produce an injury like this?
So a vodka bottle, which is a hard object, would have crushed the tip of the finger, resulting in the comminuted fracture. And in addition, as the vodka bottle broke, the glass would have lacerated the finger, resulting in the soft tissue loss that was also seen with this injury.
What's your assessment of the description of the cause of the injury offered by Ms. Hurd?
I think that's highly unlikely.
And why is that?
Because one, in general, when an injury is caused by punching against a wall or a hard object, it is extremely rare to see an injury to the tips of the fingers, which is seen with Mr. Depp's injury. Generally, you're holding something with a fist, and that in general leads to injuries most commonly of the knuckles here, or fractures of the metacarpals. We call these boxer fractures. Second most common after those would be injuries to these, but as you can see, if you're holding something and hitting against something, it is very unlikely that the tips of the fingers will be injured. In addition, just taking into account the radiographs and the pictures of the injury, I would not believe that a blunt force, solely a blunt force against a wall would result in the soft tissue loss.
What other injuries, if any, would you expect to see on Mr. Depp's hand if the injury had occurred as Ms. Hurd described?
So if you would have, if that were the cause of the injury, you would certainly, that would be a dorsally directed. So this is the dorsal in the back of the hand as opposed to the palmar side. So if you're punching against something, you would certainly expect an injury to the nail bed. And those are always seen in those type of injuries. If there is an injury to the tip of the finger, which again, I said is rare. So you would see either a loss of the nail or blood underneath the nail called a subungual hematoma.
In your review of the medical records, did you see any sign of anything like that?
None whatsoever.
In your view, is the injury, can you explain to us exactly why you think the injury is consistent with Mr. Depp's description?
Well, again, his hand, he describes his hand being held over a marble bar, which is a firm, something firm, unyielding, and the bottle hit against the finger. So basically the finger was crushed, resulting in, again, what I described as a comminuted fracture. And as Mr. Depp described, the bottle exploded. So it's certainly reasonable that the glass that exploded as well led to the soft tissue loss along the ulnar aspect of his finger.
Now, did you observe the testimony of Dr. Richard Moore?
Yes, I did.
And he testified about Mr. Depp's finger injury as well.
Correct.
Right. Did you agree with Dr. Moore's testimony?
Certain parts of his testimony I did, yes,
Okay.
but not all of it.
Focusing on the parts that well, first of all, why don't you tell us what you agree on?
Well, I agreed in terms of his interpretation of the x-rays, saying that he had a comminuted fracture and this was some type of high force injury.
Okay. What did you disagree with?
Well, I disagreed with several things that he said. He first said that he does not believe that the mechanism of injury could be, as described by Mr. Depp, holding the hand on the side of a marble bar, because he said it was all a palmar injury, and there was a palmar component to the injury. I'm talking about the soft tissue loss, but there was also a dorsal, meaning the back of the finger. So the soft tissue loss was actually, if you looked at the pictures which were shown when Dr. Moore testified, the injury goes like this. So it's an angled or an oblique type injury. And there's no way that anybody could determine whether or not it was a palmar directive force, meaning from the palm side, or a dorsally directive force. But certainly either are plausible.
Anything else come to mind that you disagreed with?
Well, he also described that this was well, he thought that this was a pinching or what he described as an avulsion type injury. And that's referring to the soft tissue loss. That's certainly possible, but if you look at the pictures that were shown when he testified, the laceration looked fairly clean. There were clean edges, it was not jagged. And generally when you have an avulsion or a pinch type injury, you see a very irregular border to the skin. It's pinched off, you can imagine, as opposed to something that's cleaner that would be lacerated by, let's just say, a piece of glass or a knife or whatever. And that's more consistent with the pictures of Mr. Depp's injury.
And we're using the term soft tissue loss. And just to make sure we're on the same page, can you just tell very quickly what you're referring to there?
Right, so there were two components to this injury. One, the fracture of the bone, and two, he had loss of the soft tissues so that the bone was exposed. So that amputated part that was found at the bar. Now, you were saying that Dr. Moore testified that this was
an avulsion, and meaning a pinching injury, right?
Correct.
Why do you believe it's more likely that it was a laceration?
Well, again, in general, a pinch type injury results in one, much more damage to the remaining tissue, but the remaining tissue is usually very irregular. The borders are jagged, and that's not what was depicted in the pictures.
Dr. Moore also testified that he thought a vodka bottle might not have sufficient force to cause the injury here. Is that your understanding of his testimony?
Correct.
What's your response to that?
I certainly believe that a vodka bottle that was thrown from a distance against a hand that was resting on a marble bar is more than sufficient force to result in this fracture and soft tissue loss.
Now, in looking at the medical records and the pictures of Mr. Depp's hand, what was the condition of his nail?
There was no injury to the nail.
And other than what you've already told us, how does that factor into your analysis, if at all? The fact that there was no injury to the nail?
Well, it makes it highly unlikely that the mechanism of injury described by Ms. Heard resulted in this injury, because you really would always see an injury to the nail and or nail bed.
Do you have any opinion regarding the direction of the injury?
Well, it's certainly based upon the soft tissue loss. It's an angled injury, or what we call medically an oblique injury, because the soft tissue loss is at an angle. He lost some of the tissue on the back of the finger as well as the palm side, primarily along the palm side. But other than that, you can't make any assumptions. Unless you saw a videotape of this injury, nobody could tell you definitively what the direction of the injury was.
Dr. Moore also commented on the absence of fragments of broken glass in Mr. Depp's injury. Do you remember that?
Yes, I do.
And how does the absence of glass fragments factor into your analysis?
It really doesn't. I've seen hundreds, if not probably at least 500 or more glass injuries, and I would say probably the majority you don't see glass in these injuries. It is much more common to see glass embedded in the wounds when you're talking about very fine glass. So if say a wine glass would explode or something of that nature, where you get little tiny shards. But in general, when you have thick glass, such as you see in a bottle or a pane of glass, you generally don't see, because they break into bigger pieces, and you generally don't see the glass. But you certainly can, but it's not surprising that you don't.
Can you definitively state how this injury occurred?
No, nobody can definitively state.
I have no further questions, Your Honor.
All right, cross-examination.
Thank you, Your Honor. Good morning, Dr. Gilbert.
Good morning.
Now, you're being paid $1,000 an hour for your work on this case, correct?
Correct.
And you agree, just to sum up how Mr. Moniz finished, you agree that the finger injury could have been caused by any number of things, right?
Yes.
And you're not offering an expert opinion on what you believe caused the finger injury, correct?
Correct.
And you're aware, you said a few times Miss Heard's account or Miss Heard's explanation, right? You remember saying that?
Yes.
You're actually aware that Amber has said she doesn't know how he lost his finger. You're aware of that, right?
Yes.
So when you were just talking about Miss Heard's account or Miss Heard's explanation, you're aware she's never actually given an explanation for how she thinks he lost his finger, correct?
No.
You're aware that Miss Heard testified, and this was from your deposition, you're aware that she testified she doesn't know how he got his fingertip chopped off. You're aware of that, right?
Asked and answered, Your Honor.
Overruled.
No, I'm not. I reviewed the records, and in one of the testimonies depositions that I reviewed, it was described that that potentially it was lost when he was punching against the wall with a phone.
And on that, the last point there, I think we agree. Ms. Hertz testified in this trial and previously that she saw him smash a phone to smithereens, a wall phone. You'd agree with that, correct?
Correct.
But she doesn't know if that was what caused him to lose his finger. You agree with that, correct?
I agree. I cannot speak for her, but yes.
Okay. May I approach, Your Honor?
Yes, sir. Thank you.
Dr. Gilbert, you gave a deposition in this case on March 17th, correct?
Correct.
You were under oath in that deposition. You swore to tell the truth, correct?
Correct.
Okay, if you could turn to page 61, please. You see there are four pages per page of paper. It's on page 16 of the document.
Okay.
Okay, in line 9, you're asked a question, and then Amber's response to that question, that's the line 9. Can you read that, please? Answer, I do not know. I did not see his finger go off. Question, and Dr. Gilbert, are you aware that Amber did not see Mr. Depp's finger go off? Answer, I mean, I'm aware that, well, I am from reading this. I'm aware of the mechanism that she claimed would cause the finger injury. Question, but have you read anything so far that indicates she doesn't know how the finger injury happened? Answer, so far from what I'm reading here, yes. Did I read that right?
Yes.
And you've heard no testimony in this trial from Ms. Hurd that the finger injury was definitively caused by the phone, so that she doesn't know, correct?
Correct.
And you'd agree that the fingernail was uninjured. You said that, right?
Correct.
And the nail bed was uninjured.
Correct.
Correct. But the area under the fingernail, in the pulp of the finger, that's where the injury took place, right?
It was not isolated to the pulp, no.
But it didn't injure the fingernail. That's my question.
Correct.
Okay.
Yes.
And under Mr. Depp's alleged theory, Amber threw a vodka bottle at him from 10 feet away or so, right?
Correct.
And you testified you have no way to determine the angle that the bottle was coming from,
Correct.
right? But she threw it on a downward trajectory, correct? She didn't, there's no allegation, you've never read anything that she somehow underhanded it so it came up to his finger, right?
Correct.
And there's no way to tell, as you testified, what exact direction it came from, right?
Correct.
And the glass exploded, but you've already testified there was no glass in the wound, right?
Correct.
You haven't read any record of that in any medical records, correct?
Correct.
You also haven't read anything about there being cuts on the rest of his hand, right?
Correct.
And there was no glass found anywhere on the rest of his hand, correct?
Correct.
No bruising or injury on any other part of his hand other than the tip of his middle finger.
Correct.
And somehow, under Mr. Depp's theory, that bottle hit the bar and his fingers, but didn't damage the fingernail while it amputated the area under the nail, correct?
Correct.
And your explanation of that is that you believe that his hand must have moved at some point during the force of the injury. Isn't that correct?
No, I said it could have, but I did not say that it did.
No, you believe that it did, don't you?
I said that it likely did, but I was not there, and I don't have videotape of the injury, so I can't determine that definitively.
Let's turn to page 25 of your deposition, please, on page 7.
Sorry, page.
Page 25 and 26. So it's page 7 of the document.
Okay.
Sorry if I was unclear on that.
No problem. I'm there.
Okay. Line 18, question. And to be clear, by quote, sitting in that position, you mean hand down, palmar side down. Answer, that's what he claimed. I mean, according to the history, yes. Question, and would it matter if Mr. Depp's hand was palmar side down? Answer, not really, because it really, and I discussed this, it really just depends upon the angle at which the injury occurred. And as well, you can't determine if his hand had moved at some point during the force of the injury, which I believe it probably did, which I didn't get into in my note here. But Question, and why do you believe that? Have you read anything in any of the materials to suggest that? Answer, no. Just that if it completely hit on the back of the finger, then he would have had a nail bed injury, which he did not. Did I read that right?
Correct.
That was testimony you gave under oath a month or two ago, right?
Correct.
So even though you have never read anything that suggests Mr. Depp's hand moved, his hand moving is the only way that you can fit your testimony into what Mr. Depp wants you to testify to about how the injury occurred, isn't it?
No, that's incorrect.
Okay, that's what you testified to, that if his hand hadn't moved, that there would be a nail bed injury, correct?
That is incorrect. That's not what I testified.
In
That's not
fact,
what.
Dr. Gilbert, there's another explanation for how Mr. Depp somehow suffered an injury that didn't injure his nail one bit, but injured underneath the nail. And that explanation is that it didn't happen how Mr. Depp says it did, correct?
I cannot make that assumption, nor can you.
No further questions.
All
Thank you.
right, redirect.
Dr. Gilbert, just very briefly, the absence of other cuts on Mr. Depp's hand, how do you factor that into your analysis?
You certainly can see an isolated finger injury with any type of injury, and I would say any other host of mechanism of injuries, you'd more likely see other. So again, if you're, I'm just using this as an example. If you're punching against a wall, you would more likely see multiple injuries to multiple fingers. It really just depends upon how the bottle or how the mechanism of the injury impacted the hand at that point in time.
Ms. Heard's counsel made a point of emphasizing that there were no bruises or other injuries on the hand, right?
Correct.
And how does that fact affect your analysis, if at all?
Well, it doesn't discount anything, but it certainly makes other potential causes of injury more unlikely, meaning punching against a wall or getting the hand slammed in a door or something like that.
And your discussion of Ms. Heard's explanation of the alternative cause of the injury, was that based on anything other than Ms. Heard's statements?
No.
No further questions, Your Honor.
All right, thank you. Doctor, you can have a seat in the courtroom or you're free to go. Thank you. You can just leave it there. That's fine. Thank you, sir.
Thank you.
All right. Your next witness.
Plaintiff rests, Your Honor.
All right. Plaintiff rests the rebuttal case. All right. Defendant counter plaintiff rebuttal case. Sure.
You ever wear a shirt that the sleeves are too short? Well, that's me today. So I have to be very conscious of not lifting up my arms. I'm gonna try to find me some pop culture shirts. Any suggestions would be greatly appreciated on Twitter, Facebook, or YouTube. Thank y'all. No makeup today, y'all. I just don't have the energy. I need to give my face a rest. So I'm looking kind of yellow today because that's what happens when I don't wear makeup. But grab my little camo hat. I have about 50 hats and I can never figure out which one I want to wear. I like camo though a lot. So that's what we're going with today. An old high school t-shirt for my ex's son's football team and the camo. So yellow and green, yellow and army green. I want to get me some, I think military t-shirts. I think, I got to look. I like Black Rifle. So I'm going to check and see if I can grab some of those off Amazon.
All right, rebuttal evidence.
Yes, Your Honor.
Mr. Murphy?
We call Mr. Julian Acker.
All right. Mr. Ackert? He has to be sworn.
Do you solemnly swear or affirm to testify truthfully in this case or penalty of law?
Good morning.
Morning,
Can you please state your name?
Julian Ackert.
And can you please describe your educational background following high school?
I have a Bachelor of Science in Computer Science from the University of Virginia.
What is your profession?
I am a computer forensics investigator.
Where are you employed?
I work for a company called iDiscovery Solutions, or IDS.
And what is your title?
I'm a managing director at that company.
What services does IDS perform?
IDS provides consulting, expert testimony, forensic analysis, data analysis, electronic data, review production services, all to the business and legal community.
Every one of Amber's
Any of those services performed by IDS?
witnesses it seems like they're coached to look directly at the jury.
How many years of experience do you
strange
have in computer
to me.
forensics investigation?
I've worked in the industry for 20 years.
Can you please describe that experience to the jury?
I have experience creating and implementing data preservation and collection strategies, doing data collections in a forensically sound manner, extracting data from collections, as well as analysis and metadata analysis of the evidence that I extract.
You mentioned collecting data from forensic collections. What material are you forensically imaging?
This would be any type of material that stores digital evidence, an iPhone, an iPad, a tablet, laptop, cloud account, your Gmail account, anything that has digital evidence.
Have you published in your areas of expertise?
Yes, I've published on data preservation and collection and analysis strategies.
Have you ever given any trainings or presentations to other individuals in the e-discovery area?
Yes, I have. I do trainings and presentations to lawyers through continuous learning education.
What, if any, professional certifications do you have?
I have a GAC GCFE, that's the GAC Certified Forensic Examiner certification.
Are they really going to?
What were the requirements of obtaining that certification?
To obtain that certification, you need a minimum number of hours in the field, as well as you need to pass a test with a certain degree of, a certain percentage of passing.
Are they really going to try to come on here and tell us that her pictures were authentic?
I'm a member of a conference called the Sedona Conference. It's a conference that is a group of legal professionals, judges, and technologists, and we discuss the intersection of law and technology issues in the legal community.
Have you previously served as an expert witness?
Yes, I have.
And when did you first serve as an expert witness?
I believe that would have been around 2009 was the first time I served.
Have you previously been qualified as an expert witness in the field of computer forensics?
Yes, I have. I've been qualified probably a half dozen to a dozen times in both federal and state court, including this court right here.
And has a court ever declined to qualify you as an expert witness?
No, they have not.
Your Honor, I offer Julian Acker is an expert in the field of computer forensics.
No objection, Your
All
Honor.
right, so moved. Could you just spell your last name for me, Mr. Acker?
Ackert, A-C-K-E-R-T.
Thank you so much, sir.
Mr. Acker, what is forensic imaging?
Forensic imaging is the process of capturing the data on a digital device in a forensically sound manner.
And how is a forensic copy created?
Using specialized software that's available to forensic investigators, we're able to collect the data from devices, and that software may vary depending on the device, like a phone or a laptop.
What type of information does a forensic image collect?
It's meant to really collect everything on the device. So for example, on a laptop, it's going to collect your documents, your emails, your photographs, your documents like Excel spreadsheets, PDF files, any applications that you ran, the history of what you've opened or looked at on the laptop, as well as all of the metadata for these different types of electronically stored information files.
And does any other information accompany that information that's collected?
Typically with a forensic image, you're also going to get log files. Log files are files that help you validate the forensic image and verify that it was a forensically sound data collection.
And how do log files enable you to do that?
Log files list information within the files. Sometimes they're even embedded within the images themselves, but they provide verification information that allows you to authenticate the image and the data on the image.
What is the purpose of creating a forensic image of devices or data?
In order to extract and analyze data forensically for the courts, you need to create a forensic image of the data first and gather the data from the forensic image.
And what, if any, specific types of data are collected in that image and extraction?
It's going to be any type of data that comes from the image, whether you're extracting photographs or documents or spreadsheets or anything of that nature.
Do you recall Mr. Neumeister mentioning the term hashing yesterday?
I do.
What is that?
Hashing is essentially a digital fingerprint of a file. It's an evaluation of the binary ones and zeros, or how the file is stored on a hard drive, and it examines the ones and zeros in a manner that gives every file a digital fingerprint, essentially, and identifies the uniqueness of the file.
And what, if any, applicability does hashing have to the visual appearance of data?
Hashing has nothing to do with the visual appearance. For example, if I had a Word document that I printed and then saved, therefore I haven't visually changed the Word document, the metadata of that Word document indicating that I printed it would be different, and therefore that Word document would not hash to the version that I used before printing.
Can you give any examples of digital photographs that visually appear the same, not hashing?
I believe Mr. Neumeister included 3 of those in his demonstratives yesterday, 3 side-by-side photographs that looked visually the same but did not hash. It made sense that they wouldn't hash. Each of them had different file sizes. And a file size can change for a photograph depending on what you do with the photograph. So for example, maybe you want to take that photograph and email it to somebody, and on your phone, you choose to use a small, medium, or large, or different size of the photograph when you email. When you send that email with that photograph, you've changed the hash value because you've changed the ones and zeros because you've changed the size of the photograph.
And what, if anything, do you recall from Mr. Neumeister's testimony regarding photos 3?
Mr. Neumeister was concerned about a particular metadata field, EXIF metadata, which there's 2 types of metadata for files. There's the embedded metadata, which is what we're discussing here, the EXIF metadata, and external metadata. And Mr. Neumeister was concerned with embedded metadata within the file that indicated that the software version that the file last ran through was Photos.
What is Photos 3.0?
Photos is actually the software application that's built into the Apple Macintosh operating system for laptops. This is the application that launches by default when you're on an Apple computer and use Photos.
What are the capabilities of Photos 3.0?
There's multiple capabilities for it. You can, for example, create an album with it and put multiple photos within an album. You can organize or sort your photos by date and time taken or place. You can also use that to edit photos.
You mentioned metadata earlier. What is that?
Metadata is information about a file. For example, with a document. It could be when was the document created or last saved, or who saved it, who was the author of the document. For photographs, metadata includes information that you've seen on demonstratives before, including when was the image taken, what kind of phone took the image, what software was originally used for that image. Any type of information inside the photograph, the EXIF data that you've heard, is metadata.
Did you form any opinions in response to Mr. Neumeister's testimony regarding Photos 3.0 appearing in a software EXIF metadata field?
Yes, I did.
And what are those?
My opinion is that for each of the photos that he identified, for all but one in his demonstrative, I actually found the equivalent original photo that did not have photos in the EXIF metadata. In other words, those are the photos that he was indicated he would have expected to see the iOS or the phone software version on those photos.
How do you know it is an original version of the photograph?
This is a little bit dependent on the Apple ecosystem. Amber uses Apple devices, and those devices, by definition of how Apple works, synchronize your information from device to device. So for example, if you take a photo on your phone, you see that same photo on your tablet or your iPad or your iCloud account, or even your MacBook. And that's all because of user experience. Apple wants you to be able to see and visually have the same experience on all your devices. So the photo that was originally taken traverses or gets synchronized to other devices by design of Apple. And that synchronization process does not affect the metadata that we're talking about here, which is the embedded metadata.
When you say that a version of iOS software was listed in the software EXIF metadata field, what does that mean?
That means that the photo was not saved using the Photos application.
And what, if any, data sets did you use to come to that conclusion?
I used all of the data sets that I collected or were collected for Amber, including mobile devices, tablets, laptops, etc.
Michelle, can you please pull up Defendant's Exhibit 1671? Do you recognize this chart, Mr. Eckert?
I do.
What is it? Without yet saying the contents, just generally, what is it?
This is a chart I created as part of my report.
Your Honor, permission to publish Defendant 671 is a demonstrative.
Any objection?
No objection, Your Honor.
All right. It'll be published as a demonstrative.
Mr. Acker, can you please describe in more detail what the information in this chart is? And Michelle, if you could just stay at the top for a quick second. A little further up. Great.
Thank you. This chart represents for each of the items in Neumeister's report, which his demonstrative was based on, the page number of the item on his report and the items that I found on Ms. Hurd's devices that did not indicate the software metadata field showing photos. Rather, they indicated that they were the original software metadata field of iOS.
And do you see the second column titled Neumeister Report Date Captured?
Yes, I do.
What does the information in that column mean?
This is the date time metadata of the particular photo on Neumeister's report. So for example, the first row, 23, the date time captured, or the date captured, is December 16th, 2015. The second row, 24, you see that the date time is May 21st, 2016. Third row, May 21st, 2016. Fourth row, May 21st, 2016.
Can you just scroll to the next page, please, Michelle? Please continue for the items on this page.
The top row of this page, the one that came from Neumeister's report, page 30, shows December 16th, 2016. And then finally, 32 shows March 23rd, 2013.
Do you see, can you scroll back to the top, please, Michelle? Do you see the, all the way to the top, I'm sorry, the right-hand column of this chart?
Yes, I do.
And where it says device ID and file name?
Yes.
Can you please explain what the information in that column means for each of the items identified from Mr. Neumeister's demonstrative?
So these are the evidence IDs, and evidence ID is the ID value I give to a particular piece of data that I collect, for example, a phone or a laptop, and the matching file name found on that evidence ID that indicated the original version of this same photograph that Neumeister identified that did not show photos in the software metadata and rather showed the iOS version in the metadata.
And what do the little A's followed by numbers back up? What does that mean?
Those are evidence IDs. Anything with an A number is the evidence ID of an actual device collected. Anything that starts with a backup and followed by another number is an iTunes backup.
So what, if any, what items in this right-hand column, based on the coding you have here, are iTunes backups?
Only the ones that start with the word backup. Even the ones that start with an A number are actually an iTunes or an iOS backup in iCloud. So your phone can actually be backed up to iCloud. And those are coming from an iOS backup in iCloud. Everything else is coming from an actual physical device.
Can you just take this down for a second,
Michelle, and pull up
1675, please?
Defendant
1675.
Morning, E. I'm a little confused because your name is Mike on
And
Twitter, so
do you recognize this truck, Mr. Acker?
I don't know what to call you now.
Without
Anyway,
yet
good
giving
morning.
into
Thank you for being
confidence,
here.
Can you please describe generally what it is?
This to me is just a bunch
This
of
is a chart
gibberish.
that I prepared as a summary of my findings.
Permission to publish.
They're all
Defendant
just there to-
1675 is a demonstrative, Your Honor.
Any objection?
No objection.
If you
All right,
see, if you
1675.
saw if you go back to
Can you
Legal
please describe in
Bites
more
from
detail what
yesterday
the
and you
three
kind of just
columns
fast
you
forward
can
to
see
the
this chart
end,
represent?
you'll see
Sure,
that
this starts to give some detail about
lawyer
the particular
Natalie
evidence ID.
talks
So
about
for example,
once a jury's made up its mind, it doesn't matter. All of this is gibberish. After they visually showed a picture of the difference, the jury makes up their mind. So
A11, 12, and
all
13
this here
slightly down
is
are
gibberish.
3 different laptops that were collected.
Depp's team showed an actual example
And do you see
of the pictures morphed
IDS
over each
evidence
other,
number column?
and that makes an
Yes, I do.
impression. So
Do you see the
this
source
guy
type
can go
column?
on and on and on
Yes,
all
I
he
do.
wants,
And
but
the
they
source
they had a
details column?
visual yesterday,
Yes, I do.
Can you
so that's
please
all they
describe
needed.
what those columns mean?
Generally, the IDS evidence number is the evidence number that we assign to a particular piece of evidence, and the type and details come from a description of that type of evidence based upon the collection set.
And Michelle, can you please do a side-by-side of 1675 and 1671? Thank you. So, Mr. Acker, can you please describe the relationship between these two demonstrative exhibits?
Totally
Certainly.
understand. Totally
If you look
understand.
at 1671, the one on the left, you can see in the fourth column the different evidence IDs where I identified the original versions of those same pictures that Mr. Neumeister had specifically identified and the sources of where they were identified. So if you look at the first one, for
They've
example,
already
the,
been shady though, with all their evidence.
the
They've been
picture
shady.
Neumeister referenced on page 24, or I guess that's the second one.
You can
There
even
are
see like on the
equivalent versions
Depp
or original
Dive
versions of those
website,
do
you can
not
see
show
all
the
that that
software
Amber's team
exif metadata
submitted
field
versus
of
what
photos.
Depp's
Rather,
team
it shows the
submitted.
original iOS
This guy's
version
full of shit.
on A001, which was Amber Heard's iPhone X, A002, which is Amber Heard's iPad Pro. Scrolling on down through there, you see it on A0011, which is Amber Heard's laptop. Same with A0012 and 13. You can see this again with the next row that's visible at the very top.
No problem.
Neumeister identified a photograph on page 30 taken on December 16th, 2015. And he was concerned about the EXIF metadata of that, showing the software version of photos. The original versions of those were found again on A001, that's her iPhone X, A002, her iPad. And it's not surprising to me that I found all these on all the devices because that's how the Apple ecosystem works. It replicates your pictures or synchronizes.
That wasn't the argument. The argument is, did she use a third-party editing
Mr. Acker,
program
you can take this
to
down.
enhance
Do you recall
what she
Mr.
calls
Neumeister's
bruises?
testimony
This is not about the
regarding what he
original
claims
photo.
of EXIF
You need an
metadata
original
modification?
photo anyway.
Yes, I
So
do.
we're not
This
idiots,
is a
Guy. We're not
completely
idiots, whether you're a
hypothetical
forensic or
scenario.
not.
Mr.
That's not
Neumeister
what we're
never specified
questioning.
Any pictures with specificity that had EXIF metadata modification, and it's a hypothetical in my opinion.
Mr. Acker, did you form any overall conclusions in this case?
Yes, I did.
And what were those?
The images that were created in this case were included log files that allowed me to validate and verify the evidence collected. I validated and verified the log files of the evidence for which I found Mr. Neumeister's original photos that he had concerns about, specifically the ones that had iOS in the software metadata field. I validated that those came from devices that had log files that were validated by me. In other words, they came from original evidence files, and in most instances, they came from more than one file.
Mr. Acker, the opinions you have testified to today and made to a reasonable degree of forensic certainty.
Yes, they are.
No further questions, Your Honor.
All right, cross-examination, sir.
Thank you, Your Honor. Good morning, sir.
Good morning.
You've worked with opposing counsel's law firm approximately 20 times before,
Give or take, yes.
Mm-hmm.
for more than a dozen years.
Mm-hmm.
Those 20 probably would have spread
Biased.
out over more than a dozen years.
Biased.
As you sit here today, you cannot testify that all of the photographs produced by Ms. Heard are authentic originals, correct?
I can testify to the ones that Mr. Neumeister identified.
Exactly. That is the point.
Thousands of photographs
Exactly.
provided
That is the
you
point.
testify,
Ding, ding, ding,
right?
ding, 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 ding.
I have no opinions on any photographs that the opposing expert has no opinions on.
My question to you, though, is as you sit here today, can you testify that all the photographs produced by Ms.
There you
Heard
go. There it is.
are
Boom.
authentic originals?
Boom.
As I sit here today, I cannot opine to photographs that have not been presented to me that are not authentic originals.
You'll agree with me that in some instances, Ms. Heard produced multiple versions of the same photograph.
There you go.
Right?
Boom. Whoop. There it is.
Yes,
There it
We
is.
talked about it, right?
yes,
And you'll agree with me that the XF data of some of the photos produced
Whoop,
by
there it
Ms.
is.
Heard reflect the use of a photo editing application.
no.
No?
I'll agree that they show the use of the photos application, which is a sorting and editing application.
Okay, so what you were quibbling with is that it will both sort and edit.
That is correct.
Okay. Are you prepared to swear under oath that each and every photograph provided by Ms. Heard and entered into evidence in this court is an authentic original?
Based on the metadata that I have reviewed of the specific photographs I have reviewed, I can confirm that those are authentic original photographs. For the ones that Mr. Neumeister identified, I identified photos that were authentic originals.
No, I'm asking you a broader question than that. There were multiple photographs that Ms. Heard provided that were entered into evidence in this court. Are you testifying that those are each authentic originals?
I have no testimony or opinion on those because nobody's provided me opinion that they're not.
Okay. Mr. Gibson, will you pull up Defendant's Exhibit 712 and Defendant 713?
Thank you. Ha.
These have already been admitted, and I asked that.
But remember, he'll recross, so they'll find some way to dance around it.
Can you see this, sir?
They're so full of
Yes, I
shit.
can.
You'll agree with me that those are different pictures?
Visually, they look different to me, yes.
All right. We can take that down.
Oh, I love it. I love it. I love it. Can we confirm that these are originals? Oh my goodness. Oh man, I love Twitter.
Can you pull up Plaintiff's Exhibit 1308?
I can just climb in it and put a blanket over me and be totally okay with being on Twitter
This is not
24 hours a day.
Your Honor, and I propose to use it as a demonstrative.
Any objection?
Not as a demonstrative, Your Honor.
All right.
I'm waiting for baby Hobbit born to get all fussy.
Any objection to entering it into evidence?
I would object it's cumulative, Your Honor. Actually, no, no objection, Your Honor.
No objection. All right, it's in evidence then.
1308 is in evidence. Mr. Gibson, can you blow up the time, date,
Visually, they look
file
different to
name?
me. That was the most obvious dodge ever. Amber Heard's expert admits that Heard's photos went through a sort and edit feature. I picked up. Did you pick that up? He
Sir,
said
you just
it does two
agreed with me
things. It sorts
those
and
two
edits.
photos are different photos, correct?
I agreed that they were visually different, yes.
So they are two visually different photos that were created at the exact same hour, the exact same minute, the exact same second as each other, correct?
And that's what the daytime metadata shows, yes.
And the metadata shows something else too. They have the exact same file name, don't they, sir?
Yes, but that's not embedded metadata.
Okay. But there's always a but.
How would you have?
So we're supposed to believe this one is this
real?
answer is an exception, right?
I think you would need to look at the software metadata field, which I haven't looked at. I don't recall if I looked at for this.
Oh, now you don't
I
recall.
think that's
Okay.
what even
Okay.
Mr. Neumeister said, that you need to look at the software metadata field.
But we have two photographs entered into evidence in this court that have the same identifying information, but in your view, look visually different, correct?
I don't agree that they have the same identifying information. I don't see a software metadata field here.
The identifying information includes the hour, minute, and second they were taken. This picture were taken.
I see that.
No further questions.
All right, and just for the record, since we already have 712 and 713 evidence as redacted, now this will be 712 and 713A. So 712A and 71213A are now in evidence, just keep the record clean, okay? All right,
Your Honor.
redirect.
Mr. Acker, you just mentioned embedded metadata. What is that?
Embedded metadata is metadata inside a file. I talked earlier about the date printing.
Nobody gives a shit, dude.
That's embedded into the file.
The jury
That's
doesn't
refers
speak
to
that
the
language.
file
The jury
reference.
speaks layman's terms,
And
very
based on all
simple
the photo
ways of
metadata you have
understanding
reviewed,
these
Do
photos.
you have any reason to question the forensic authenticity?
We don't give a
of
shit
any
what you-
photos
what
Mr.
you-
Neumeister
They don't
testified
care
to,
about that.
which you were responding
They're
to?
going to visually take it and they're going to say that
Can you
photo's
repeat that
different. She
question?
did something
Based
to it.
on
It
all
doesn't
of
matter what the
photo
forensics.
metadata you
It's
have
it's
reviewed
apparent.
based
People
on
are
the photos
visual.
Mr. Neumeister
They are
testified to,
visual.
Do you have any reason to question the forensic authenticity of those photos?
Sit down,
I do
baby
not.
hobbit born. Sit down.
Following your cross-examination, Mr. Acker, have any of your opinions in this matter changed?
They have not.
And is it still your
Great.
testimony that the opinions
Now
you
sit the fuck
testified
down.
to today are made with a reasonable degree of forensic certainty?
Great. Sit the
Yes.
fuck down.
No further questions. Your
All right,
Honor.
Thank you.
Sir,
Sit your
can
ass
have a
down
seat in
now.
the courtroom, or you're free to go.
Get the
All right.
fuck out of my
Did you want to approach this for a
stand.
moment?
Nobody gives a shit. I mean, if you watch Legal Bites live stream just at the tail end of yesterday, they lawyer Natalie, I don't know who she is, but I have to start following her because she was talking about trials and juries, no matter what instructions are given, they actually make their own mind up. You know what I mean? Like they create whatever system within that deliberation room that works for them, and then they go by that. Even though they're given instructions, they still have the freedom behind closed doors as a group to figure out what's going to work in terms of how they decide. So really, that's why you can read their faces and their expressions all you want, like, in terms of the attorneys in the in the audience, kind of trying to read how they're responding. That's why the jury favors Camille. So they're looking at Camille to see because she's a good attorney, and I think that she's presented very well, and I think they trust her instinct. So by her response, they're just kind of taking into consideration her reaction. So I think that is, the jury will do what they want to do in the deliberation room. You know what I mean? Like they'll stay within the guidelines of whatever they're instructed to do, but at the same time, when they get together as a group and they decide what they want to do, they're going to have their disagreements, agreeing to disagree, trying to figure out what to do in terms of verdict. But at the same time, their system, they're going to be passing, it's like if you've ever seen a movie and you see the jury at a table and they're all trying to decide and they're presented with the evidence and they're going to listen to those audios, you guys, and that's it. They're going to be like, it's clear that Amber was the abuser. It's clear. But at the end of the day, it is defamation. Has nothing to do with
Your
DV
next
or
witness.
SA. It's
Your Honor, we would like to call
defamation.
Dr. Don Hughes to the stand.
Oh,
Dr.
God.
Hughes.
Great. Here we go. Tell me that the other psychologist is in the audience to intimidate her. Hey, Ian. Ian is in the, here she is
Thank
with
you,
her
Doctor. Just
smug
remember you're still
attitude.
under oath, okay, ma'am?
Yes, Your Honor. Thank you. And could you please just remind the jury who you are again?
Sure, I'm a clinical and forensic psychologist. I am board certified in forensic psychology. I am the president-elect of the trauma division of the American Psychological Association. And I evaluated Amber Heard over 6 visits for approximately 29 hours.
Why are you here today?
To offer a rebuttal testimony to Shannon Curry's testimony of yesterday.
Now, Dr. Curry said you used improper methods. Would you agree with that?
Of course she
No,
wouldn't.
I would not.
Why? Please explain.
As I testified to you all several weeks ago, I used a standard forensic procedure that is well established in our field. It is a multi-method, multi-hypothesis driven procedure where you're looking at a variety of different details and tests and external data to arrive.
Don't have an attitude. Don't come in here with your fucking attitude.
There are 3
Shannon Curry did not act that way. Don't do that. It won't go well with the jury. They don't like you anyway.
Dr. Curry seems confused. We have forensic assessment instruments. Those are instruments that are very neatly tied to a legal criteria. Those are most notably done in a criminal court for competency. If someone has competency to stand trial, we have very clear measures that can track that legal criteria. The next level are forensically relevant instruments. And those instruments are not linked to a specific legal criteria, but they do have information that's germane to that finding. And that can be an example of a risk assessment measure and a malingering measure. So the malingering measure that I utilized was the MFAS, and that was the only malingering measure in this case. The third
Nobody believes
category
you. Doesn't
are
matter.
clinical assessment instruments, and those are
You already made, there's no,
instruments that
you
are
don't get a
validated and
second chance
well-researched
to
and
make a
used
first
in the
impression.
clinical realm as we
Shannon Curry
understand people's
made such a
symptomatology and
deep
diagnostic,
impression
and
on the
functional
jury.
capacities.
They don't, this
Those
is
are
all,
things
they're not
like
gonna,
the MMPI,
they're not listening to her.
the PAI, the CAPS, the TSI, because they are clinically relevant and they still give us very valuable information to individuals who are involved in a court case. And the reason that we do that and we use these clinical measures is because the majority of the people that we see are in a clinical realm. They're not in a courtroom.
Wow,
So they're
that's crazy.
well-validated and well-researched methods. What we also do is use a very
But you have to remember, you know, like,
test within that category.
nobody
We
likes
use
her.
some
She's
tests,
arrogant,
some
so
face
they're
value
not
checklists.
gonna,
We use some tests that are those
they're listening. Let me
broadband
see what they're saying about her.
personality
Hold on.
inventories.
Let me
We
see what
use
Larry's
structured
saying about her.
clinical interviews. And then we look for the consistency
And what
across
James is
those
saying.
data points. And when we use
Twitter's blowing
different
up right now.
types
Let
of
me see.
tests, it gives us information about the individual, how they go about these tests in these different modalities.
Come on.
Now,
Oh God, here comes the
Dr. Curry
sexist
seems to
Dr.
suggest
Hughes.
that Amber Heard
Nobody cares.
tested
No,
the
not
most
this bitch
extreme
again.
category
Everybody's
in
listening.
all of these different tests. Is that accurate?
They're only copying
That
John.
is-
Everything that Johnny Depp's side does,
That is
they
not
do.
accurate. They were not on the checklist. I mean, people sometimes do. They go, all the time. This happens to me all the time, frequently. And that is not how she endorsed these tests. She endorsed them in a very moderate way, in a very nuanced way, describing her symptoms.
Get the fuck out of here
that
with
I
the,
determined
just
was,
please,
accurate and reliable.
get your arrogant
Dr. Curry
ass
also
out of
suggested
here.
that,
Nobody likes you
Amber Heard
anyway.
was tested very, very high, 98 percentile, I think, on malingering and feigning. Could you speak to that, please?
Sure. So, I mean, she said a lot of things. So let's go through those tests. The first was the PAI, and that's that other broadband.
Objection, non-responsive.
I think it's very responsive.
Ju-
Okay.
Thank you. What you think? Oh my God, Elaine, you are not the judge, Elaine.
Thank you. So that's
You are
the
not the judge,
broadband measure that
Elaine.
has validity scales built into it that gives us indications about how the individual goes about the test. I told you last time that there was no evidence.
There she is with the
of
attitude. Get the
malingering,
fuck out of here with that.
exaggeration, or feigning
They
on
don't
that
listen
test.
to you like that
What
when you
Dr.
treat them
Curry
like
was
they're
talking
stupid.
about was
Don't
this,
treat them like that.
tendency to put your best foot forward to minimize faults on this PAI. That scale was right at the cusp. And then there were two other measures that we look at that to say, is this enough for an elevation for me to consider that as a serious response distortion, of which Dr. Curry was saying, and it was not. What was relevant on this test was there were elevations on anxiety, on affective anxiety, meaning anxiety, tension, worry, on traumatic stress, on hyperactivity, and on affective instability.
Nobody
Those were the
likes you,
four scales
Hughes.
that were elevated on this test.
You have a sense of
Borderline scale was
arrogance
not
in your
elevated on
voice.
this
Don't
test.
do
This
that.
test
Objection, Your Honor.
Thank you.
May we approach?
Get her out of there. See her attitude? She does not like being cut off. She doesn't like, she comes in with a chip on her shoulder. That's not impressive to the jury at all. I know if I was sitting in the jury, I would not appreciate that at all. I'd be like, bitch, sit down and, reasonably tell me why you believe this. Don't sit here and say, come over here with like, Dr. Curry's wrong. She's prettier than me. She's, because she is. You know what I mean? She's more impressive than me. You know what I mean? I can't help that I look like a cat lady. You know what I'm saying? Like, bitch, get out of here with that. Get out of here with that. She's going to get booed off the stage. Don't nobody care about your attitude. Nobody cares to hear your attitude. Same attitude. She has not changed. She didn't learn the first time. She's coming off even more gruff than she was before. He's smiling, so he won something.
So Dr. Curry, let's move to the TSI 2. Dr. Curry testified about your findings on that. Did you agree with her testimony yesterday?
No,
Please
again,
describe why. Explain why.
what Dr. Curry went back to, which is this 98th percentile, which I told you in the manual. All you have to do is read the manual. It says specifically that we do not use the percentile ranks for this test. That indicates to me that, Dr. Curry does not know the psychometric properties of this test, and then she is therefore not qualified to interpret it.
Mm-hmm.
That score, the one that's elevated, which she's talking about, that percentile rank, has a raw score. Amber's raw score is a 10. The cutoff score is a 15. She's nowhere near that level of exaggerated symptoms where I can't further
Get out of here. Get out of here.
Secondly, there are 3 scales out of maybe there's about 20, a little more on the TSI.
We don't care about what you think. We don't care.
And memories of the trauma come into your mind when you don't want them. Defensive avoidance, sort of behavioral ways that we try to push out.
Cut her off in the middle of the question. Wouldn't that be
And then
fantastic if
relational avoidance,
if their time
having
ran out while
difficulty
she's
in
sitting there?
interpersonal relationships. Those are all trauma-based symptoms, and those were elevated on this test.
Thank you. Dr. Hughes, the MFAS, Dr. Curry addressed that as well and had criticisms for your interpretation.
Nobody cares.
Do you agree with that?
No.
Please explain.
So the MFAS, as I told you last time, is
As I told you.
the only measure of malingering that was done in this case.
She's
Dr.
not-
Curry did not independently
She's
administer
not-
measure malingering, and there are other
Oh my
ones that
God.
she could
I
have
can't with
done
this.
to
I can't.
augment her evaluation. And she kept saying something that MFAS is not for malingered PTSD. That's wrong on a couple levels. People who are going to malinger and feign don't only feign one diagnosis. They sometimes talk about all different symptoms.
Sometimes.
And they exaggerate and they make themselves seem much worse than they are. So when you're doing an evaluation, you're giving a malingering
We don't
measure
give a
to
shit. We
get a
don't
sense
like
of
you.
how this
Get
person is
out.
responding to this
You're not making
evaluation.
any kind of impression.
Now, what you do is you take those 3 tests that I talked to you about, the PAI.
Give me
the
somebody's,
TSI,
give me
and the
jury's
MFAS,
facial
all
expressions
with
right
valid
now.
validity scales, you have greater confidence in your results. And that is in the literature, and that's literature that Dr. Curry cited in her report.
Who wants 15 minutes of fame? Look
The
at that.
methodology that I used, that in a study that had the PAI, the MFAS, and the TSI in the
Did Dr.
title
That's why
was
you left.
testing
That's why you
feign
left your
coronavirus
notes blank,
PTSD.
bitch. Right?
Thank you. Now, Dr. Curry also talked about the danger assessment scale and suggested that you had inappropriately interpreted that. Do you agree?
That's also incorrect.
Please describe for the jury.
Which
Thank
I
you,
told
Christina.
last time,
Thank
the danger
you.
assessment
Thank you,
scale
Christina.
has
I am
It's a
retweeting your
statistically
stuff. Thank
validated
you so
risk
much for
factors
doing that.
serious or
She
lethal
pulled the audios.
domestic
Thank
violence.
you.
Those risk factors exist whether we go forward, we're sitting with someone in an acute setting.
You
and
certainly did
assessing
not
them
listen
right
to the
now,
audios,
or if we
girl.
look backward and we look retrospectively about
There you go.
what
Whoop, there it
factors may
is.
have been present in a case that indicated severity. That
Get out of
instrument
here.
is used in what we call, there's called domestic fatality review boards. Those are boards after somebody has been
When the
killed,
defense plasters a
that
phone
has
number
occurred
on
in
the
a
Molly
domestic
message,
situation. They
do
look
the
at these risk
entire
factors
words
to
of the
see
whole courtroom
what was
gasps
there and
in
what could be
disbelief.
done.
This is more than just
Dr.
a
Curry
fuck up on
also
their part. This
criticized
is a
your
major catastrophe
administering of the
from the
CAP
PR
5.
perspective.
Do you agree with her?
That was
criticisms?
yesterday.
I do not.
Will you please explain to the jury?
So the CAPS 5, as you all have heard multiple times, is a structured clinical interview in determining PTSD according to DSM-5 criteria. On this measure,
What's
Amber
this?
Heard scored in a moderate range. She did not over-exaggerate on this test.
What's
She
this?
could have said no, mild, moderate, severe, and extreme. All of hers were either 2s or 1s or 0s. None above that.
But
So
that was
she's
her
scoring
point,
in a
is that
moderate range, which still
she
has
was trying to
some
sell
severity.
herself as
We don't
never
want
having
someone
any
to be
problems, never
having
just
moderate
happy-go-lucky.
PTSD,
That's
but
not the
an
kind of demeanor
exaggerated
of someone that has
profile or an
PTSD,
exaggerated
bitch.
response level
God.
of someone
Those of
who's,
us that have PTSD
administering an
know.
instrument.
And the last of these Dr. Curry referred to was the PCL 5. Do you agree with her criticisms of your administration and interpretation of that?
No, so the PCL-5 is a checklist of symptoms of PTSD. It is, as she said, it is a face valid instrument. It seems it's very clear about how you can endorse this. But what the person has to do is say, how disturbed am I by these symptoms? And when you have face valid measures with these other measures that have the built-in sort of ability scales, you're sort of controlling for that response bias error. You're controlling for that individual to sort of over exaggerate. But then what you do with that test, because this is, we're not just administering them like robots, is you go and you do a clinical assessment. And that's what I did. I took what she endorsed on that test in January of 2021, and I did a clinical assessment of those symptoms.
Don't have that look on your face. It doesn't give you any.
That is something we do clinically, and I do
Stay
in my
stoic,
office
man.
all the time.
You're just burying
Yes, she gave
yourself.
me PTSD from that in January 2021.
Thank you.
Get her off the
Dr.
stand,
Curry
please.
said you misinterpreted her test results. Do you agree with that?
Yeah. I agree that I agree that I interpreted them, that she misinterpreted them.
Okay. And please explain.
Yes, so I said that before, my stance on the MMPI and how she interpreted it is, I believe, wrong, and I think most.
Objection, Your Honor. That's the issue we just addressed.
I don't.
See how every time they object, Elaine gets stumped. She doesn't know. She's not quick on her feet, so she gets knocked off. That's why the more you object while she's talking, the more she gets flustered. She can't come back. They talked about that in LawTube yesterday. Elaine is not good at, boom, 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 boom. She's like, whenever there's an objection, she just gets thrown off. She gets thrown off every time. That's why she tells the judge, Your Honor, she should be able to answer that.
Dr. Hughes, Dr. Curry also testified that a victim of PTSD has to effectively be prone and unable to function at all. Would you agree with that?
Objection misstates the evidence.
She said they couldn't hike, they couldn't move, they couldn't function in any way, shape, or form. Thank you.
No, that is not correct. That is often actually a myth and misconception about individuals who were struggling with PTSD or trauma-based disorders, and I'm often called to answer that and speak to that. People who are struggling with trauma and PTSD are very strong, courageous, resilient people, even though that they're struggling.
That's not true.
They get up, they have to go to work.
That's not true. That's not true. There's so many PTSD, especially veterans that can't work, can't be in. They're very antisocial. They can't seem to fit into society. They have panic and anxiety and they're very agitated very easily. So no, I don't agree with that at all.
They're going to be having to think about it and have startle and have physiological reactions until they can find a way to hit that pause and shut it off again. So they still
I don't agree with her at all.
Impairments in other ways.
That's not true.
They go about their lives. They're not, totally debilitated. If you have someone in that high range, the highest score is an 80 on the caps. Ms. Heard had a 28. If you have someone in the higher range, we have seen people who are, severely disabled because of it, but that's not the norm of people who have this moderate PTSD.
And did you find functional impairment with Amber?
Yes, I did.
Now, Dr. Curry also said that it is not within the scope of a psychologist to evaluate domestic violence. Do you agree with that?
Of course, I don't agree with that. This is what I do for a living, day in, day out, for 25 years. We are specifically trained to understand the profound impact that trauma has on people's lives. That's what we do in the trauma division of the American Psychological Association. We disseminate that knowledge. And domestic violence is one of those profound traumas. Domestic violence is part of state licensing boards, that you can't get licensed in some states unless you take training on domestic violence. You can't renew your license unless you get training on domestic violence. So people who have, specialized training in this area, it is,
Therefore, again, though, she's saying, I'm better than she is. I know more than she is. She does. Instead of, it's not what she's explaining, it's how she's saying it. So to belittle or demean like it's a competition, that's not what she's there for.
So you have to
That's not what
assess
she's there for.
the physical violence, the psychological
She's there
violence, the
to
surveillance, the economic, the emotional,
help
and
the jury
sexual violence.
logically put this together.
That is
Objection.
understanding-
Thank you.
Narrative.
She's on a rant. Please
All right.
cut her shit
Next
off.
question.
Thank you.
Now, Dr. Curry suggested that you made a determination just based on personal.
She just wants to hear herself
and
talk.
just on checklists and a couple of tests that you misinterpreted. Would you agree with that?
I vehemently disagree with that. As I stated to you, over 29 hours and 12 psychological tests and reviewing.
She said she didn't use all 12. She only used 8. We got you, bitch. We already know. Don't even try to do shit that with your arrogance up there. Don't do that. It's not impressing anyone.
What a solid forensic methodological exam looks like. And then I made my conclusions based on my clinical education, knowledge, and training to come up with a professional expert opinion.
And just
See, like,
to
I'm
remind
professional,
you,
she's
to
not.
Make sure we're reminded here, you were qualified in this court, in this case, as an expert in forensic psychology, and specifically in domestic violence and in no, I just lost it.
There she goes again. She gets
Intimate
flustered.
violence, correct, intimate and in trauma, correct?
Objection, Your Honor, misstates the record.
If you want to ask the question again.
Yeah, probably should do that. You were qualified. I gotta find my note. You were qualified as an expert in forensic psychology with a specialty in domestic violence and in trauma, correct?
Correct.
Okay, and that was in this case.
That's correct.
Okay. Now, do you still hold the same opinions you did that you gave the jury earlier?
Yes, I do.
And do you still hold them within a reasonable degree of psychological probability and certainty?
Yes, I do.
Thank you.
All right, cross-examination.
Thank
Yes,
you.
ma'am. Can we approach quickly?
Nobody believes you, Dr. Hughes. It doesn't matter how many degrees that you carry. The only thing I am wondering is, like, when it comes to domestic violence, I think I think psychology, there is an area, I believe, of I think it's psychiatry. Let me see. I gotta figure out this before I say anything, because I have to see let's see. Okay. Let me see. I'm going on the NIH website. Psychological assessment of intimate partner violence. Therapist perceptions of intimate partner violence.
Good
I
morning,
was-
Dr. Hughes.
Good morning, Mr. Dennison.
The last time you were here, I believed that you testified that you had diagnosed Ms. Heard with PTSD before you gave the gold standard CAPS-5 test.
That's correct.
And that diagnosis is actually reflected in the first of the disclosures for in this case.
I believe the first disclosure was February 2021, and at that
Yeah.
point I had done 11 psychological.
I'm looking at the psychiatry,
And
the National Center of
your disclosure reads, Ms. Hurd's responses on the PCL-5
Psychological Assessment of Intimate Partner Violence.
Of post-traumatic stress disorder with an etiology of intimate partner violence she experienced by a former partner. Remember writing that?
That's correct.
Psychologists may undertake a risk assessment for IPV for a number of reasons, including
That you need to read the manual, right?
Yes.
Can we put up 1311 as a demonstrative?
interview accused by the victim's assessment. Interviews should follow a review of official records. But how? Conduct, determine the base rate. Table
Any objection
1.
to 1311 bids, Your Honor? All right, you want to approach?
Tom?
Determine the level of risk. Institute factors. Like any psychological assessment, a sound risk assessment will involve triangulating multiple sources of information from. But this is intimate partner violence. We're talking about domestic. This is IPV. I'm looking for domestic. When it comes to psychology, like what is their role? What is this? How do I, what? Wait. How do I?
Thank you.
I don't see this in a document either. They're getting the right one up.
Yeah, we got it.
If a client is not opening up about domestic violence, mental health professionals can implement several important strategies and tools to assess for it.
Any objection to that demonstrative?
No, Your Honor.
Okay, 1312 can be published to the jury.
How do I ask my
Dr.
client if they're
Hughes,
being abused?
Do you recognize what the National Center for PTSD is?
What it is? Yes, I do.
And they publish the PTSD checklist for DSM-5,
That's correct.
that what we've been calling the PCL-5.
Correct.
All right. And are you familiar with the document that's on the screen?
Yes.
What is it?
It's the instruction manual to how to administer the PCL-5.
I'd like to move for the admission of 1312.
Any objection to 1312 can be into evidence? All right, 1312 and evidence.
All right. Can we go to the second page? Can we blow up the second paragraph on the right? The PCL-5 should not be used as a standalone diagnostic tool. When considering a diagnosis, the clinician will still need to use clinical interviewing skills and a recommended structured interview, e.g. the CAPS-5, to determine a diagnosis, correct? That's what the manual says.
Right, and this manual
Okay.
also says that this is a screening instrument, so when you do the clinical interview, you absolutely can determine diagnosis.
So
at
the
this
answer is
time.
yes. The manual says
Still
The
need to use
PCL-5
clinical interviewing skills, which I use.
let me finish my question. The PCL-5 should not be used as a standalone diagnostic tool, and they recommend using the CAPS-5 to determine a diagnosis, correct?
It does say that, yes.
Yeah, and you made your diagnosis before you did the CAPS-5.
I made my diagnosis doing clinical interviewing and 11 other psychological tests that supported diagnosis of PTSD and symptomatology.
I love Ben Shu. I love him when he knows their
You said
when he
that
knows
you
there's
read the
something
manual.
good for their
You also
case.
agree with me that we need to read the directions.
Camille's tuned in.
Sure.
Okay.
Ace. Our ace.
Tom, can you pull up 13? 1309 as a demonstrative?
If the client is not open about domestic violence, mental health professionals can implement important strategies of assessing it. So basically what she was saying is
Thank you.
there's components to it, it sounds like. So psychology gets involved, but it's not everything. It's like there's a whole pool of things that determine. So that's what Dr. Curry was talking about. She was not just talking about, hey, I'm right. She's talking about that's one part of it. And she was talking about there were gaps in her notes and all that kind of stuff. So basically, and again, we already know she's biased. So that's why she's not credible. Doesn't matter how many years. It just means she's practicing on her own terms. She formed a personal opinion. That's why no one liked her. She wasn't forming a medical opinion.
The jury is demonstrative.
She just has this, she has this look of her.
Doctor, do you recognize the demonstrative that's in front of you?
Yes, but I didn't put the red lines on that.
No, I did.
Yes, I know.
Okay. So this, what do you recognize this as?
I recognize that we previously discussed this, and I told you that I oriented Ms. Hurd to a different time frame because she was already out of the relationship.
Okay, maybe we should back it up a little. This is the CTS-2 that you administered as part of this battery test that you indicate you did in relationship to your diagnosis.
Right, this is the conflict tactic scale too.
And you'll agree with me that this test specifically asks, in front of every single question, how often did this happen in the past year?
Correct, and I
Right.
oriented
And
the
you
individual
know-
to not limit herself to the
Correct.
last year to get an accurate assessment.
She's being
of the
combative.
violence and abuse that she experienced in the relationship.
Objection, Your Honor, move to strike.
All right. We'll strike the last part of the answer. Strike the last part of the answer. Thank you. Next question.
Yeah. And you know that at the time that you gave this test to Ms. Hurd, she had been away from Mr. Depp for far longer than a year, correct?
Which is why I oriented her to a different
Yes or no?
time frame in answering the question.
Yes or no, ma'am?
Of course,
Okay, you she was gone for more than a year.
of course.
All right. Let's look at another one of these.
Don't snicker. It doesn't look good. Stay stoic, man.
You talked about the danger assessment test.
That's correct.
Amber. Not a good look, man.
What number is this? 13, plaintiff 1310.
Thank you.
Any objection to 1310 as a demonstrative? Okay. We publish the jury.
Dr. Hughes, this is a blank form, but this is the danger assessment test that you also gave to Ms. Hurd, correct?
I didn't give it to her, I filled it out based on the data that was provided to me.
Oh, so you answered the questions and you filled it in.
It was somewhat collaborative.
Okay. Can we blow up the second paragraph? It says, using a calendar, please mark the approximate dates during the past year when you were abused by your partner or ex-partner. You didn't use any calendar, did you?
I did not use a calendar because she was already out of the relationship. As I said, these are static risk factors, so they don't change. So I oriented her to the time of the relationship.
Ma'am, it's fair to say that this examination that you gave specifically indicates that you were supposed to look over the past year. And
That's one administration. People use this instrument for if you're in an acute situation in a relationship, trying to get a better assessment of the current behaviors. We can use it retrospectively, like I just stated, and in homicides and looking back about what are the serious risk factors that were in this relationship.
I didn't ask you about anything other than, don't the instructions limit this test to the previous year?
You can give this test.
Say yes or no, ma'am.
No, asking you about the instructions.
But I'm telling you how the test is administered in clinical practice and in forensic
And,
practice.
and opposing counsel can come up and ask questions about that. I'm asking you about the instructions. And the instructions say, look over the past year.
Yeah, on this, yes, that it says that.
And you had actual knowledge, we gave you the test, that Mr. Depp was gone way more than a year before this test.
That is correct.
Right. All right, let's look at more instructions. Can we look at 1247, which is already in evidence?
A lot of people are saying Dr. Hughes makes me gag. That's so funny.
Dr. Hughes, you recognize this one too, right?
Yes.
All right, this is whatever it calls CAPS 5.
The one where you left all your notes out.
Let's blow up the instructions. Standard administration and scoring of the CAPS 5 are essential for producing reliable and valid scores and diagnostic decisions. Correct?
Correct.
And you know you have to do this in a standardized way because it is the first instruction, correct?
Correct.
Can we go to the next page? One more. Oh, wait. That's great. This is a page on scoring, and we talked about this last time.
Yes.
You score these tests by frequency and intensity.
Correct.
And you'll remember that in every single instance that you were asked to fill in the blank about frequency, you failed to do so, correct?
That's not correct.
Oh, you filled in any blank on this form with respect to frequency?
I filled in the frequency on the side of the caps where I am actually scoring the caps.
No, I
Where
asked
it's
you whether
relevant.
you filled in a single blank on this form with respect to frequency. Is the answer to that yes or no?
I don't know what you mean, a single blank.
All right, let's page down. Let's keep going. All right, we'll stay at this page for a second. This is the very first box you were asked to fill in as to, I think, a fairly fundamental question, right? What happened?
We talked about this before, Mr. Dennison, and I had 88 pages of notes of what happened. It would have been redundant to put it there.
You know that you are obligated to produce this test in a way that other people can meaningfully review. Yes?
The people in this case who are meaningfully reviewing them have my 88 pages of notes.
Right, but you chose to put absolutely nothing in the box, the standardized box, that said what happened.
You don't have to put it in the box if you have it somewhere else. It's not,
Because this
it's
is not a
not,
standardized test.
if it's not a research instrument that is used for research, if you're using it for a clinical diagnostic purpose, no, you don't. If you have that data elsewhere.
Okay, let's go another page or so. All right. Let's go another one. All right, let's look at item 4B4. And I asked you whether you filled in the blank about frequency. And there's a blank in many of these items that asks number of times. You didn't fill a single one of them in, did you?
Right, because I filled them on the right side of the instrument where I am scoring it.
And that is the way that you believe that you followed the instructions of a standardized test.
Yes, correct.
No further questions.
All right, read your rights.
Very briefly.
Static
static risk factors or risk factors that don't change. It's maybe, if you smoke cigarettes, you may have a risk of lung cancer, right? That's a factor that doesn't change. You can look forward if someone's smoking, you can look past if someone's smoking. So these lethality risk factors are present whether you're evaluating them in the last year or 5 years ago.
And when you're trying to assess for trauma related to the interpersonal violence that we discussed, why is it important to get a time frame in which the relationship was in existence?
Well, you want to see the amount of trauma that the person experienced. The longer that they're in a relationship, you have more successive trauma. And one of the things that we know from the research is more trauma is not better. So the more successive traumas that you have, the greater likelihood that somebody's going to have psychological consequences and symptomatology as a result.
And therefore you need to get it within the relationship.
Objection leading.
And so how does that relate to needing to get the time frame in the relationship?
Well, you need to understand when you're trying to evaluate the impact of something, you want to have to understand what happened to the person. And that's sort of the core and the basis of trauma-informed care and of trauma diagnoses. You have to understand, the traumatic event and how it transpired and how it played out for that individual so that you can better assess for the symptomatology that's falling from it.
You said you had 88 pages of notes. What were in your 88? And without going into the specifics, can you just describe what was included in the 88 pages of notes?
In the 88 pages were many of the documented incidents of intimate partner.
Objection, Your Honor.
She's just describing it. That came up. He said you didn't fill those in the boxes. She said it was in my 88 pages. I'm just saying what was in your 88 pages. I'm not asking her to give each of the specific events. She can describe the summary of it.
Can we come up?
Boom. Shut her down. Shut her down, man. Nobody likes her. She's all over Twitter. Put a clown nose on this bitch, please. Dr. Curry was very elaborate in the standard procedure of how you're obligated. The way she filled it out was unethical. It was bottom line.
What is the difference between
They shut her down.
clinical scoring and clinical evaluation and research evaluation with respect to the CAPS-5 and the other tests?
Action compound.
Sustained.
I'm not as quick on Twitter as a lot of these people are. Dear doctor, here is what the standardized means.
Sustained. Next question. Okay. Can you explain to the jury what the difference is between clinical scoring and evaluation on a test?
She's trying to do the same thing that they did.
Your Honor, compound.
Overruled. Good.
Sure. So the PCL and the CAPS-5 are frequently used in research. And when they're used in research, that means the document stands alone. They don't have 88 pages of notes to help understand the background of the trauma.
That's why you fill out the boxes so that they can, this jury is not, they don't have time to go through 88 pages of notes.
Back in the day when I was a research assistant, I had to input that into the computer. And then they would maybe look at some of that data for the research study. So that becomes very, very important.
So, Andrea Burkhart said, according to Dr. Hughes' instructions and directions for standard testing are optional.
Afternoon recess. Our morning recess. Let's take a 15-minute recess. Do not discuss the case with anybody.
The information that took apart Amber Heard's hoax crime has been available for years, but the media has actively suppressed it. Really think about that. The charity lies, the lack of medical evidence, all of it. They chose instead of ruining Johnny Depp's life. Yeah. She just said, I didn't have to. It's standard procedure. It's her obligation as a therapist. It's unethical not to. I understand what she's talking about. Like, I'm not going to write it here because I wrote it there. But that particular procedure and that's in place. So if you are in a trial, right, and they need to go through notes, they're not going to know that it's somewhere else. If you don't fill out every portion of that, and understand, oh my God, it's not rocket science, lady. It's fucking common sense. You're this completely supreme, so you say, forensic, psychologist, but yet you're dismissing the standards of your job. Like it doesn't make any sense. Yeah. I didn't write it in the box. Where's it supposed to go? That's exactly. Where's Waldo? Hey man, I'm totally there with you. This is too much. It's just this lady's, and then her arrogance, man, when she gets up there, her demeanor, the energy that's around her it's so off-putting. I mean, I'm sure the jury feels that. There she goes again, coming up like, I can't believe I have to come back here and explain my work when, in my opinion, it looks so, it looks so self-explanatory. Well, that's not the way it works. Okay. That is not the way it works. Hold on. I'm going to go to Twitter. Let's see if I can. I just got to remember I need to get some more coffee too. Well, we're good this morning. We haven't had any buffering. That's good. I'm going to put this here. She's just stupid. She's stupid. She's just not making an impression. The whole point of representing a team is to make an impression. You know what I mean? You're not doing Amber's case. And then Amber's snickering all the time. What is happening with that? Girl, I mean, you're at the tail end of this and you want to have some kind of snicker and laugh as if it's in the bag for you? And jury's paying attention to every move you make? Are you serious right now? What do you mean? Like, where do I stand with everything right now? Like, what do I think? Is that what you're saying? Elaine, can you go? Elaine, can you go without arguing for even a minute? That's funny. There was no way. Wait, what did she say? This was underwhelming. Who wants to step up to help me invest in paying these two for proper PPV debate? No shit, man. It's just, what's shaming is Dr. she's not certified, right? But Dr. Hughes is, but yet Dr. Curry goes more by the book and the instructions and the duties of her job rather than, hey Candy, good morning. Well, the thing is no matter what's submitted in evidence, because I didn't hear, like, if you guys know, nothing happened. Dr. Hughes came back up on the stand and made an ass out of herself as usual. Because nobody's listening to her. And I was waiting for Larry to put some updates on the jurors' faces and James. Because I think I'm not getting tweet notification from James. That was a problem. Anyway, why is Elaine only argument to witnesses that are damaging to their case? Always you wanted to be on television. That's funny. So anyway, so we had the forensic computer guy about the pictures this morning, Candy, which also could not verify. I mean, he came up and just basically disputed what Depp's tech forensic guy was saying yesterday, which didn't do them any good either, because ultimately by the end of the interview or by the end of the questioning, he could not verify that they were original pictures. He just couldn't. I mean, bottom line is, like I said, when you're talking about a jury that has no training, that's going to go back there and deliberate, you have to make it as simple as possible because they're under a timer. Like, they're not going to have time to break all this shit down. They're going to go by visuals. People are visual. So like when they see the picture side by side, it's clear that each picture looks different. Yeah. So anyway, so that was the first set of witness. Oh, excuse me. I'm sorry. That's not true. Yeah. No. I think it was the front. I take that back. I think their first standing witness, physical witness, was a orthopedic surgeon, a hand surgeon, and then they tried to, of course, throw in some kind of opposition with his deposition versus what he's saying today, which basically is going to try to dethrone, like, the point of, did she break the finger or whatever, tear the finger off or whatever the hell. Oh my gosh, you guys, look, it's only been an hour and a half and already I have like 10 pages of notes. Everything is moving very fast today, very different atmosphere. Clouds, the jury's clouds the jurors today. They appear restless, impatient, ready to get out of here. See, that's what I'm saying. Like, they don't, when you're at the tail end of this thing, and Candy, you can chime in on this if you want, but when you're at the tail end of this and it's just been an abundance of information, and their final rebuttal witnesses are not short, brief, and to the point, because the jury's already overwhelmed, exhausted, full of, their brains are just mush at this point because they've had so much information to consume. Then they have to go back and deliberate. And those rebuttal witnesses, you want to make their direct and their cross as simple as possible, you know? And Dr. Curry yesterday, I know she spoke in some hard to read language, but and it depends on how you process information as a person, how detailed you are. Because I know Dr. Curry speaks a bit elaborate. I get that. But I think at the end of her, direct, I think she made her point, which just means that Dr. Hughes administered all these tests. And it wasn't until she gave a test, Dr. Curry, 10 days after that, Dr. Hughes decided to give one of those tests and diagnose her with this or that. The way I received the information yesterday, which therefore leads a little bit of sus. So, in other words, everything that Dr. Hughes has done has been in bias and been to the benefit of the case, which what Dr. Curry is there to say is she was not following protocol and being very elaborate. And whether or not you write what your solution is or what your current evaluation is on the side of the paper or whatever, you are obligated as a physician to fill out these mandatory forms for such reasons, like what we're talking about, which is 7 or 10 people. And let me bring up the jury box so you guys can see it. um you're still like, they want simplicity. So if they're running through notes and there are boxes of medical notes for anyone really that are empty, oh, and they're going to look at each other like, where the hell is what we're supposed to look at? I mean, and what are they going to do? Call the doctor and say, hey, where'd you put the notes? Oh, I'm sorry, I put them up there on the right hand side. Can't you see them? Or didn't you see the reference on page da 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 da? Well, that doesn't matter. It doesn't matter how redundant the notes are. As a physician, as a psychologist, it's your duty, your ethical duty, to fill out and follow protocol. You don't take shortcuts. That's not the way it works. You know what I mean? So there's that debate. And then, like I said, the surgeon battle, of how Johnny's finger got cut off is another thing that happened this morning. So Johnny Depp's last rebuttal witness was the surgeon, and then they rested, I believe. So the surgeon just came off and said, that he believes that Johnny Depp's finger was severed or whatever, however they are saying it was. The second set of witnesses, then they rested after that one. So the first rebuttal witness for Amber's team was forensic, uh, the forensic computer guy, the tech guy, to examine the photos, which therefore they went and talked about the metadata and what was submitted versus, what the previous guy said yesterday and all of that. So that was kind of a showdown, and they're all there to oppose each other. I get it. But after a while, you have to understand, people are visual. They just are. It's like I could put an audio video, you know, on YouTube. Like, for instance, I could do a live stream like I do in the morning on audio only with me not on camera. And then do a live stream with me completely on camera and balance the ratio of who clicked on my video that was interested in the audio versus the visual, right? And most people are visual. So most people are going to click on the video where I'm on the video talking to you as I'm, like where you see me talking to you rather than the audio portion of that. And that's a perfect example of photos. People are visual. So when you show them a picture versus all the technicality of how the picture got there, if she used an editing software, you're going to look at the picture and say, oh, there's quite a difference between these two. Nobody gives a shit about all the middle the complicated details of that. They're going to say, I don't see any swelling. I don't see any bruising. This picture looks like this. This picture looks like this. And that's what they're going to assess. You may, out of the 10 people on that jury, like may have some people that are analytical like myself, and want to see all the details and stuff, but very, very rarely does that happen. So that was the second witness. That was their first rebuttal witness. And their second rebuttal witness is Dr. Hughes, I believe. So they only had 2 witnesses because their time is very short. And so that was Dr. Hughes. Dr. Hughes is, and I think we're in the middle of redirect, aren't we? I don't remember. But this is it. After this, they only get 2 witnesses this morning because their clock is out. And then that's it. And then I think the rest of today will be closing arguments, if I'm not mistaken. Now, closing arguments should go into today, into tomorrow, I think. But, don't quote me because as far as scheduling goes and the way that closing arguments work, I'm not quite sure. So, but the jury is restless. They're ready to sit down now with all this information and, start making some decisions, I think. All right. So let's see. Today might be a very short day because the defense only has about 34 minutes left. So Johnny's team, no, excuse me. I'm sorry. The defense is Amber's team. So Amber's team only has 34 minutes left, which I don't know who they're going to close on with that. So we'll see. At 9 a.m., we can see a witness seated in the front row of Johnny's side. I guess they were not done with their case yesterday. So I think, aren't we missing a witness for Johnny Depp? I feel like we were remember the stewardess that was supposed to, did we miss that? Remember when the feed cut off yesterday? It's kind of weird because our feed cut off and then we were trying to find a network, remember, to watch, but yet Legal Bites said that they had a witness. So I don't know. I'm a little confused about that. I know it was a link. Also, Johnny Depp's team on Cross, you filled in these incorrectly, didn't you? Here's the evidence. Amber Heard's team on Cross. Dr. Curry, did Mr. Depp let you eat food? That's funny. That was yesterday. That's funny. 14 minutes ago. Let me show you the jury box one more time. I apologize. I meant to get to that. So, Candy, you haven't missed much, really, but the time is running out for the Heard team. So we have 34 minutes on the clock for them. Johnny's team does have longer. So I'm trying to figure out how to open these pictures without it popping up on my left screen. Let me see. Let me see if I can left click on this and open it this way. I didn't feel so bad. I was watching one of the other live streamers yesterday. He's like really, really popular. He gets like millions of views. And I saw him he was fussing with something and a window popped up. He was doing multiple things at one time. And a window popped up in his main court feed. And then he moved it over really quickly. So I was like, oh, good. I'm not the only person that's like, where my computer defaults to opening on one side, because obviously you have to be like really, conscious of what you're showing. And I'm glad that you guys are really attentive to that. So I thank you guys for being here with me. I hope that I'm trying to figure out how to market, like, what do I want to say? Promote myself a little bit better. So I'm on Facebook as we speak here, trying to get some more people in the chat somehow, but I've been kind of slow because I have to post in several groups. So I'm a member of like 150 YouTube groups. So I'm trying to figure out which one I'm kind of copying and pasting so I can get myself together. Anyway, so here's the picture in case you guys care. I did watch Legal Bites yesterday, Candy. I don't know if you saw the tail end, but it was a really good effect yesterday. I was really worried about Johnny's Cross. Johnny's Cross was not as big of a deal as I thought it was, so that was good. And I saw multiple attorneys talk about that. So Emily talked about it, Rob talked about it, Ian talked about it, Runkle, Alita, lawyer Natalie, Uncivil Law Hogue talked about it. So they were all really pleased with TMZ. They didn't think that Johnny's Cross was that bad, which was nice. And that was only because no matter what the text said, we've already seen those texts, with the whole in the beginning, remember with the whole coffin thing or whatever the hell that was about. So the texts weren't that damaging, honestly. Whether or not they came from Johnny directly or not, that didn't really matter. And then they were also talking about what we say TMZ guy. There was somebody else I feel like that was really effective for them yesterday also. I think it might have been the forensic guy. He was really, really the picture guy showing the visual of one photo being overlapped on the other. And I think that was really effective as well. Like I said, people are visual. So to see that motion going from one photo onto the other, I feel like that was really, really effective. I feel like seeing that in motion, that's why I think remember Brian's video that we watched, the first 3 videos on his gallery? Remember that on his catalog? And we went through part 1, part 2, and part 3. And he was talking about the picture and the background in the picture. Do you guys remember that from Incredibly Average's videos, where he kind of stops the video, he plays a song, and he photoshops everything? And that was very effective for his viewers. So I think when you use that kind of that kind of method to show as a example of the photo situation, then I think that's more effective. And I think that left doubt in the jury's minds. So I did see that for this case, the jury is given only what's left of today and tomorrow, I guess, to determine guilt and award. Very unusual, not typical. Yeah, I think they said in the very beginning that the jury was only going to have one day to deliberate. I think that was announced in the very first in day 1 of trial. So I don't remember, but I'm almost positive that the jury only gets one day to decide this, which is, to me, wow. And at the end of the day, no matter how much we've heard about SA and DV, and the bottom line is this is a defamation case. They have to prove malice, they have to prove damages, they have to prove the DV and the SA came into the picture because of the op-ed and because of what she accused Johnny of. So at the end of the day, this jury has to decide, did Johnny do the things that he was accused of doing? I mean, it's that simple. And it's about defamation and her actions. Did they prove malice to defame him in any way, regardless of the hashtags and all this bullshit they're talking about? Because this has been going on for a long time. And you have to remember that in the UK trial, they did not allow him to present as much evidence to defend himself. Amber Heard was a star witness. It was not her case. And they went by her word. So a lot of what she provided was not even factual. And the judge, I think the verdict in that was the judge that decided, I believe. I don't think that was a jury. I could be wrong, but just remember the son, right, was the person that wrote that article was the son of the judge. So even though the paper's called the Sun, SUN, the person that wrote the article was the judge's son, SON. So it's like there was an affiliation there, you know what I mean? And that was kind of unfair anyway. So Johnny D is right. This doesn't sound like him. It does sound a lot like someone else. And this was floating around on Twitter yesterday. And I'll show you again, which I think is very important. You should retweet it if you have a following. But this was very effective to people on Twitter right here. It doesn't sound like him or whatever. And this is what they're talking about, the incoming versus the verbiage on it. I need, I want, I take, versus a picture that is on the internet that she has out there. She's holding a sign. Good afternoon, my beloved Tonto. He was filming The Lone Ranger. This blonde texting bitch will eat you alive. I want, I need. Give me what I want, mine. So this doesn't sound like something someone would post, even if it's in private, sexting, whatever the hell they were doing. That doesn't sound like she was terrified of him either. So there's that. You know what I mean? Like, so, I mean, the jury's going to take into account all of what's going on. So here's the graph, like I said. So when the DIY guy is talking about the jurors, here's 1, 2, 3, 4, 5, 6, 7, 8, and 9. 1 is in their late 20s to 30s, 2 is in their mid 20s, 3 is in their mid 30s, D is in their 30s to early 40s, 5 is a mid-30s male. I'm sorry, female, male, male. Then you've got 6, which is a male in his 60s. Then you've got 7, which is 20s, 30s. That is also male. Caucasian, mid 50s. And then you've got an Asian Polynesian male in his 40s. So this is something that you need to take into account when we're talking about Larry's posts. And that is where he's reporting all the jurors and how they're feeling right now. So James just posted. Let's see what he said. So let's see, because all I really care about right now are James's and what's the time looking like. So by his feet, Ben keeps a small brown alpaca stuffed animal. And at one point when it fell over, he reached down and stood it back up. That's funny. That's funny. Somebody probably gave it to him. Today might be a very short day. Okay.
Are we ready for the jury?
All right, we're back.
Yes, yes, sure.
All right, here we go. Well, I don't know. I don't know if I believe that. I mean, I do believe that he called, but I think he's been in the business long enough to understand. I don't believe that he was directly trying to get her fired. I think he was trying to let them know what was happening and how it was going to backlash on the studios. That's what I think. I mean, he doesn't have the power, for one thing. He doesn't have the power to just fire somebody. I don't believe that. So that's just my own take on it. We can agree to disagree on that. So no, I don't believe that he was being deceptive. I do believe that he was forewarning them, and letting them say, hey. I mean, he could have said that in a private text to Stephen Deuters, okay. But honestly, it doesn't really matter what he wants at the end of the day because they're in production. So they're going to make the final decision. Does he have an influence? Possibly. But I mean, was he the one to actually decide if she was going to be fired? I doubt it. And that's only because my brother was in the industry. So I know regardless of what kind of pull he had, he did not have the power to fire her. So he couldn't just call and say, "Hey, axe her." You know what I mean? Like I know he has pull, I know he knows the producers and I know all of that stuff and I know he got her the audition, possibly he even got her the job. But once they're in production, they can't just go and fire her. That means a replacement and cutting. No, that I just don't believe that. There's too much involved for him to just, say, "Hey, I want her out." I don't know why Kipper did. I don't know why they didn't bring Kipper back to the stand. I'm not sure. Again, I mean, I don't know if I'm right. I'm just knowing that based on the way the industry works, my son is a film student as well, and based on, just learning from my brother, throughout knowing people in the industry and stuff, I just think that, not to say that I know anything like I said, but I do know that, we learned through my brother how the industry works, and regardless of his power, he could not just get her fired. Even if he called and whined and pitched a fit, he has no control over that. But I believe him when he said, "Hey, I called them to tell them what was happening and to tell them how this may or may not affect the studios." I believe that part, you know, and it's up to them on how they want to act on that, I mean, TMZ already came and verified, she set the whole thing up. She set the whole thing up. And on top of that, to confirm his deceptiveness, we could watch the behavioral panel's video because they're going to do another video on him. So just make sure you're subscribed or make sure you're following the behavioral panel on Twitter. Get their notification tweets and see what they say. I guess if that's But either way, I mean either way, it doesn't really matter at this point. It doesn't matter. I don't think I'm going by the attorney's assessment, and I don't think it had that much. I don't think the jurors are picking that up on that. I just don't. Whether or not they want to believe it, that's going to be up to the deliberation room. That's just my own opinion, Like I said, I mean, I could be wrong, so I'll see the behavioral panel's video. But either way, we'll know tomorrow. I mean, all this shit it's not that deep, people. It's not. They're on crunch time. It's not that deep. I mean, one of the attorneys in the Legal Bites live stream already said early on the jury decides what they want to do. It doesn't matter what they see. If they make up their mind in the middle of the trial, their mind is made up. Period. It only takes one to hang the jury. So we'll see. There is no way to see what the jury or even try to
right, thank you, ladies and
try to
gentlemen. Be
figure out
seated.
what they're
All right,
thinking.
your next witness.
Your Honor, defendant calls Amber Heard.
Oh,
All right,
great.
sir, if you come to the stand, please.
Great. She's going to lay it on thick again just for that last try
Yes, ma'am.
oppression.
Water.
She doesn't seem afraid to be walking by Johnny Depp right now, does she? She's not flinching now, is she?
All right. Thank you, ma'am. Just a reminder, you're still under oath, okay?
Of course, Your Honor.
Thank you. Thank you. All right, your question?
We'll see how she stares him down.
Amber, just to orient you and the jury, at this time, we're in the rebuttal to your counterclaim against Mr. Depp. So I'm going to confine my questions to that, okay?
All right.
How have you suffered publicly as a result of the Depp Waldman statements?
Objection, speculation.
Overruled.
I am harassed, humiliated, threatened every single day. Even just walking into this courtroom, sitting here in front of the world, having the worst parts of my life, things I've lived through, used to humiliate me. People want to kill me, and they tell me so every day. People want to put my baby in the microwave, and they tell me that. Johnny threatened, promised me that if I ever left him, he'd make me think of him every single day
What?
that I lived.
Objection, Your Honor, non-responsive.
I'll sustain the objection as to that.
Thank you for putting Camille on that. Camille's back there with her finger on the mic. You go, girl.
How did Mr. Depp's statements and threats to you that you were discussing, how do those continue to manifest themselves today?
In the harassment and the humiliation, the campaign against me.
You shouldn't have lied.
Echoed
You shouldn't have
every
lied.
single day on social media.
You shouldn't have lied.
now, in front of cameras.
You shouldn't have lied.
Every single day, I have to relive the trauma.
You shouldn't have lied.
My hands shake. I wake up
You
screaming.
shouldn't have lied.
I have to live with the trauma and the damage done to me.
You shouldn't have lied.
My friends have to live with a set of unspoken rules.
That's what
about
happens
how
when you lie.
to not scare me.
Objection, hearsay.
Thank you.
Yes, sir.
Unspoken rules
Overruled. Go ahead.
about how to not touch me, not to surprise me. My intimate partners have rules about how they can deal with me, how they can touch me.
Mm-hmm.
I have
Yeah,
rules for
whatever.
doctors and medical professionals I see, gynecologists I see. I live my life with these sets of rules that I have to.
Please do not
follow,
drag
my
this out. They
friends
only have
follow
30
for me
minutes,
not
by
to
the way.
have a panic attack or a triggering event.
Uh-huh. Yeah,
I
because you
relive
heard
the
Dr. Curry
trauma.
yesterday.
Even
So,
if I'm
okay.
training to do my movie, for instance, if I'm training for Aquaman, combat scene,
Aquaman.
and a trigger happens, I have a meltdown and have to deal with that. The crew I work with have to deal with that because of the damage I walk around with every single day
You shouldn't have lied.
and what I've lived through.
We heard TMZ yesterday.
I'm not
You set
sitting
it all
in this
up,
courtroom
dude.
snickering.
You set it all up. And did you
I'm
think
not
that the
sitting in this
public wouldn't come
courtroom
for you?
laughing,
Are
smiling,
you
making
serious?
snide jokes. I'm not.
That's your fault.
This is horrible. This is painful.
Here we go crying
This
with
is
no tears.
humiliating for any human being
She
to
studied
go
that.
through.
She was laughing yesterday.
And perhaps it's easy to forget that, but I'm a human being.
Uh-huh. No tears whatsoever.
And even though Johnny promised that I deserve this and promised he'd do this, I don't deserve this. I want to move on. The statements, the attacks on me, the campaign, that Johnny has elicited millions of people.
Well, how he doesn't have any control over millions of people.
Foundation.
Thank you.
Torture me.
Speculation.
I'll sustain the objection. Next question.
Thank you. No, no tears whatsoever.
How have the Depp Waldman statements impacted your ability to do charitable work?
You know, the only reason that
Whoa, whoa, whoa. Come on now.
people like
Tone it
Dr.
down,
Kirby
please.
can sit up here on the stand and say I'm high functioning and I do things like have hobbies and have
Tone it
interests.
down.
Objection,
Because I'm not-
non-responsive.
Your Honor, Mr. Depp gave long-winded responses yesterday.
Okay. It's because I found a solution to that pain. I woke up every morning with panic attacks and trauma until I realized I could do something with it. So to answer your question, Ben, is I was able to turn the things that I've lived through, my pain, my life experiences, into work,
Into a book?
action, into providing a voice for other people. I'm not a saint. I'm not trying to present myself as one, as you all know, but I selfishly found relief in being able to use what I've lived through to advocate for others, to bring light to these issues, to give a voice to people who don't have the voice and the platform that I have. And while I would not wish this situation on my worst enemy,
I can't. I have to block you. I won't do that.
who doesn't have it. But I now, as
I have the
today,
option of
can't
timeout
have a career.
or banning
I can't
you.
even have people associate with me because of the threats and the attacks that they have to endure.
Objection,
when they are.
non-responsive.
Thank you.
And I can't do my charity work.
Sustain the objection.
Move on.
Amber, other than the threats that you've described, what other threats have you endured since the Depp Waldman statements were made?
I receive hundreds of death threats regularly.
Shouldn't have lied.
daily.
TMZ just confirmed yesterday. She
Thousands
set this whole thing up.
this trial.
Did she not think that the
Started
public
people
would have some
mocking-
kind of opinion on it?
mocking my testimony about being assaulted,
Mm-hmm.
making fun of my
Objection, relevance.
Thank you.
Non-responsive.
Stand damages. You can continue.
Shut her down.
It's been
No tears.
agonizing.
None. No tears.
Agonizing, painful.
She knows how to make the
was
face
really-
and the cringy whatever, but she doesn't know how to
Who
cry,
ever has to go through.
which means she's not feeling what she's
Oh,
saying.
no one ever has to go through something like this.
When she goes down and sits at her chair, she's gonna just be
want
fine.
Johnny to leave me alone. Just
Now
want him to
she's
leave me
crying.
alone.
I mean, now she's laughing.
I've said that for years now, and I thought he would after
Objection,
2020.
non-responsive.
Thank you.
Sustain the objection. Next
Thank you,
question.
Camille.
What do you hope to reclaim after this is over?
You certainly don't have a career.
Protecting the secret that I did for as long as I did has taken enough of my voice. Johnny has taken enough of my voice.
No
I have
tears.
the right to tell my story. I have the right to say what happened to me. I have the right to my voice and my name. He took it long enough. I have a right as an American.
Oh, are you trying to get political
talk
right
about
now?
What happened to me?
Are you really trying to
Story
get political
and
right
truth.
now?
I have that right. I hope to give
You
my
have
voice
Elon
back.
that you're working on as we speak.
It's all I want. And I've said that from day one.
Thank you, Amber.
Get the hell off the stand.
Cross-examination.
Look at, she has no tears. What, she wipes her nose. She picks up a tissue and she wipes her nose, but with her finger. She wipes her nose with her tissue and then she makes no sense. You don't wipe your nose with your finger when you have a tissue in your hand. She does it every time. Putting her on the stand does not help. It makes it worse. Even for them, Johnny Depp's cross wasn't very good. It wasn't damning, but like for her to keep going on and doing the show, it doesn't help. And she's always clocking the jury, always. Who's she looking at? What juror is she looking at? 9? Wait a minute. Hold on. Hold up. What juror is she looking at? Let's see. She's looking at 9. She's looking at 9 and 5 and 4. Let me move this over here so I can keep it up. I have to see who she's looking at. I love Camille. Come on, girl. This is your time to shine. Come on, girl. You know what's weird is she's drinking something yellow. And Johnny came in yesterday and was drinking something yellow in his bottle, in his Fiji bottle. And now she came with something yellow. Either it's a common drink that's just available and, and that they're offering to the celebrities, or she's copying Johnny, which is weird. Yeah. She wipes her nose with her finger while holding a tissue. Happens every time. The behavioral panels talked about her behavior. She's histrionic and BPD. The behavioral panel said it several times. Yeah, you got to watch your language. I don't know how viewer. I'm gonna start calling you viewer because I don't know your name. But yeah, there's guidelines in the chat, and I get stricken if I get reprimanded in my email. Oh wow. Oh, I see. I don't know anything about that. So, but good to know, I guess. Camille is on it. I'm so glad she's like linked to Amber. She was probably waiting for this. Girl, come on now. I gotta heat up my coffee. We're at 8:23 in California. I got up at 4:30. I was too tired to put some makeup on my face. I was like, no, I need to rest. My face needs to rest. I'm old. My skin is old. See? This is what the average person's saying. Apart from being called out for a liar, how has she been humiliated when she stood on the stand and said that she had to clean up shit and vomit that Johnny was lying in without proof? She tried but failed to humiliate him. The point is she set this whole thing up. So you can't set something up and I'm not saying Johnny's innocent. That's the thing, is I'm not saying that Johnny didn't do this or didn't do that. That's not what I'm saying. But he didn't do things to the extent that she did. That's the point. She set this whole thing up. He said it did not have to go this far. It did not have to go in this direction. You've shut me down. You snickered. You smiled. She did that shit all day yesterday while, she was laughing and just thought she had it in the bag with the new baby hobbit born. And, that's not the way it works. I mean, you can't come up here every time she grabs a tissue. She does never, ever. Brian said, so 5+ hours of cross exam. Wouldn't that be glorious? No way. Are they going to use the cross examination on her for the rest of her time? I love Camille so much. Amber goes for the win. Back on the stand. Yeah, really. Nate the lawyer just posted that. I haven't gotten anything from him. You know what? I don't have notifications on for him. I need to. Whitney's, I guess maybe they told Whitney to be stoic. She looks weird. Whitney has she has a strange demeanor. She always looks afraid to me. She looks worried and afraid. She should be. She should be. Geller Depp said, "Oh, now Amber Heard wanted Johnny to leave her alone. So when she was texting him 2 years after he left her, when she wrote the op-ed, no shit, man. For reals. Now she wants to cry to the world and say, I'm sorry. That's her way of saying I'm sorry, by the way. I don't think she's mad. I think she's more concerned. I think she's worried. I don't think she's mad. I don't think she looks mad. I think that's her demeanor. But I think she honestly looks worried. Concerned. You know, she has a look of concern on her face all the time. Or at least in my opinion. I don't think she looks mad. I think that's just her demeanor. You know, that's how she looks. Oh. Oh, I see. Okay. Y'all know much more about body language than I do. I watch the the behavioral panel. I watch Spidey. And there was one more person that I watched, I can't remember. The language guy or something. I think he's called the body language guy or something. He's kind of funny. He's like, "Hello, my body language buddies." He says that every time. "Hello, my body language buddies." I got it here. Do I have him on Twitter? Am I following him? Let me see. He cracks me up because of his body language guy. Let me see. Meal's got to get some good content today compared to yesterday because of TMZ and all that. There's Larry. Yeah, Jesus. Oh, he's live right now. I'm following him, but what's he saying? I don't think he's saying anything. Let me see. Let me see if he's tweeting at the same time. Everybody's streaming this trial. Everyone's streaming this trial. Has he said anything? If you gaze long into Twitter, Twitter will gaze back at you. I've seen people I respect slowly descend into madness on this app. What? Intelligent people babbling incoherently about an issue like hysterical nutters. So weird. Oh, he's talking about Meghan Markle? Amber is the snarkiest victim ever. Oh, he was judging her yesterday. That was the best live stream ever. You rock. Let's see. Serious, what the WTH? He hasn't really tweeted today. That's strange. All right, let's see what Larry's saying. What's going on with the jurors? I didn't hear them sidebar. Dang. She's crying today. See, that doesn't work. That's why she should have. Remember how I kept saying she needs to stay stoic? Like yesterday, she didn't need to have that demeanor of arrogance and smugness on her face yesterday because everybody was looking at her. And if they're going to bring her on the stand like they did Johnny, then now she's going to claim, like, from yesterday's demeanor to today's demeanor. Now she wants to come and cry and say, my life is ruined and this and that and the other. That doesn't go well. Hey, how are you? Jissy? Go ahead. I had a question to ask. Is the final day today? I've seen a lot of people say that it ends today. Well, the witnesses end today. Closing arguments, I believe, are tomorrow, and then the jury will deliberate. So I don't know if we're going to have witnesses all day today, but I do know closing arguments are tomorrow. And I don't know if we're coming back Monday just for the verdict. I'm not sure. But yes, this is their final witness. and Camille's getting ready to cross. So not sure. I think Johnny's team has 5 hours left, I believe, on the clock is what Twitter's saying. And then closing arguments are tomorrow, like I said. So, and we're not sure who's doing closing arguments yet. We're not sure if it's going to be Ben Chu for Johnny's team. We're not sure if it's going to be Elaine or Rottenborn doing the closing argument. So we're just not sure at this point. But yes, today is the last day for witness testimony. I hope that answers your question. Yeah, well, that's why I like the fact that you and I like the fact that you and Candy are voicing, what you see in terms of body language and stuff like that. So, like I said, I'm no expert at anything. I just go by intuition, sort of, I guess. So what I see and what I feel when they say something. So for me, it's all about emotion for me. It's like, and I know sometimes emotion can cloud logic, but there's things to me that are common sense and things to me that only are, like make sense, right, to do. And then there's, the part of me that's, that is it just there's just a natural way of doing things. I feel like just the natural behavioral thing, you don't, but also, just being able to witness her on the stand and the way that she's been testifying. And then yesterday, I think yesterday was the worst for her. I mean, she should have never came in with the smirk and the energy of, I got this. I mean, obviously she didn't say that, but what I'm saying is that her demeanor and her energy that was around her was like, I'm going to win. And I think part of it was because she had um that new attorney on her team, and she just felt like, oh, now we have someone just as strong as Rottenborn. And also, she was pretty happy with Rottenborn's cross yesterday. Rottenborn came strong, which was fine. I don't think, I mean, as an attorney, I think Rottenborn's performance yesterday was, I agree with LaTube about how Rottenborn's performance was probably the strongest it ever had been. But at the same time, did it really make enough of an effect at this late in the game, And that's why we're relying on the DUI guy plus, which is Larry. He's in the audience and they're reading the jury. And we've been sharing, I don't know if how long you've been watching, Jesse, but I've been sharing this little graph here. Hold on one second. My mouse is lagging. So hold on one second. But this is the graph. One second. This is the graph of the jury box. So when you look at her, if you set this down, E and 9, 4, 5, and 9 are right to her right. And 6, 7, and 8 are in the front, and 1, 2, and 3 are in the back. So when you see her eyes shifting, you can tell who she's looking at. Get Elaine out of there. That woman is a scam and a clown. I believe it. I mean,
Ms. Hurd, you just testified that this case has been very hard for you. So let's talk about that and why.
All right.
Your lies have been exposed to the world multiple times, right?
I haven't lied about anything I've been here to say.
You sat here and told this jury that the events in Hicksville started with Mr. Depp getting really upset about a woman leaning on you. Is that correct?
Yes, that's effectively what happened, yeah.
You testified that he actually grabbed that woman's wrist and twisted it, right?
And told her that he could effectively break her wrist by saying he knew how many pounds of pressure, or asking her how many pounds of pressure it took to break a human wrist.
But your own witness, your former best friend, Rocky Pennington, she didn't corroborate that, did she?
I'm not quite sure what part of that night she saw. There were a lot of people there.
She didn't testify that Mr. Depp grabbed anyone's wrist in Hicksville.
Again, I don't know what Rocky saw. There were a lot of people there that night.
You testified that once you brought Mr. Depp back to your trailer, he trashed it, correct?
That's correct.
And the manager of the Hicksville trailer park was furious that Johnny had wrecked the whole thing. Do you remember that testimony?
That's correct.
Well, we heard from that manager of the Hicksville trailer park Morgan Knight on Monday, didn't we?
I'm not quite sure who that guy was or if he had any involvement in this. I know a lot of people have come out of the woodwork to be involved.
So you're accusing Mr. Knight of testifying and committing perjury?
I'm not accusing anyone. I just don't recognize that man.
You heard Mr. Knight testify that it was actually you who was upset with Mr. Depp spending time away from him. Isn't that correct?
How would he know? He wasn't there.
You heard Mr. Knight testify that it was actually you who was yelling at Mr. Depp.
Again, I've heard a lot of people say a lot of things to be involved in the Johnny Depp show, but he wasn't there. He doesn't know. And he certainly doesn't know what happened behind closed doors, like most people.
So you're calling Mr. Knight a liar?
I am saying he wasn't there, and what he testified to doesn't match what I know happened. But I don't fault him. He wasn't there, so how would he know?
He testified he was there, Ms. Heard. Did you hear that?
That's his testimony, yes.
So you're calling him a liar?
I'm just saying he wasn't there.
You heard Mr. Knight testify that the trailer wasn't trashed, and that's why you're calling him a liar.
He testified that a light fixture was broken, similar to the way that.
Yes, others in the light fixture.
fixture.
That was the only thing that was
Ms.
broken. Ms. Heard. The only thing that was broken in the trailer, according to Mr. Knight, was a light fixture. Yes or no?
I realized that he summed it up by saying a light fixture was broken, just the way his security guard summed up him trashing my closet as being
Your Honor,
rearranged.
I'm going to move to strike everything after he summed it up, that it was a light fixture. That's non-responsive.
Answer the question, Your Honor.
And the security guard testimony, Your Honor?
I'll allow it, go ahead.
Mr. Knight also testified that he charged Mr. Depp only $62 for the damaged light fixture. You heard that, correct?
I did.
In Hicksville, you were the only one that was jealous that Mr. Depp was spending time from other people. Isn't that correct, Ms. Heard?
That is incorrect.
In Hicksville, you were the one who was upset that Mr. Depp wasn't giving you enough attention.
Incorrect again.
Ms. Heard, you told this jury that you had no idea the press was going to be at the courthouse when you got your TRO on May 27th, 2016. Do you remember that testimony?
I said I did not have anything to do with it. Yes.
No. My question again. You told this jury that you had no idea that the press was going to be outside after you got the ex-parte TRO on May 27th, 2016. Do you remember that testimony?
I apologize, I must have misunderstood Ms. Vasquez. I actually had no idea whether they were going to be there or not. When I walked into the courtroom that day, it was completely quiet, still, empty. Even though I had given Johnny's team notice that I was filing a TRO, we had no reason to believe the press knew.
And Your Honor, I would also ask that you instruct the witness to please stop talking once I lodge an objection.
Your Honor, she's trying to answer the question as best she can. Ms. Vasquez is misrepresenting to her what she testified to.
Well, I'll strike the last part as non-responsive, just if you guys answer the questions asked. Okay, thank you, Ms. Heard.
In fact, you testified that you were, quote, shocked when you saw press when you were leaving the courthouse. Yes?
Yes.
You weren't shocked at all, though, were you?
Incorrect. It was
You knew the press
horrifying.
would be at the courthouse, right, Ms. Heard?
No.
Well, you did bring your publicist to the courthouse with you on May 27th, 2016, didn't you?
I sure did. I'm a public figure. I brought my publicist in case it blew up.
Mm-hmm.
In case.
You
Mm-hmm.
actually had alerted TMZ that you would be filing a TRO against Mr. Depp that very
No,
day,
I did
didn't
not.
you?
No, I did
The
not.
one day you didn't bother to wear makeup to cover up the mark on your face.
I did not call TMZ or any other news source or paparazzi source. No one.
Well,
I
we
never
heard
did that.
testimony from former TMZ employee Morgan Tremaine yesterday, correct?
Did I hear his testimony?
Yes.
Yes, I was here.
Yeah. And you heard Mr. Tremaine's testimony that he knew to dispatch the paparazzi to the courthouse on May 27th, right?
I heard him say that he knew that, yes.
Yeah, and that he dispatched paparazzi to the courthouse to capture a picture of an alleged bruise on the right side of your face. Do you remember him saying that?
Yep. I remember him saying that.
That information must have come from your team, right, Ms. Heard?
Absolutely not. Why would I want that? What actual survivor of domestic violence?
Oh,
wants
please,
that?
stop.
Now, the video of Mr.
She's riling her up. It's a strategy. She's riling her up.
Correct?
Yes, I did.
And you acknowledge that the video was released online the day before you were deposed in connection with your divorce from Mr. Depp in August of 2016, right?
I believe it was, yes.
But you testified that you had absolutely nothing to do with the video's release, right?
Absolutely not.
And you testified that you learned about it when you landed after flying into LA. Do you remember that testimony?
Upon touchdown is when I was alerted to the video's
You
existence
heard Mr.
online.
Tremaine testify that this
It's a
was not the
strategy.
video
She's
of
doing it on
yesterday,
purpose.
Didn't you?
She's getting a rise out of her.
And you heard Mr. Tremaine testify at TMZ.
She knows how she
that you
operates
found the
now.
video the same day you landed.
That's why she's so
at LAX.
effective.
Yes?
I don't know if that, I don't know. if
See,
that's
she
what
gets
his
flustered.
testimony
She
was.
doesn't know what to
You heard
do.
Mr. Tremaine testify that the cabinet video
Go
was posted
Ace.
15 minutes after TMZ received it. Yes?
That's what I heard him say.
And that this could only have been possible if the video was received directly from the source. Yes?
I heard him say that. I don't know if that's true or if that's possible because it didn't come from me. I was
Mr.
flying.
Tremaine
So
testified.
I know that's incorrect is what I mean to say.
Another liar on the stand.
I just know that that's incorrect.
And you heard Mr. Tremaine testify that TMZ owns the copyright to the cabinet video, right?
That's news to me.
The cabinet video you filmed of your then husband. Yes?
The copyright ownership of that is news to me. I learned that yesterday.
It's the cabinet video that you captured of your then husband. Yes?
That is correct. I did capture that video. And yes, that was my husband.
The same cabinet video that was released the night before you were deposed in your divorce. Yes?
That's correct.
You must have also heard Mr. Tremaine testify that the version of the cabinet video that TMZ received was incomplete compared to the video the jury saw in this trial. Did you hear that?
The video that that you have seen is complete.
Right. But the one TMZ got the day before your deposition in divorce was incomplete.
I don't know, I
haven't
haven't seen it.
He testified that the beginning portion of the video where he set up the camera, that wasn't included in the video that TMZ received.
I don't know what video TMZ.
I'm talking
received.
about Mr. Tremaine's testimony.
Let's just focus on Mr. Tremaine's testimony.
No, I'm asking you if you recall hearing him say those words to this jury.
Yes, I heard his testimony. We all did.
And he testified at the end of the video where you can see
She's good, man.
smirking.
She's
I know
good.
you testified earlier
She really is
on
good.
Smirking in this trial, but you sure were caught on camera smirking in that video.
I disagree with
Not also not included in the TMZ video.
Everyone can watch that video and you can determine whether you think it's funny to me or not.
Mm-hmm.
That's because the video came from you, right, Ms. Heard?
No, it did not.
You
That
edited
video
out
did
the
not come
portions.
to me.
Ms.
I mean,
Heard,
come from me.
Ms. Heard, you edited out the portions that made you look bad before sending it to TMZ.
You're very wrong about that.
So
If
that
I
only
wanted to
Mr.
leak
Depp
information, I
looked
could have
bad.
done it in a more effective way, a lot sooner and a lot more.
Because
I
you
was
knew exactly
living
how to
a
do that,
mountain
right?
of this evidence. If I wanted to leak it, I could have done a lot more with it.
But you testified earlier in this trial.
See?
that You didn't know how to.
She's riling her up for a reason. She's combative. Look.
You edited that video before you gave it to TMZ so that only Mr. Depp would look bad. Yes?
That's absurd.
Right in the middle of your divorce proceedings.
Again, you're very wrong.
Okay.
I'd like to show you a picture from that's already admitted into evidence. It's Defendant's Exhibit 799.
This is why they saved the time. Breaking her down just like the first time.
This is you at the courthouse on May 27th, 2016, when you got your domestic violence restraining order against Mr. Depp, right?
It is.
And next to you is a woman named Jody Gottlieb, right?
Yes.
Jody Gottlieb is your publicist.
And dear friend.
Now I'd like to show you what's been marked as Plaintiff's Exhibit 1316. This is a picture of you and your friend Rocky Pennington, right?
That's
That's
correct.
correct.
Your Honor, I'd like to move to admit this photograph.
Any objection to 1316?
No, Your Honor.
All right, 1316 evidence was published to jury.
Yeah, no, they saved
This
it.
is a picture of you on May 28th.
She does not like Camille, so Camille knows how to work
I know
her.
when this was taken.
This is the day after you obtained the domestic violence restraining order against Mr. Depp, right?
I have no idea when this
Mhm.
image was taken.
Suddenly she doesn't
There's
remember.
no bruise on your face in this picture, is there?
Again, I don't know when this was taken, and also I'm outside. I was obviously wearing makeup. I
Oh,
don't know when
uh-huh,
this was
yeah.
taken, so I
The
have
day
no
after?
idea if I can
Let's
speak
Right.
to
refresh your
what
recollection.
bruise you can see
Let's
or not.
refresh your recollection about when this picture was taken. Can we please pull up Plaintiff's Exhibit 1315, just for the witness?
Let's refresh
This is an
her
article
recollection,
dated
shall
May
we?
30th, 2016, right, Ms. Heard?
That's what it says, yes.
And this article contains the same photograph of you and Ms. Pennington we were just looking at, yes?
Yes, I see that.
And the article is entitled Amber Heard Smiles as She Puts Arm Around Friend One Day After Getting Restraining Order Against Johnny Depp. Is that what the title says?
I know that's what the title says, yes.
Your Honor, I'm going to move to admit and publish the article with everything but the headline and date and the photo redacted.
Objection, Your Honor, that's inconsistent from the way you treated all of these.
I'll just take the objection. All right, next question.
Let's take a look at picture Plaintiff's Exhibit 1317. This is also a picture of you and Ms. Pennington on May 28th, 2016, isn't it?
I don't know when this photo was taken, but it looks like the same outing as the picture prior.
Your Honor, I'm going to move to admit and publish Plaintiff's Exhibit 1317.
Any objection?
No, Your
All
Honor.
right, 1317 into evidence.
There's no bruise on your face in this picture either, right?
I disagree. If it is taken when you represent it was taken, then obviously there's a bruise on my face. It's covered by makeup. as per usual.
Right. Okay.
Zoom out of that picture for a moment, please. Thanks. That's Josh Drew in this picture, right?
Yes, that's correct.
And Ms. Pennington
That is correct.
in there too?
That
Ms.
is correct.
Pennington submitted a sworn statement on your behalf in support of your domestic violence restraining order, didn't she?
I believe she did, yes.
Mr. Drew also submitted a statement in support of your domestic violence restraining order.
I believe they both did, yes. Mhm.
Mr. I'd like to show you Defendant's Exhibit 512, which is already in evidence.
They wanted her back up on the stand.
You've seen
This is the last impression
have.
the jury has of her.
On
The last
second day of your
impression.
direct testimony, you testified that this was taken in the downstairs of the main apartment. On
The jury
December
trusts
15th,
Camille.
2015. Do you recall that testimony?
Yes, I believe so.
So it's your testimony that Defendant's Exhibit 512 reflects damage to Penthouse 5 that occurred during the December 15th, 2015 incident. Yes?
I'm not quite sure.
Now
from
she
what
doesn't
incident
remember.
this
She
is
doesn't
when I see
recall.
this photo
I'm not quite
in the
sure.
document
I don't
context.
know.
Let's give you that context. Can we please, we could have day 16 trial testimony?
Day 16 was, I think, her original testimony when Camille crossed her.
All right.
You guys wanted her back up on the stand. I mean, Camille's good at her job. They wanted her back up there. Yeah. GC, why isn't she laughing now? I'm telling you, that was a really bad look yesterday. She doesn't realize what she did to her
Could you
case
please
yesterday.
turn first to page 4585?
Really bad. That she should not have done that. I said it several times yesterday. You don't go to court on the day before it ends with that kind of arrogance. You do not do that. It doesn't matter that the jury is not seeing the social media clips. It's they're looking at her face. She's laughing and smirking and doing all these things. I mean, think about what they're thinking.
Starting on line 16, where it says, let's talk about December 15th, 2015.
You said 458. I'm on 4485. Sorry, you said 4584.
4585.
Pardon.
Line 16.
She can't talk. She's flustered. Every time she gets caught in something, now they're pulling her transcript from her original testimony. It's an example of how she lies.
Line 16, where it says, let's talk about December 15th, 2015. See that?
Yes.
And then do you see that your testimony about December 15th, 2015 follows?
Let's see. It's just the first line or two. Yes.
Okay. Now I'd like you to turn to page 4603. Starting at line 12.
46 there,
4603.
line 12. I mean, the bottom line is there's nothing funny
Starting at line
about
12
this. It's
and going
just
on to page
you can't
4604
set
line
somebody up, blow their life up, and then turn around and walk away with a snicker. That's why I was saying yesterday was
And do
imperative.
you
She
see
should have
that you
not had the
testified that
demeanor
Defendant's
she had
Exhibit
yesterday.
512, which is on the screen,
Yes,
is a picture of the downstairs of the main apartment.
that's correct.
And the main apartment is Penthouse 5 in the Eastern Columbia building, right?
No, depends on what, the main apartment's penthouse 3 generally when we say main apartment.
Penthouse 5 was
where you had your closet?
The downstairs was kind of like had some of my painting studio set up and a reception area. Upstairs was the closet. Mezzanine office was in between.
All right, so it's your testimony that defendant's exhibit 512 reflects damage to the penthouse 5, that occurred during the December 15th, 2015 incident, right?
I'm just not sure from which incident this is a picture of, since I'm only looking at
Even
a
though your
partial
counsel
floor.
was asking you questions about December 15th, 2015, and then admitted this picture into evidence
Again,
in relation to that incident.
Sorry, go ahead.
In relation to that incident on December 15th, 2015. This exhibit, defendant's exhibit, you are the defendant, number 512, was admitted into evidence in this court. You testified that this was the result of damage that occurred on December 15th, 2015. Yes or no?
I just need to orient myself because I'm just looking at a picture of a partial
No,
picture of a
Ms. Heard, you
floor.
didn't just
So
look
I
at a
can't.
picture. You looked at your testimony.
You pointed me towards the page and then asked me a question. I haven't actually reviewed it. I don't know if this was submitted in relation to that incident.
Let's actually leave up defendant's 512 and please pull up defendant's exhibit 725.
I told you, Amber, you are
Preserving
fucked.
evidence in redacted form, Your Honor.
That they wanted to put her back up on the stand. It was a bad idea. It was a bad idea because she can't.
You've seen this photograph as well, right?
I have.
On the third day of your direct testimony, you testified that this photograph reflected spilled wine in Penthouse 5 on May 21st, 2016, didn't you?
Again, I don't know because I'm looking at a partial picture of a floor. So unless she removed the metadata you've covered up, we could then tell. If you
I didn't cover it up, Your Honor.
Could we unredact
Your Honor
them so
did.
we could get context?
That's how it's in evidence.
That's how it's in evidence.
Next
Well,
question.
the metadata next to it is so that
Ms.
to
Heard,
avoid this
Ms.
sort of
Heard, there is
confusion.
no question pending, and I would appreciate it if you wouldn't be making arguments to the jury.
Sorry, I thought you would ask me about it.
I didn't ask you about anything. Let's look at your direct testimony from the third day.
Yes, ma'am.
She's so good, man. She really is good. Yeah. Well, oh, it's days before, so now I don't remember what I said. Then she's arguing that the picture, now she's going to say it's somebody else's fault when they submitted the picture, the
Let's
redacted
turn to
picture.
page 4750.
They gave the picture.
In day 17 transcript.
Sorry, can you repeat that?
4750.
They put her up there. And let me guess, in private, she said, put me back on the stand. Johnny went back on the stand. I want to go back on the stand. I want to do exactly what Johnny does.
Specifically line
It's
16.
just sad, man. It's sad.
Do you see where Ms. Bredehoff asked you to describe for the jury what took place on May 21st, 2016?
I see that.
And do you see that your testimony is reflected about May 21, 2015?
Yes.
That follows?
Yes.
Now let's turn to page 4804. At line 14. 4804. Starting at line 14
Yes.
through 4805, line 4.
Man, she's
Going to what line?
Line 4 at 4805. Do you see that you're testifying that the defendant's exhibit 725, which is reflected on the right side, reflects spilled wine on the floor in Penthouse 5?
That's correct.
And defendant's exhibit 512 and 725 seem to be different versions of the same picture, don't they?
That's correct.
So which is it? Which one was taken on December 15th, 2015, or May 21st, 2016?
If you remove the redacted metadata, you can find out. It's right there.
Or if you're telling the truth, you would know.
Recognize a portion of a spilled wine on a floor, and I'm supposed to know off the top of my head when you've
No.
lived through 5 years of this stuff? I don't think so. That's not how that works.
Go ahead. Keep snapping. Look at her eyes.
Ms. Heard, at the beginning of your cross-examination
Your
last
Honor, may we
week.
approach?
Yes.
You wanted to put her up there. You thought she could handle it. Now you're going to cry and say, oh, she's being too hard on the witness. No, it doesn't work that way. You wanted her up there. She was going to be subject to cross. You know, all they're doing is repeating her testimony at when she first got up there initially on the stand. If she can't handle that, they should not have put her up back on the stand. This is her last impression on the jury, and it has not been good. If you're telling the truth, you would know. You can't intercept and say, I object, Your Honor. Can we approach? You know, what are they going to say? Oh, no, she's being too hard on her. All she's doing is going over previous testimony that she said under oath, and it's an example of how much she lies. That's all this is. It's not rocket
Ladies and gentlemen in
science.
the gallery, I would ask that there be no words or no phrases, no words, no sounds at all coming from you. If I hear one more sound, I will clear the gallery and we will continue this testimony without anybody in the courtroom. Understood? Good. All right, your next question.
Ms. Heard, at the beginning of your cross-examination last week, I showed you an audio where you told Mr. Depp to tell the
So the
jury,
gallery has been warned.
tell the judge, tell the world that he is a victim of domestic abuse. Do you remember that?
That's correct.
And you testified you found
Be
it hard to
adults, people
believe
back
that
there.
Mr. Depp
Be
would tell the
adults.
world that he's a victim of domestic abuse, didn't you?
I said I find it hard to believe that he would do that, knowing that he himself had beat me up for 5 years.
But he has told the world that he's your victim of domestic abuse, hasn't he?
Well, he started to say that only recently. He didn't make that claim up until very recently. So when we signed our divorce agreement and we signed a statement saying that neither party had ever said false claims for financial gain, it was relevant and important to me because I was the only one making the accusations. I was the only one making those claims. He wasn't doing that at the time, and he signed his name to it.
You didn't expect
So it's his
people
fault.
to show up and testify on his behalf. That did you?
Incorrect.
When you told this jury under oath that you never assaulted, when you told this jury under oath that you punched Mr. Depp because you thought of Mr. Depp pushing Kate Moss down the stairs, you didn't expect Ms. Moss to agree to testify that never happened, did you?
Incorrect. I know how many people will come out of the woodwork to be in support of Johnny.
So you
It's
think
clear
Ms.
by this
Moss
courtroom
needs
how
to
many
come
people
out
will
of the
do that.
woodwork to testify for Mr. Depp?
Everybody who was around in the 90s and the early aughts knew that rumor. I had heard that rumor from multiple people. Of course, that's what flashed through my head when my violent husband not only swung for me, but all of a sudden swung for my sister. Of course I thought of that. I did not expect her to show up or not expect her to show up. It didn't
She's
matter.
look at
It
she.
doesn't change
It's
what I
you can
believed at the
see.
time when we were on the stairs and I thought he was going to kill my
You can
sister
see.
for pushing her down the stairs.
You told this jury under oath that Mr. Depp was aggressive and trashed the trailer in Hicksville. You didn't expect the manager of the Hicksville property, Morgan Knight, to come forward and testify that wasn't true, did you?
Incorrect. I've already been through trials with this man. I know how many people will come out and support him.
Okay. Okay.
You told this jury
His fault.
under oath that you had no idea that the paparazzi would be at the courthouse on May 27th, 2016. You didn't expect a TMZ employee to show up to testify that TMZ had been alerted that you would be at the courthouse and knew exactly which side of your face to take a picture of, did you?
I know how many people will come out and say whatever.
It's always everyone else's fault.
That's why I wrote the op-ed. I was speaking to that from
Okay.
on. How many people will come out in support of him and will fall to his power?
Okay.
He's a very powerful man.
Right.
And people love currying favor with powerful
Okay.
men. And I know that
and
firsthand. I've
received
lived
jail
it.
time for committing perjury.
Excuse me? I didn't hear your question.
You didn't hear
Excuse
my
me?
question?
Ms. Vasquez, if you do mind,
Curry.
please just repeat the question. I didn't hear you.
Curry favor and commit perjury in this courtroom
I have
for
seen
a
people
powerful
do this.
man?
I have seen people do this time and time again. That's why I wrote the op-ed.
You didn't expect Ben King, the house manager in Australia, to show up from England. He flew from England to testify that Mr. Depp's fingertip was found exactly where he said it would be. Did you?
I have never heard Johnny testify to knowing where his finger was, or really, frankly, making a claim that he knew where it was when it was found. I've never heard Johnny claim that.
You didn't expect
Johnny
Keenan
doesn't-
Wyatt.
Johnny has never
Ms.
actually
Heard.
said that.
Ms. Heard.
And
I think the
Ben
jury
King,
can,
yes.
Ms. Heard, there's no question pending. You didn't expect Keenan White, Mr. Depp's longtime sound technician, to show up and testify that Mr. Depp is not being fed lines through his earpieces, but instead music, did you?
Not that it matters much, but of course I did. I know how his employees treat him.
So you
I know how
probably-
his team treats him. Of course I expected that.
Okay, so you probably expected Isaac Baruch to come and testify for Mr. Depp, right?
I'm not sure I thought about that.
Yeah. But you didn't expect Mr. Baruch to weep for Mr. Depp after what you've put him through and so many others with your life.
I
did you?
relate to Isaac because he and I are
There's
the
no
only
further
ones who
questions, Your
cried
Honor.
on this stand.
Nothing further.
All right, correct, redirect.
Thank you, Your Honor. Ms. Hurd, if Mr. Baruch felt misled, who misled him?
Johnny, and I don't blame him. I don't blame him for crying. This is horrible.
Ms. Vasquez has suggested that you faked bruises on your face. Is that true?
Absolutely not. I didn't need to.
Did you ever fake an injury caused by Mr. Depp?
No.
Is any of the evidence of your injuries that has been put to the jury in this trial fake?
No, absolutely not.
And to the extent that there may be some confusion over when a picture of spilled wine was taken, why might that be?
Objection.
There's
Lack of
so
foundation.
Because there's so many incidents of violence. There's so many pictures. There's so much evidence. Most people don't have this kind of evidence for years, 5 years. And when I was saying that to Johnny on the phone in that recording, I was saying for years this has been going on. And I have pictures, we have texts, we have everything. Normally you don't get this.
Yeah, and we have the audios of you like admitting for hitting him, and
challenge this in this way.
it's insane.
It's crazy. It's easy to not know.
You
the
hear him
context
so
of
many
it,
times in the
but
audio
pictures
saying,
still
"Come on,
line,
Amber.
because there
Stop.
are so many.
Come on,
more
Amber,
important
stop."
Details, pictures, and also so much I didn't photograph, so much I didn't have the presence.
Oh,
Objection, non-responsive.
Thank you.
I'll sustain the objection. Next question.
Did Mr. Depp abuse you physically,
Yes,
verbally,
yes,
emotionally,
yes,
psychologically?
yes.
She's looking at juror
How did the threats
9
that Mr. Depp made against you
in the front
individually years
5.
ago
She's looking at the female
resemble what
5
you've
in the
endured
mid
as a
30s
result of the Depp
and the
Waldman
early
statements?
40s.
Beyond the scope of cross, Your Honor.
Overruled.
Johnny promised me he would
Again, words.
that he'd ruin my career. he'd
Again,
take my life
words.
from me. Death was the only way out, and if I got out, this is what he'd do to me. He'd make me think of him every single day. He promised me global humiliation. You saw those texts. What he couldn't do, the work of one individual, meaning Johnny, when he was inviting a disgruntled employee over for a spot of purple to fix my flabby ass up, that revenge that he sought back then was just what he could do as an individual, calling the studio to get me fired, trying to block him.
Objection, Your Honor. Lack of foundation, speculation,
It's
hearsay,
all in
non-responsive.
I'll sustain as to non-response.
Ms. Hurd, how did those things that you just testified to that Mr. Depp did, how did those resemble what happened to you after the Depp-Waldman counterclaim statements were made?
Those are
Objection, Your
just
Honor. Lack of foundation.
She's,
overruled.
thank you, Your Honor.
Those are just an echo of what I'm living through today. It's like what I'm living in.
You shouldn't have lied. You shouldn't have lied.
This courtroom and the other
You shouldn't have
courtrooms
lied.
dragged me into to do the same
You shouldn't
thing
have
again.
lied.
That's just an echo of the violence.
You should
and
not
the
have
abuse
lied.
that I suffered within our relationship. The campaigns to have me fired, that blocking
That's
me
why I
to
wrote
check,
the
ruin my
op-ed.
career,
She's done.
The threats he's made to
That's why I
humiliate me
wrote
globally
malice. That's
are
why
being
I
lived
wrote
out
the
in real
op-ed.
time in front
No
of you,
tears
ladies and gentlemen, for
whatsoever.
the past 6 weeks, and for the whole world since our camera's here.
No further questions. Thank you so much, Amber.
Uh-huh.
Sir, you can have a seat next to your attorneys.
Is she going to play scared of him now when she walks by the table?
If I can have the attorneys approach.
She doesn't seem scared to walk by Johnny right now. Dude, they wanted her up there. I'm dying to know what Emily's thinking. I'm dying to know what Emily's thinking. That's why I wrote the op-ed, malice. She goes up there and she gives an impression, and then she wants everybody to be, look at, there's her snicker. Look, watch. I'm gonna show you this real quick. Hold on, I gotta retweet it first. This was her, look at. She wants to go up there, right? And cry or whatever. But yet, real quick. Hold on. She wants to go up there and look sad or whatever the hell. So much breath. But yet she looked, let me refresh this real quick. She looked like I just retweeted it. Where's my retweets? How do I find my retweet? Ooh, the behavioral panel. Wait, how do you find your retweets? Oh, wait. Tweets and replies. Here we go. Hold on. Do I have it? Who just... Oh, Geller. Hold on. Let me go to Geller's. Hold on one second. Let me go to Geller's. I'll show you right now what I'm talking about. Since obviously I can't get the hang of this thing. Twitter's popping off right now. Did she really just say Isaac?
All right. Your next witness?
Hold on.
Your Honor,
I'll show you in a minute.
counterclaimant Amber Heard rests.
All right.
Thank you.
ma'am. All right, ladies and gentlemen, you have heard all the evidence you're going to hear in this matter. What I propose doing is to go ahead and give you the rest of the afternoon off so you can have a good restful afternoon and evening, and we will do closing arguments tomorrow morning at 9 a.m. and then the case will be submitted to you for deliberations. Just to give you a little logistics of how that will go, tomorrow I won't give you a time limit as far as how long you can deliberate in the afternoon into the evening. I will tell you, within reason, I will tell you I do not serve dinner, so keep that in mind, okay? You will not be deliberating on Saturday or Sunday or Monday, because Monday is a holiday. I would like to have you back here Tuesday morning, at least by 9 o'clock. If you want to come earlier, that's up to you. You can decide as a group if you want to come earlier than 9 o'clock, but you have to be here at least by 9 o'clock just to resume your deliberations again. And again on Tuesday night, and if you have to go to Wednesday or Thursday, that the time that when you take your breaks is up to you, as long as you take them together, as far as not having any deliberations unless all of the jurors are in the room at the same time. When you take your lunch is up to you. And then again in the evening, within reason, I'll let you go as long as you'd like to go. Okay? So have a good evening, and we'll see you tomorrow morning. Okay? Do not discuss the case with anybody. Don't do any outside research.
Now what? Okay, let's hear what's happening for court. Closing arguments, though. We're back tomorrow to see closing arguments.
All right. We'll go ahead and take a modified lunch recess just till 12:50. We'll come back at 12:50. We just have a few jury instructions left we have to do. Make sure we get the verdict form taken care of. I want you to review the laptop that we have mocked up and make sure everybody agrees what's on it. And also I want you to look through all your exhibits and make sure we're all on the same page. Before you leave, I'll make sure you have copies of the jury instructions in the order that I'm going to read them, and you should be able to prepare for your closing arguments for tomorrow, okay? All right, we'll see you at 12:50 then.
All right, you guys, let's go to Emily's stream. Let's go to Emily's stream real quick. I need to see what she's saying. You guys know I rely on Emily. Let me see. Oh my gosh, my mouse does not want to move, of course, right now. Stop it. What, did I lose it? My mouse does not want to move. Here we go. Sometimes I have to put it on the lacquer desk. What happened? Hold on 1 second. I was trying to... Give me 1 second, y'all. I was looking for... Oh my God, this is This is irritating me. God, I can't wait to get my new computer, y'all. I'm gonna be so happy. I was looking at it yesterday. I want to open up a new tab, but I want to find Emily's stream first. And then I'm going to have to back it up because I don't know what Joe, I know she doesn't really start talking about anything until everybody leaves the courtroom, so I'm not quite worried about that. The umbrella guy. Here's Emily's right here. All right. Let's open up a link for her stream. And let's see what she's saying when they walked out. I need to understand anyway with this break. I don't know when to, I'm trying to figure out like schedule. I don't know how the deliberation process works. I mean, obviously we'll be here tomorrow for closing arguments, so that's not a big deal, but as far as like waiting and knowing when the verdict is announced and all that, that's something I need to learn from the attorneys. So this is our daily
Franco's textemily.com from your mobile device will get you there. If you
All right, let's just hold on 1 second. Let's hear what she's saying about Camille's cross. Come on. Are we that far? 10 minutes, 10 minutes, 10 minutes. Boom, boom, boom. Boom, boom. Okay, here we go right here. All right. So let's see what she's saying. We're behind on her stream, but it's okay.
Timing. I think this is the end of evidence. I think we have reached the end of evidence. But it seemed like Amber Heard wanted to give her own closing argument. I want to know what happened in the gallery to get the judge to admonish the gallery so strongly. The gallery has to be mindful because their reactions can impact the jury. So it's just there are a lot of people in the gallery. We know from those that have been there in person that it's largely Johnny Depp fans, and it would be very difficult if one of those fans in the gallery did something or said something that impacted this jury in a way that could upset this case after 6 weeks and likely tens of millions of dollars of litigation. That would be wild. So thank you. Grant, no need to be conflicted. I think Amber Heard absolutely feels the pain of a global kind of hate campaign. Whether that was orchestrated by Johnny Depp or not is for the jury to decide. But there's no denying that that is in fact going on online. What it's caused by is really the question here. But I've always said throughout this trial, the parts of Amber Heard's testimony that rang the most true to me is when she is talking about her career, when she is talking about the negative impacts of her career, and when she's talking about her reputation online. Whether that's attributable to the statements she's suing over is the big question. But I absolutely believe that we've seen it throughout this trial, how she's been talked about on social media. We've seen the weight of public opinion against her. So
yeah, but but the thing is though that she didn't.
She feels angry and hurt.
Maybe she did, but she started it. He said
because of that
she started
is what
it.
the jury is going to have to decide. Is the judge going to say we've come to the close of evidence, ladies and gentlemen? Did she just close her laptop?
Witness, Your Honor, the counterclaimant Amber Heard rests.
All right.
Okay.
Thank you, ma'am. All right, ladies and gentlemen, you have heard all
Oh,
the evidence you're going to hear
okay.
in
I
this
thought
matter.
we've already heard
What
this.
I propose doing is to
We're
go ahead
behind.
and give you the rest of the afternoon off so you can have a
Thanks,
good
Judge A.
restful afternoon and evening, and we will do closing arguments.
So now I just need to hear
tomorrow
how do we
morning at
move
9
forward?
a.m.,
Like
and then the case will be submitted
we already
to you
saw
for
this.
deliberations. Just to give you a little logistics of how that will go. Tomorrow, I won't give you.
We don't need to hear that.
Legally court shit. So let's talk about that. The court's going to ask about jury instructions. I want to know if they are done yet, and then I'm going to answer questions.
Hey, my first buffer of the entire day. Are you guys proud? I know I am. My first buffer.
We are done.
We'll go ahead and take a modified
That's a
lunch
funny-
recess just till 12:50.
funny
We'll
face.
come back at 12:50. We just have a few jury instructions left we have to do. Make sure we get the verdict form taken care of. I want you to review the laptop.
I just want to hear what she has to say moving forward so I understand how to move, because I'm a new streamer, so and I've never done court before, so I don't. That's why I rely so much on LawTube and why I kind of pop into Emily's stream, because the thing is for me, like, to pretend as I was a juror, it's not that I don't like Amber Heard, with such a giant whatever, I understand the effect of the public, but at the same time you have to understand she started this. She started it. So,
To make
like,
sure
for her
everybody
not to
agrees
act
what's on
naive
it.
and not
And
understand
also
the
I want you to look through
power
all your
of the
instructions to
internet,
make sure
that's
we're all on
kind
the
of
same
not
page.
the
Before you
jury's
leave, I'll
fault.
make sure
It's
you
not
have
the
copies
jury's
of the jury instructions
responsibility.
in the order that I'm going to read them, and you should be
The
able to
jury
prepare
had
for your
if
closing
there's young
arguments for
people on the
tomorrow,
jury,
okay?
they know.
All right, we'll see you at 12:50 then.
Maybe the
So
old
that will
schoolers won't
likely
know.
not be televised. They've not televised these types of court proceedings before, though the gallery and the public are allowed to be in there. They do not televise those parts of Law in Motion, which is the only thing I'm frustrated about not being there in court for, because I would love to hear that happening in court. Of course, when they do it up at the sidebar, you don't hear it.
Wait a minute. Wait, what was she just saying?
Televised. They've not televised these types of
Wait,
court proceedings
what?
before.
I missed that.
Though
Hold
the
on.
gallery and the public are allowed to.
What is not televised? I missed it. Sorry, I was talking. Sorry. Wait a minute. I missed what is not televised?
Okay, do not discuss the case with anybody. Don't do any outside research.
I went back too far.
Wow. And with that, we are at the end.
Wait.
All that's left is closing arguments, jury instructions, and for this to go to the jury. The court's going to likely do some legally court shit. So let's talk about that.
What was not?
Give
me a second.
The court's going to ask about jury instructions. I want to know if they are done yet, and then I'm going to answer questions. We are done.
We'll go ahead and take a modified lunch recess just till 12:50. We'll come back at 12:50. We just have a few jury instructions left we have to do. Make sure we get the verdict form taken care of. I want you to review the laptop that we have mocked up and make sure everybody agrees what's on it. And also I want you to look through all your exhibits and make sure we're all on the same page. Before you leave, I'll make sure you have copies of the jury instructions in the order that I'm going to read them, and you should be able to prepare for your closing arguments for tomorrow, okay? All right, we'll see you at 12:50 then.
Okay.
So that will likely not be televised. They've not televised these types of court proceedings before.
The jury form and all that. That's what she's talking about.
Televise those parts of Law in Motion.
Okay, I understand.
The only thing I'm frustrated about not being there in court.
That makes sense.
Because I would love to hear that happening in court. Of course, when they do it up at the sidebar, you don't hear it. Wow. Wow. All right. We're going to get to questions tomorrow morning at 9 a.m. We are going to start with closing argument. I will be interested to see tomorrow what jury instructions are coming in. The court will read the jury instructions out loud. So you will see from the court all of the jury instructions. She will either do that before the attorneys argue or after.
Okay.
So we could start off right at 9 a.m. with reading in the jury instructions. Or
1 second, E.
I hope that she does the jury instructions first. I think it gives you a powerful leg to do your closing on.
Okay.
And I also think it gives the attorneys the weight to say this instruction, that instruction you've heard the judge say. And then closing is fresh in the jury's mind when they go back to deliberate. Only 2 hours each side. So 4 hours total tomorrow of closing. That might be split up by the lunch break, depending on when jury.
Okay. Or the first break, maybe. Well, no, that would be lunch. It would be 2 hours, probably 2 hours break. So I don't know. I'm waiting for her to tell us what I know I'm buffering, but I'm waiting for her to tell us which side is going on first, if she knows. And then because
instructions are read.
To me, it would make sense
then
before
this
lunch.
case will go to the jury, and the court said you can deliberate as long as you like until it's time to break for dinner. So if they want to go to 7 o'clock tomorrow, they can. Will we be on verdict watch tomorrow? Yes, we will. Do I have like a storm watch? I need like a storm watch logo. Verdict watch.
You guys keep.
But they then have a 3-day holiday. Will I be flabbergasted if this jury reaches a verdict tomorrow? Could that happen? Yep. And if that happens, we will see all of it together in Virginia. The verdict forms will include the damages portion. So they will get to decide liability if somebody defames somebody, and then they will get to decide how much. and we will see on closing how
Gotcha.
much they ask for. Each side should be asking for their
Okay.
damages
Okay.
and asking for what they want. I don't think we're going to hear Heard's team argue with a straight face $100 million. I don't think that's going to happen.
Yeah,
I
no,
wonder
it's
if
not.
Depp's team
It's
will
not.
ask for, you know, his damages are $7 million that she took in the divorce and didn't donate. Or if they're going to say what he's looking for is his name cleared liability, give him $1, we don't even care.
Yeah.
And that will be very, very interesting to see.
Yeah.
So with the 211,000 of you in here, I will just remind
Wow.
you, if you want to stay in the loop with what I am doing, and if you
So
want
I
me
will
to
be
alert you
following
when I go
Emily, you
live,
guys.
if there is not a verdict tomorrow, I will go live for Verdict Watch, and when we have word that a verdict will be
Okay,
read.
so
Join the text crew. North America, don't have to pay. Like Phil DeFranco's, textemily.com from your mobile device. We'll get you there.
okay.
If you are not in North America, where your cell phone might not allow you to be part of the text crew, just follow me on social. I will be sharing on
So
my
make sure you
Instagram
guys
stories
are on
and
Twitter.
whichever platform you prefer, at
Yeah.
the Emily D. Baker.
Yeah.
When it is time to go live, and if you like and subscribe to this channel, sometimes sometimes YouTube chooses to notify you. Sometimes it's a
Well,
mystery.
how?
So we will see. I'm glad we still have a court feed right now.
But how do we find out
That's
when
absolutely fantastic.
when the verdict is in?
Wow,
That's the thing.
wow. I'm gonna get to questions. I'm gonna see if we have anyone
wanna
else
be
who can join
online
us. It
then, and I
depends
don't
if
know
they are
how.
outside of the presence of the jury and being mindful about what happened in court today. I
just really
want
want to hear her
what
talk about
happened with the
about
with
her,
the
Amber.
audience. And so
I don't want to watch her stream
we're
necessarily,
going
but I
to see
always
if
want to
we
know their
can bring somebody in who
afterthoughts.
is in court today. All right. Let
Okay.
me
Just thoughts.
close this out and get to a few questions.
Okay. Oh crap.
She said she wrote the op-ed because she knew people would run to defend him because he's powerful. I thought it wasn't about him. She said in her cross-examination with Camille last time that the op-ed was about him and others, but yes, she seemed to say more clearly, this is why I wrote the op-ed, because of my experience with him. I think we've already gotten to the fact that this op-ed
is about him.
Johnny
Yeah.
Depp. I think after the ACLU
Yeah.
testimony, that, you know, the shit's out of the horse on that
Yeah,
one.
yeah.
There's no pulling it back.
I agree.
What is going
I agree.
to matter is if she thought it was false when she
Okay.
wrote the op-ed. It's all going to come down, for me, for willfulness on the defamation. And
Yeah.
I said I would bring up that jury instruction, so I'm going to get that ready. If
Okay.
we get Runkle in here, then we will put a pause on that
Okay.
and talk about court. I'm going to try to get to a few questions. Thank you for the
I just
super
want to
chats.
know.
I am trying to get
I
to as
want to
many
know
of them
her
as I
thoughts
can.
on the
If you put a question mark
the
or a Q at the front, I can know it's a question
on
and make sure
the
you answer it.
on her.
Johnny Depp has the right to defend himself as well against defamation. Where is the
Okay,
evidence?
I'm gonna stop that, you guys, because I don't want to run her stream while I'm running mine. I think that's kind of not good. And we're done for the day, right? Are we done for the day? I think we're done for the day, right? So I can log out of this. I feel like I don't know if we should, if I should. We're done for the day, right? Are they signing off? I don't want to sign out if I don't. If I know we're done. Are we done for the day? That's the only thing is I'm kind of lost as to where we are at the moment. I know that closing arguments are tomorrow at 9, which of course I'll be here streaming. When Amber says I never lied, number 6 and 7 visually snarl in her direction. Uh-oh. Let's see. Have they finished for the day? Yes. Did I hear that right? The jury have until Wednesday to reach a verdict. I just want to know how we're going to be informed. That's my I mean, as a streamer, I want to know how I'm going to be informed in order to be online, to be, logged in with everybody else so I don't miss it. I actually got a headache. I know, man. I feel the same way. But they wanted her on the stand and you get that last impression, And to me his was bad, but not as bad as hers. I think hers was bad. I think hers was worse. And I think they touched on the points that they needed to touch on. That's the thing about not being able to, kind of be in tune with LawTube at the same time, because I'm not an attorney. So for me, I'm more leaning on what the attorneys are seeing and interpreting from the cross, from her last impression on the jury, from, where are they now? And since I haven't had any feedback from, like, my brother hasn't popped in to say anything about it in his thoughts, or my son hasn't had a chance to come on and talk to me about his, you know, where he stands with it. It's kind of difficult to figure out. I mean, all I can do is tell you my personal opinion, right? Of like what I'm feeling. And I mean, because at the end of the day, it's about defamation, right? At the end of the day, it's about defamation. So, like she said, you have to keep that in mind. Was he guilty of the things she accused him of? Um, was there malice involved, right? Because it's per se, and and damages and defamation. I mean, did the op-ed defame his name? And I think the jury has a really hard task in terms of, I mean, for me, if I was a jury member, if I was called to be a jury member on this case, I would think, I mean, if I was invested, okay, because remember, they're not supposed to be watching anything outside of this, right? So they don't know all the stuff that's been surfacing out in, so in the interwebs, if that makes sense. So um whether what platform you're on, or they don't know, or they're not supposed to know what's going on Twitter, on social, on YouTube, on IG, on any of the platforms, that TikTok, and it's hard because a lot of this stuff has been, you know a lot of people have had a lot to say about this case, so I could understand. But if I was a jury member, Camille's closing would have her cross and her closing would have a big effect on me. Um, Having a fair mind, listening to the audios, because I don't know if they've heard the audios. Obviously, all the evidence that were submitted was overwhelming. So they have access. They're going to have a laptop to hear everything. For me, I would say the audios did it for me. That, in my opinion, the audios really did it for me. Because I didn't know anything about this case. I heard about it. It started airing on YouTube, and I started watching it from day one. And then I started forming my opinions by what I was hearing on the trial, and then looking around on YouTube for more information, and discovering LawTube and all that kind of stuff has been helpful, because I'm more interested in what is the law looking at, in my opinion. So this is not just about my personal opinion about the case. It's about what is the law considering in this case. Like, it doesn't matter what's going around on the interwebs. It doesn't matter. You know what I mean? I know everyone, I stand for Johnny. He's innocent. Amber's this, Amber's that. But you have to think of it in the box of the law. So like what he's suing for is what your focal point has to be on, which is defamation. Defamation per se, and did she do this intentionally to damage his name? Did she accuse him of things that truly happened, or did she accuse him because she was upset about the divorce and didn't get what she wanted? I think, having access to the Depp Dive uh, uh, website, um, hold on. Hold on. 1 second. Give me just 1 second. Okay. So having access to the Depp Dive website, because it's public information and all of the evidence has been submitted on that website that you can actually see. Once you actually start thumbing through that and you listen to the audios, you see the pictures, all the PDFs that have been um, uh, submitted in this case, that's public information now. It changes your mind. It really does. So it actually, I try to stay fair minded, and that was one of the things I liked about Hogue on Legal Bites. you know, and Alita. I mean, I think they're pretty fair. I really like Rob also. I think he's pretty fair-minded when he's expressing to the public about how trials work and how legal proceedings work, because it, you know, you can put your personal opinion in this thing as much as you want. You can be you know, you can be upset at Amber Heard, you can call her names, you can say, you know, you can be in support for Johnny, you can do whatever it is that you want, but when it comes right down to it, whether or not, you know, you feel a personal emotional connection with this case, it's going to fall under, you know, the laws guidelines of defamation, you know what I mean, malice, to intentionally damage each other's names, since there was two suits going on at once, and I think a lot of people got confused with that. They didn't understand that her case and his case were piled on top of each other, and that's what was happening in the process of this entire case. So, you know, I think that's what's important about this whole entire thing, is that when they deliberate, you know, they don't know, or they're not supposed to know, like I said. And that's why the TMZ guy was so effective. That's why the TMZ guy was, hey, you know, you know, she submitted the video. I believe that. I do believe that. I don't believe that Depp's team did it. I mean, they could have, but I don't believe that. I mean, because the facts are there. She sent the video. She sent, you know, a heads up that she was going to be at the courthouse to file a TRO. Suddenly the paparazzi's out there. Nobody's in the fucking courthouse but her. She's expecting them to catch a shot. She makes sure the side of her face is available, you know, and that kind of thing. Like I said, regarding the photos, you know, they gave the jury saw the actual visual motion of one photo going over the other with the altered, you know, image of enhancing the redness on her face, you know. And I don't know. I mean, I just think the jury has a big task, you know, but like I said, with the panel on Legal Bites, one of the attorneys on Legal Bites panel yesterday, her name is Natalie. She just came in to say hi, but she was talking about trials, and she was talking about the jury itself and how juries work. And she was talking about how some jurors tend to reach a point in the process where they make up their mind. They kind of stand one way or the other. And so even when they go into deliberate, it's kind of like the underlying consciousness is that they've made up their mind. So now they're kind of guilty and proven guilty until they see something that changes their mind, or vice versa. And with Amber lying so much and all of those pieces of factual evidence coming in with everything that her side presents as her word, and also just displaying that it's always someone else's fault, displaying, well, that must be wrong, the nurse must be wrong, the doctor must be wrong, they're lying, they're lying, they're lying, they're lying. No, you know, I don't recall, I don't remember, I don't recall, I don't remember. And it's always in, you know, it's always in a convenient state of mind. That to me right away would say, what? You know what I mean? And I mean, it's just almost like, it doesn't take a rock. It's not that deep. You know what I mean? It's like what we talked about. It's like what we saw with Richard Grannon's video about word salad, you know, talking about someone that describing what word salad is and going through a conversation where someone's, it's like a child. This is a perfect example. Oh my God. Ray Liotta. Ray Liotta passed away. What? How sad, you guys. Wow. You see that? That must have just happened 5 minutes ago. Oh my goodness. I hope my kids are watching this. Ray Liotta passed away. They always know things way before I do. And I would say too that if Johnny Depp at his age doesn't have high blood pressure, he sure as hell does now. That's so sad. R.I.P. legend. It must have just was released. Oh my gosh. Wow. Wow. Oh, what's this? Aw. I can't believe this. Are you guys? This is terrible. This is why I love Twitter, you guys. What happened? Ray Liotta, an actor known for his roles in Goodfellas, Field of Dreams, and Grand Theft Auto, Vice City, passed away at the age of 67. Aw, sad. That's what happens when you get older, though, man. It's scary. Goodfellas, John Q, Field of Dreams, GTA, Vice City, Killing Them Softly, No Sudden Move, Karina, Narc, Blow, Slow Burn. Hey, didn't Johnny Depp do Blow? Slow Burn, Wild Hog, Smoking Aces, Observe and Report, The Place Beyond the Pines, Many Saints of Newark. Wait, here's Deadline. Here's the article. Deadline, Hollywood. I think my son's asleep. Deadline.com. Let's see. Let's look at the article. Hold on one second. We'll talk more about the case in just a minute. Oh my gosh. Ray Liotta dies, Goodfellas. A shocker. Ray Liotta, the terrific actor whose career broke out, came in 1990. Martin Scorsese's crime Goodfellas and co-star of Field of Dreams, has died. He was 67. Deadline hears he died in his sleep in the Dominican Republic, where he was shooting the film Dangerous Waters. We will have more details when they become available. Liotta leaves behind a daughter, Carson. He was engaged to be married to J.C. Nitolio. Aw, that's sad. Aw, he was engaged. I don't think Ray Liotta was ever married either. Liotta was a big resurgence, right? Recent turns included The Many Saints of Newark, Marriage Story, for which he shared an Indie Spirit Award for its ensemble, and No Sudden Move. He finished the Elizabeth Banks directed Cocaine Bear and was due to star in the working title film The Substance, opposite of Demi Moore and Margaret Qualley. Aww. Sad. Aww. I hate to hear that. Wow. Now I forgot what I was saying. That's so sad. Look at the tweets. Wow. That's crazy. R.I.P., man. R.I.P. Like I said, I hope Johnny Depp takes care of himself. Johnny Depp will be 59 on the 9th of June. And I hope that he takes care of himself. You know, all this stress of being in the media. Oh, that's okay, Candy. It's all right. It wasn't, I mean, you know, you can have a chance to, they've rested. So, but you missed a good one. You missed Camille. Camille crossed again. Ray Liotta passed away. We were just looking into that. But yeah, you guys, like I said, at the end of the day, you know, it's about defamation. It's about, I mean, still, I don't like, I mean, I think the jury will take into consideration what Amber Heard is going through online. I get that. But like Emily said, it's the, and I agree with her, you know, it's going to be the determination of why. She started this whole thing and he said, don't do this. He said that many times. Don't do this. You hear him on the audios, and that's what I'm, it's just the audios, man. I mean, you can't escape the audios. There's so much that it's just a telling tale in the audios, you know? You can show me all this evidence, and you can tell me the story. You can present your evidence if I'm sitting in the jury box. But once I listen to those audios, it's just so telling. And I understand that she's talking about his addiction. I get that, you know, and that is made light in her audios, you know, several times if you've heard all the audios. And there is new audios on the Depp Dive website. There is new audios. I don't know if you guys know that, but there's new audios. Angie posted yesterday. There's like 5 new audios on there. And that's why I intend on, making videos and making sure those audios are out on my channel. But the audios are what got me. She's very combative. She's very combative. You can tell, like, and that's the thing, if they did not want Camille to rip into her that way. And there she goes again. And not to go all over the place, but point being, when she gets up on the stand, she's directed, right? So when she gets up on the stand, Rottenborn starts and says, how has this affected you? Da 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 da. And they ask Johnny the same thing. She goes into this long spiel. She wants to do this whole performance again. She wants to get emotional. There's no tears. She wants to say this and she wants to say that. And eventually we know that she's going to say it's somebody else's fault. And we know that she's a master manipulator. So she's going to leave the thought in the jury's mind. He's a big star. He's an A-lister. He's powerful. Oh, woe is me. I'm small. I don't have anything. He wanted to, block my career from evolving, this and that and the other. And I don't believe that. He told her on the phone in the San Francisco phone call, which is my next drop, because I'm actually uploading the audios as we speak. But that 5-hour audio, you guys, it took me 10 hours to get that 5-hour audio put in here. It took me 10 hours to do that all night. And it took me 3 days to get it to even upload. It was challenging. I'm not going to use words I don't need to use, but yeah, it was very challenging to try to get this audio up and running. It was terrible. But the audios are what did it for me. The audios. Because he said, and by the way, actually, you know what? Are we done for the day at court? Are we done? Does anybody know? Are we done for court today? Because I only ask because they're still streaming. See how they're still streaming? Are we done for the day, you guys? Are they going to be filming anything else? Because I don't want to sign out if they're going to film something else. I mean, if they're going to air something else. I think the jury's just done for the day, right? Closing arguments, do they start today? That's where I'm confused. I'm just confused about closing arguments. I'm confused if okay, she has to come back. Okay. The reason why I say that is because I was going to play that audio for you guys. It's very important you hear it. It's very important. And if we don't get time to do it today, I definitely am going to have another live stream tonight. Okay, closing arguments are tomorrow. So let's go ahead. When court ends, if you guys want to hang out a little while, I'm going to play that audio for you all because I think it's very important. I mean, we can hear it first because it's brand new. Like I said, if you guys aren't following Angie on Twitter, then you need to be following her. She updates the website daily. So if you have a Twitter, it's best. Oh, I wanted to show you this real quick. This is what I wanted to show you. So this is another thing that really, this is why I was so upset yesterday. So Eric was with, or, you were with me. My viewer was with me all day yesterday and heard my attitude and my take on court yesterday. So I'm going to move this. I'm going to slide this over here just for a second because I have Twitter up on Edge too, but I have this particular tweet. So this right here was very important. See? So Amber has absolutely no effing awareness and it's actually sad. She needs help. So, okay. So that's a personal opinion. But what I was saying about this is that this is her demeanor yesterday. This demeanor right here was imperative. It was going to set a precedence of the impression she was giving on the last day, on the last 2 important days of the case. She came in smiling. She was smug. She had this energy. You don't do that. She needed to maintain composure, regardless of how she feels. And this was her this morning. Same thing. But then she wants to jump up on the stand and she wants to cry, and she wants to show she wants to show the jury that she's sad and how affected she is, but yet she can turn on and off her emotions, which she's not obviously feeling any emotions, because nobody in their right mind can nobody can do that. Nobody can turn, can be, it's just absolutely psychotic to do that. To be so out of tune of your emotions. And I forgot how to insert this into my tab again. I'm trying to insert it into my tab again. Oh crap. Oh well. So that's one of the reasons why I wanted to talk about that, because when people ask me where do you stand, and why do you feel so strongly about, not liking Amber or whatever, it's because of the type of impression, like the cameras are on her at all times, right? Everybody's dissecting her every move. She's already not liked in the public's eye. But again, the public has already explained why they don't like her, or why they have this attitude or whatever, towards her, because she started this whole thing. She started it. You know what I mean? She from the deposition in 2016, which therefore that's why everybody should. How far back do I need to go? Uh, Maybe the last after lunch, probably. After lunch. I think she gets called after lunch. Unless you want to see Dr. Hughes. Yeah. So, and, I think Candy and I will have a very interesting conversation on Saturday as well, since she has a bit of a different take on things. But for me, yesterday and today was imperative, her attitude, because the jury's studying, they're studying these two people, and Johnny Depp has stayed even keel. You know what I mean? He stayed even keel. He's been attentive when he wanted to perk up. You've seen him do that. But the snickering and the snarkiness and the demeanor and the bringing in this new attorney last minute, and his aggressiveness and the style. I mean, the jury's paying attention to everything. And if she's such a victim and she's so scared, I mean, imagine nobody would feel comfortable in a room with someone that they feared for their lives. And then to watch him on the stand yesterday when he was crossed, and have this snicker, this attitude, this I don't know. You saw it. Okay, you saw it. So that already put a bad taste in my mouth. I don't like the woman, because I feel like she's manipulating the entire system. So basically, she's the girl that cried wolf. That's what she is. He told her, we can divorce and we can do this amicably and quiet. And we all knew that Johnny cared about her a lot. In the audios, Johnny Depp takes accountability and responsibility for what his ailments, which is his dependency, anything that he's done. But he did not do the things that she accused him of doing. And you can see in the divorce papers, which I brought up so many times, about the minute that he said he wanted out and he was going to file, he goes on location and she files immediately the minute he leaves town. On top of the fact that she had been cheating on him while they were still married. I know that she filed the divorce as well, because she would have been evicted if he would have filed first. And they would have been evicted in 21 or 23 days or whatever. And, she was trying to save face for her and her friends. And then she got greedy and wanted to own 1, 3, and 5 or whatever was in the divorce papers, along with the life alimony, knowing that California is a community property state, and, and all of that. So you have to take that into consideration as well, in terms of how that's what prompted her to conjure up this story, which therefore, again, I understand being in all fairness of Amber Heard's side, but there is an audio of her saying, literally spitting out the words of the plan she had to frame him. She's explaining the story as she was planning on setting it up. So that's what changed my mind about Amber Heard and how she intentionally did all of this. She blackmailed him, she framed him, and that was it. And she wanted what she wanted. And I don't know why. I think it was her own insecurity and her own fear that he would not give her anything. They didn't have a prenup, so obviously she knew she wouldn't have any power over what he decided to do. So it would have been better. And he tried and tried and tried. And honestly, even if she wouldn't have done this, I think he still would have gave her what she wanted. or at least enough, for what he thought was reasonable. I don't think he was greedy. I don't think he was, you know. It's just like he said, I don't, on the stand, he said, why they said, why don't you want your name attached to the donations going to the children's hospital? And he said, because I don't want the acknowledgement for that. You know what I mean? There's really no need to do that. If I'm going to donate my persona to the hospital, I want to show up as Jack Sparrow and spend time with the kids. I don't want it to be about money. And so that's another thing. So like I said, I'm not saying Johnny Depp was not not getting not getting upset. I'm not saying that Johnny Depp was not whatever. I'm not saying that. I'm not saying, but I don't believe he did the things that she accused him of. Not at all. I don't believe that at all. Do I believe that he had a fit and, maybe called the studios or whatever? Maybe. Does he have the power to have her fired? No, he does not. Does he know a lot of powerful people? Yes. You know what I mean? But she was poking the bear. She was constantly pushing him and 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 pushing him until he literally had a response. There are numerous audios of him pleading with her and saying, what do we need to do to settle this? How do we come together? Let's make a statement. Let's figure this out. Let's come to an agreement. And she loves to fight. And so she wanted to go down, and she was the one that pretty much narrowed it down to that. If you don't give me what I want, I will destroy you. And I don't think he had that. I mean, but like I said, even with the text messages, okay, you want to believe the text message is fine. You're entitled to do that. It's your opinion. You have to come to a conclusion on your own. But at the same time, you have to look in sequence, not just the fucking evidence, not just the evidence. You have to go back from when they got divorced. This is all the way back to 2013 throughout the relationship, and go through that evidence and also know the story. So that's why I say Incredibly Average has the best narrative. So if you have to, okay, until me and here's my assignment to those that are tuning in that care. Go to Brian's channel, Incredibly Average, and watch every single one of his videos. Every single one of them, from part 1 to part 2, refresh your memory, whatever. Take one whole day and just let it run and watch all of his videos, and he will break down from beginning to end their divorce, how much haste, how much bad energy there was up until now, where all of these incidents, all of the evidence, all of the pictures, all of the stories, the UK trial, because he followed this story for so long. So that's all I'm saying. I'm not telling you to decide that Amber Heard is guilty. I don't, that's up to you. I know how I feel, and I know based on what I've seen and what I've heard where my mind would go. And I think Johnny Depp deserves his name back. That's just me. We're not talking about money right now. I don't believe he did those things to her that she's saying he did. I don't believe it. I don't believe it. Were they mutually nasty to each other? Or were they mutually, spitting out ugly words to each other? Probably. But I do believe that she was the aggressor. I could hear it. You can hear it on the audios. You can hear all those people in real time talking about her doing these things. You can hear them saying she knows what she's done. You can even hear glass hitting the ground when Johnny's sitting next to in that penthouse, in this one that I just dropped right now on my channel, the 4 hour and 22-minute, whatever. You can hear her not getting her way. So she throws something across the room. You can hear it. And he's sitting right next to the phone. And he says, come on, Amber. Really? You know what I mean? And so, there is a piece of audio in the Depp website where he gets mad. But again, he's frustrated. He's like, he yells, I think it's like a 30-second clip or something of an audio where he yells and he says, this is not happening. He gets really upset. You can hear it in his voice. So it's not that he didn't get angry, or that, he's not guilty of having a dependency. It's not, I don't believe that he did the things that she accused him of doing. Bottom line. Do I think she wanted to defame him? Yes. Do I think she was jealous of him, jealous of his career, envious of his career? Yes. Do I think that he might have been, do I think that there was a misunderstanding when they got married, that he honestly, I think he expressed his, I feel like because they, when you first, there's the honeymoon stage of any relationship, right? So I believe that somewhere in the time that they met, that he expressed to her what his true idea of a partner was. But I don't believe, being that Vanessa Paradis is a singer, I don't believe that he would wanting to shut her career down. I just don't. I don't believe that. I don't believe it. That's just my own opinion. I don't believe that. But could he have been uncomfortable with her roles or whatever? Maybe, I don't know. That's just a boy being a boy to me. You know what I mean? But I don't find that to be um something that makes him an abuser. I don't, I just don't. And the reason why I say that is because he's had so many long-term partners previously. I mean, Winona Ryder was an actress. Kate Moss was a model. Vanessa Paradis was a singer and a model, I believe. So, he's had too many partners that have never come forward and said anything like this. So for one person to come out with nobody else coming out of the woodwork saying anything, that's another thing that should take, yeah, that should matter in your opinion. Yeah, pushing and pushing and pushing. Yeah, she pushes that man to a negative response. And yeah, anyone who is still defending this woman is, yeah. Well, I mean, like I said, people want to stay fair-minded. People want to, but that's because they haven't, I mean, if the jury, we don't know if the jury's going to have enough time to review all that audio. Come on, let's face it. There's like 12 hours of audio. I mean, it's ridiculous. And even the way that it appears on the Depp's website, as you can see, those audios are little clips. Some of them are 2 hours. I think the longest clips submitted were 2 hours a piece. So even me, like I was thinking, if I'm going to put this on my channel, I'm wondering how to put the clips together, because a lot of the clips that have been released on YouTube are 4 hours and 22 minutes. Like even the one that I did, I mixed Toronto and the 4 hour and 22-minute clip. And, it came out for me as a total just now, because I just uploaded the video to my channel. It came out at 4 hours and 25 minutes. So I don't know why it did that, because it was 19 minutes and 38 seconds for the first clip that I play. And then it was 4 hours and 22 minutes for the second audio. And I just did straight audio this time. So, yeah, I don't know. I'm going to try to do this public. We'll see if I get claimed. I'm kind of scared to do it, but I just published it right now. The reason why I'm scared is because I don't know. I've never done an audio on my channel yet. So here it is. Whoop, there it is. But anyways, that's where I stand. So like I said, we're not the jury. We don't know. We don't know what they're going to decide. We don't know what the jury's thinking. Oh, crap.
That?
Yes, Your Honor. Thank you. It's
Okay.
just an Eastern Columbia building.
Okay, here we go. Sorry. Nobody reminded me. God, an hour went by fast. Hold on. We're behind in the stream.
Okay.
Okay, wait. Hold on. We're just going to be behind, I guess. So if you guys are watching real live streams, I didn't know. I didn't know we were back. Hold on. Hold on. Crap. I'm behind in the stream.
Let's go ahead and start with jury instructions, since they're almost all done. That would be helpful.
Sorry, you guys.
Okay.
I was just jabbering.
I already have them in a potential order, but let's go ahead and go through them. Oh, one thing I'll do for the record first. Plaintiff's 287, which is the same as defendant's 780T, is a corrupted file that we received from both of you. I guess it's corrupted on both of them. And nobody seems to be able to do anything about it. So I think it might just be that it's in evidence. However, it's not going to go back to the jury because it's corrupted. Okay, does everybody agree to that?
Yes, Your Honor. Thank you. It's just an Eastern Columbia building video, so that's fine.
That's just, just it's corrupted. Okay, do you have more exhibits to give? Good.
Okay, thank you. Sorry, I didn't mean to start gabbing.
All right, so these, you want to get your list, Jamie, to make sure. All right, it's defendants 393, 821, 857, 857A, 883, 1859. 1905.
Those are all paper? Wow.
Shows nothing. 1050. This seems to be a longer one. Hold on. And I think that is it, correct? All right, are you missing any other exhibits?
Your Honor, if I may approach.
Yes,
we
you have some?
from
Okay.
Today,
Let's
yes.
go ahead and get those.
I need to take my vitamins.
All right, so these were the two through. Oh, these. All right, so we have. Okay, I think this one's theirs. All right, so I have plaintiff's exhibit 1316 and 1317. Yeah. 1301. Does anybody have 1301? Plaintiff's 1301. An Instagram post.
We'll get it, Your Honor.
711A and 711B, the one without the metadata, and one with the metadata showing. It was the same pictures, but it showed the metadata.
I believe that was 712A and 712 and 713A.
Yes, I don't have those. We just have 712 and 713A.
Understood, okay.
Can I get them now? Trying to get all the exhibits together right now so we have them all together so we can review them.
And then the other one is, 120D is not in evidence, but on their list is in evidence.
120D, is it David?
Yes.
So 120D was listed as, you had it as an evidence, but we do not have it in evidence. All right, is that all the pieces of evidence? Excellent. That's good. Good, okay, so we are very close to getting all of that. I don't want to leave here until we have every piece of evidence with Jamie and everybody has reviewed it, so we don't have to review that tomorrow and waste time with that, okay? All right, so now I think we can do jury instructions, correct? All right, let me just go over the ones that we had a few issues with. At the first one I'm gonna go over is the self-defense. There's two, that would be number 28 and 29, correct? And I took those under advisement. Do you still have an objection to the self-defense? All right. So what evidence do we have in trial that would allow to have these two jury instructions?
Sure, Your Honor. So I think there's evidence in the record showing that, Mr. Waldman was Mr. Depp's agent, that, he was retained in connection with the UK litigation and with this litigation. There's evidence that he engaged with third parties in that capacity, that he met with the Daily Mail with Mr. Depp, and that he believed Mr. Depp's version of events. And so I think all of that, is relevant evidence to a self-defense, that Mr. Waldman made those statements in self-defense on behalf of Mr. Depp.
All right, so you're saying if agency is found.
If agency is found.
We believe they're inappropriate, Your Honor. First of all, we have not been able to locate case law, but
We found one from 1860?
That might have been-
1887.
And I know I had seen one a
We said
while
it was
back.
reversible error if you didn't give the self-defense one, so.
Well, I know I'd taken a look at one a while back. I think, but I don't have a case site for you. I think it's a question of law as to whether it applies. And so at a minimum, I think we should figure that out, I guess. But the reason we don't think it should apply is these were statements that were made by Mr. Waldman in 2020. I guess it was before Ms. Heard's counterclaim. So if he's saying that
It goes to the op-ed, I think.
Understood. So if he's saying that this lawsuit was a statement in response to the op-ed, statements that were made a year and a half later by Mr. Waldman, and it doesn't, again, Your Honor, the key words are fairly and reasonably. So obviously both sides are going to argue defamatory implication and what did the op-ed really mean, and did it say these things? But saying, even under their theory, 2 years ago I became a public figure representing domestic abuse.
to say that then it's fair for Mr. Waldman a year and a half later to make public statements that Amber and her friends roughed up the place and spilled a little wine, all the things that he said in those statements, that's not fairly and reasonably. Ms. Heard responded fairly and reasonably to Mr. Depp's case through her counterclaim. The parties can speak to each other in the courtroom here, but saying that if someone makes a statement in an op-ed, that then you can go and do whatever you want for 2 years, say whatever you want. And obviously, there's only 3 statements that comprise the counterclaim. But as the evidence has shown, it was part of a pattern by Mr. Waldman. It's the opposite of proportionate. It's the opposite of fair and reasonable response.
Okay.
Mr. Depp's opportunity for a fair and reasonable response, well, we don't believe it was either, but he had the opportunity to file a lawsuit in this court.
Right.
To have Mr. Waldman be his attack dog and to say anything Mr. Waldman then says as his attack dog is somehow fair and reasonable and entitled to the privilege is inappropriate. And I do think that before Your Honor gives it, we need to confirm whether it's a question of law.
Okay.
Your Honor, Mr. Rodmore noted that this lawsuit was a response to the op-ed, but I think there could be multiple statements in response to the op-ed. So I think that's not dispositive of anything. And the statements were clearly a direct response to Ms. Heard's allegations on their face. And whether that response was fair and reasonable is a jury question.
What do you say is the matter of law? The privilege of self-defense is a matter of law?
I think it could be whether it applies.
Okay, I don't think it's a matter of law. I think it's whether or not if there is any evidence that a jury could find it being protected speech, not the weight of the evidence, but if there is any evidence. And I don't think it's my role to weigh that evidence as far as how long it was made afterwards.
I think it is, Your Honor. I mean, it can't be the case that anytime there's an alleged death, this is why this doesn't come up often, because this just isn't given. If it were appropriate here, every time there's a defamation case, this would be an instruction. Even the person who's the defendant in the case, who said, "Well, all I said, I was responding to something that was said before."
So all your evidence that you say goes to the jury are just the statements. That's why this should be given. That he made the statements. That's the only evidence.
Well, I think
You gave me evidence of agency, but that's just agency. Do you have any evidence that of self-defense, that he actually said these statements because of what she said?
Well, I think there's circumstantial evidence, at least, that so it's agency. He's an attorney who's retained in connection with this litigation and the UK litigation.
That doesn't automatically give you self-defense, though, a privilege of self-defense.
And that's
you have to make them. I have to have some evidence that the statements were made in response to the direct accusations of Ms. Heard. And just some evidence.
On their face, they appear to be a direct response.
Not the statements themselves, but is there any other evidence? The statements fairly arose in response to Ms. Heard's accusation. Did anybody testify that he made these statements in response to her op-ed?
No.
Not that I'm aware of, Your Honor.
All right.
Your Honor, just one small point there. There's no requirement that it be in response to the op-ed in particular. The question for self-defense to apply is simply whether it's made in response to an allegation against Mr. Depp. And Mr. Waldman's evidence is clear, I think, that he was responding to allegations against Mr. Depp, and he believed those allegations to be false. There was extensive evidence in the record on that, in fact, I think.
That he was responding to. So if it's not the op-ed, then we're really in murky ground. If he says, "Well, I was responding to what she said in 2016," that's
what Mr. Munez is saying is that you take it as a separate case. You take it as a separate case, their claim and then your counterclaim. So your counterclaim is a separate standalone case, right?
Okay.
So the standalone case doesn't. Your claim doesn't deal with the op-ed, so they're saying in defense of your case, that's why this comes in.
But he couldn't have made the statements in defense of our case because these are the basis for our case. So what he had to have been, what was he responding to if it wasn't the op-ed? And if it's not the op-ed, then we're really in murky ground because there's no. Plus, Your Honor, a couple points. To your point, there's been no testimony that he made these in self-defense to anything.
Two, the defense doesn't apply. And this is, it doesn't, this is under the Haycox case, 1958. It doesn't apply if we prove malice. So it has to be made in good faith and without malice. So it's coextensive. I could bring the case up if you want, Your Honor. So if the malice inquiry incorporates this, this is the, let's see, 200 Virginia 212, Haycox versus Wilcox Dunn. And it looks like on page 231, they're discussing a Massachusetts case, and that says, statements made in an honest endeavor to vindicate one's character or to protect one's interests are usually regarded as qualifiedly privileged, even though they are false, if they are made in good faith and without malice. So the malice inquiry takes care of this. In addition, I don't think I need to remind the court, but for the record, Mr. Waldman was not allowed to answer any questions about this. So to say, well, he could have been making it in defense of something, they could have let him answer questions and get that evidence on the record. They can't say, well, he could have been making it in defense to something now.
And when I say, just looking at your case, you're claiming these alleged defamation. The three we have allegations. Well, they're saying in response that they made them because of something she said that maybe is not the op-ed.
Then there's no evidence of what that is. She was sued. She said 2016 when she made her and 2018 she has the op-ed that have a couple words that they're trying to turn into what we've just seen for the last 6 weeks, and then she responded to the lawsuit. Okay. So it can't be the case that by trying to defend yourself in a lawsuit that was brought against you, if it's not the op-ed, then it's got to be her statements in the lawsuit, that somehow trying to defend yourself through judicially immune statements in a lawsuit entitles someone else to go out and say whatever they want and then try to veil themselves in the privilege.
Counsel for Ms. Heard made a point of making clear that there was extensive allegations about Mr. Depp circulating. They repeatedly brought up the UK action, which was in fact the context in which I believe these statements were made based on the date. It was very close in time to the UK action. They brought up the Dan Wooten article. These allegations date back to 2016. These allegations are out there, and there's there's evidence, from which the jury could find that Mr. Waldman was acting in defense of Mr. Depp.
We're not acting in defense against Ms. Heard's accusations. So what are Ms. Heard's accusations that would be defense that are in evidence?
Your Honor, there has been extensive evidence of the accusations against Mr. Depp going back to 2016. For example, the Dan Wooten article that they raised in evidence prior to the op-ed, which included the word wife beater, and was essentially,
But it has to be.
That's not Ms. Heard's statements.
Ms. Heard's statements. Right.
I don't believe that's correct, Your Honor. It doesn't have to be
Against Ms. Heard's accusations. It is correct.
That would be crazy, Your Honor, if they get a jury instruction because he was responding.
I understand.
Again, the number of allegations made by Ms. Heard, it's been very well documented in this case. You have the op-ed, and it doesn't have to be it doesn't have to be any one particular allegation, but you have the op-ed, you have the People magazine article, you have the republication of her statements through the wife beater and the Dan Wooten article. You have the fact that she was giving testimony in the UK action about these issues.
Well, then would you agree that actual malice, you don't get the self-defense if there's actual malice in his statements? If the jury finds actual malice, then you don't get.
If the jury finds actual malice,
then it's not protected
that may obviate the privilege, but that doesn't mean that the privilege is not applicable or a valid.
But the only way they can find in this case is if there is actual malice. This goes back to their defense, slap defense as well. The only way they find defamatory statements in this case is if there's actual malice. And it's unique to this case, I understand that. But so if they find actual malice and defamatory statements, you don't have protected speech privilege.
And if there's no actual malice, they win.
Yes, correct. The same with this, that's why we're not giving a jury instruction on the slap defense, because there's no basis for it.
I mean, if the instruction is not being given on the understanding that it's essentially moot.
Which I agree. I think it's what happened with the slap defense as well. We found out after we went down that legal road, we found out that was moot as well. Okay, so you want me to deny it or withdraw it? I'll do either one.
If you don't mind denying, Your Honor.
Okay, that's fine. I'll deny. That's instruction 28 and 29. Okay, put that in the deny stack. All right, next one I have is the republication one. Okay. So I see both of them dueling paragraphs for the republication. Yes, sir. And I understand last time we spoke that you must determine whether any content that was added constitutes a republication. And you just would rather have just the 3 sentences as yours for republication. Is that correct?
Correct, Your Honor.
That didn't,
No,
well,
no, I
you
think
must
it's the
find
flip.
that she read, or you want to add that into it? I'm not sure. I'm just not sure how I'm reading it.
I think, and I don't mean to put words in their mouth, I think we want the whole thing at the top.
Right.
And they just want the 1 sentence at the bottom.
Okay, that's correct.
And Your Honor, we talk about not going backwards. We went
No,
over
I
this on
understand.
Friday. Your Honor said that on page 92 of the transcript, I don't have a problem with the republished jury instruction. I just think it has to be accurate with adding the language. And
Right.
that language was on page 89. You said, but you also have to say, but adding content to it may establish republication. So that's what we did in the sentence that starts with merely linking.
Right.
It did say merely linking to an article does not amount to republication, period. And then we added directly from the transcript, but adding content to it may establish republication. So now they're going backwards. They just want you to strike the whole thing except the first sentence. And that's different from Your Honor's ruling on Friday and also doesn't fully capture.
No, it
the
doesn't
republication
capture the whole
doctrine.
legal argument.
And if I may just make our argument for the record here, Your Honor.
Well, you did on Friday, but if you want to do it again, that's fine.
Okay, just very quickly. So I think the issue with republication is whether it reaches a new audience, which is what we
And that's there.
what we propose. Right, it's included in their instruction, and that is basically the full extent of our proposed instruction, and we believe it should be limited to that. Lakova is a case that they've repeatedly cited in support of this republication issue, and that's a case where there was a defamatory New York Times article that was hyperlinked in a more recent New York Times article, and the court said that that's not directed at a new audience. It's the same party tweeting to the same audience, so there's no republication. And that's not the case here, where Ms. Hurd has retweeted a Washington Post article. So that, Ms. Hurd's audience on Twitter is different than the Washington Post. And
But if she just retweeted a hyperlink, that's different. But in this context, and that's why I took the motion strike under advisement, once I got it, there was more content to it. And that's why I'm putting it in the jury instruction, because it is accurate that a hyperlink alone is not enough to reach a new audience. What I'm willing to, what I think would also add to it, though, is after you must determine whether any content that was added constitutes republication. And let's see, I would say then you must determine whether any added content republished the op-ed to a new audience. I could say it that way. Or I could say, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication. I could say it in that term. Add that to the end of that paragraph.
I think that's fine if that's the court's inclination.
Do you have any objection to that?
I'm thinking, sorry, I'm
Okay.
slow on the. Yeah, that.
Sure, okay. Let's see. All right, let me see if I can incorporate it into it. Okay, so merely linking to an article does not amount to republication, but adding content to a linked article may constitute republication. You must determine whether any added content was intended to reach a new audience. If you find it was intended to reach a new audience, it constitutes a republication.
I think we would prefer just to say just that first sentence, merely linking to an article does not amount to republication, but adding content to a linked article may establish republication, period.
Well, that's what you already had. This is
No, because we had you must determine whether any added content that was added constitutes a republication. I think it'd be better to just delete the last 2 sentences than to add the sentence at the end.
Your Honor, I just want to note, I don't think that adding content is a requirement for republication. I mean, we found a number of cases that when somebody repeats a defamatory statement, that they're as liable as the original defamer.
We're not
And,
going back, we're not going backwards. So either it's his language or my language. What do you want?
I prefer the court's language.
All right, I'm gonna put my court's language. Okay.
Do you want us to do the revisions? Because if you do, we may have to just get one more time from you.
Okay,
We're happy to, or
Sammy, can you do it? You gave him to
We did.
Word format?
we did.
All right, can you do that? Here.
The only other thing I would note is I think the word retransmitted in the second line is misspelled.
In the second line? Okay, all right, we'll take care of that. But adding content, adding content, yeah, it's like this one right here. And then just get rid of all of this and add this instead. Okay? All right, and we'll clean it up. We just took out the box. Okay, we'll get that done. All right, takes care of that one. Next one is, I think, instruction FF. Defamatory meaning, consider the publication as a whole. And we had dueling answers here. And the defendant just has op-ed in it. The plaintiff just has it as plain, which, I mean, it does say that it means you may not seize any word, phrase, or image. So it would appear that, so it could apply to both of them in that context.
The problem, Your Honor, is that we believe that because the counterclaim statements that the jury will be presented with are redacted, so the statements are in isolation, that there's a risk that as they're phrasing it, the jury may read the phrase, "You must read the statements in context as a whole," to say, well, we can't do that, so therefore there's no liability. We think because it's impossible to read those statements in the context of the whole piece. And so that's number one. Number two, the op-ed was all Amber's statements. So the whole thing was her words. The counterclaim statements were Mr. Waldman's quotes in another article that we don't believe, well, that's not an evidence. So there's no point arguing about that other than you just have these one or two sentences from Mr. Waldman. So we believe that the jury's going to be confused if we give their instruction and say, we cannot read it as a whole. So therefore we can't, follow the jury instruction.
Okay, I can see your point with that. Yes, sir.
I don't think there's anything there's a lot of instructions here. I don't think there's anything that would indicate they can't find the liability if they're not able to take statements in their proper context, in the context of the entire article. Just thought it would be more appropriately phrased to be mutual, as opposed to obviously applying only to one party.
Well, because yours says you must read the statements, which is true, but you also can take the content in the context as a whole, but you can take the context of the op-ed as a whole, which is accurate. What I could do, if you want, I could keep the op-ed up top for their claim, and then for your claim, we can, in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read the statements. I could keep that in there as the second paragraph. That way they can't just pull out, because it's accurate law also, that they just can't pull out the word hoax and say, okay, this whole statement.
Agreed.
Okay?
That's fine. Thanks.
Is that okay?
That's fine in concept. I guess I would ask if Your Honor does that to add a clause saying disregarding any redactions on.
Well, it says the statements themselves, statements, in theirs, you must read the statements in context as a whole.
Right. So, but I think, could we say in determining whether any of Mr. Waldman's statements or whatever are false and defamatory, you must read the text of those statements as a whole. The text of those statements in context as a whole or something.
Well, it's you must read the statement in context as a whole.
You must read, can we say you must read those statements in context?
You must read those
because I just don't want them to think that it's impossible for them to.
Any problem with just putting those instead of the.
I don't think we have a problem with
Okay, in determining whether any of the statements attributed to Mr. Waldman are false and defamatory, you must read those statements in context as a whole. This means you may not seize on any one word, phrase, or image, or consider only one particular statement, phrase, or passage in isolation. Does that sound correct?
Yes.
All right, we'll add that as a second paragraph. Keep Sammy busy. Takes care of that. All right, the next one I have is the objections and assertions of privilege.
Which? 32.
Oh, I'm sorry, it's
Sorry.
Depp 32. It's a new instruction.
Oh, yeah, right.
Yeah,
This is
you
the
have
one
the
at the end. This is the new one.
Do you have the objection?
We do. Yeah.
Okay.
The objection, Your Honor, is that the objections made by counsel during the course of trial, we have no problem with something on that. But instructions, what they're trying to do is to direct the jury what inference to draw from Mr. Waldman's instructions not to answer.
Well,
And
the only legal inference they can draw, they can't draw any inferences from that.
Exactly, and that's my point.
Well, and that's what this says. You may not draw any inferences from the fact that objection was made.
Yeah, but saying sometimes attorneys stated objections during the course of this trial and instructed a witness and instructed a witness not to answer a question. Objections and instructions to witnesses are not evidence, and you may not consider them in reaching your verdict, nor are you to draw any. So, why do they need to be told this? I mean, I think this risks confusing the jury.
Because to be fair, the depositions you wanted to keep in all those objections when we usually would take them out, but you wanted to keep them in. So I want to make sure the jury doesn't have any improper inferences from leaving those objections in. You wanted to leave them in because show that, hey, I asked the questions, they weren't answered, fine. But you can't infer from that, oh, well, they're hiding something then, or it's attorney-client.
Understood. I mean, just like you can't infer when someone takes the fifth in a criminal case. I get that.
Right, which I would give an instruction for.
Of course, I know, I understand that, but I think that the jury is entitled to draw their own conclusions and not inferences. They're not entitled to infer anything from that. But I just think that this risks confusing the jury and getting the jury to think, if they stand up in closing and say they haven't presented any evidence that Mr. Waldman was doing this, then that's using this instruction as a sword. If they get up there and say they haven't, do you understand what I'm saying? They haven't proven that Mr. Waldman was acting as his attorney. They haven't proven that Mr. Waldman was authorized to make the statements. Then they rely on this to hide behind that. And we're not allowed, and I'm not saying that we will, but I'm not going to say, you heard him instruct him not to answer, and you should infer that he was acting as his agent. I know I'm not going to say that, but if they're going to argue in closing the converse of that, then that's prejudicial, and that's makes this inappropriate.
All right, yes, sir, Mr.
Your Honor,
Rose.
this is just an accurate statement of law. They chose to play about 30 minutes of Mr. Baldwin being instructed not to answer. Without this instruction, that's prejudicial.
All right.
And it would also be prejudicial if they're allowed in closing to say that we haven't presented evidence of anything about the parameters of Mr. Waldman and Depp's relationship.
That doesn't follow from this instruction.
does.
This instruction is simply saying that the jury is not to draw any inferences from the objections and instructions inserted by counsel. They can consider the evidence. They can consider whether evidence was presented or not. The instructions and objections are irrelevant to that question.
No.
All right, I understand your objections, but it is an accurate phrasing of the law. And I want to make sure that the inferences aren't taken against an attorney-client privilege.
Okay. Can you deny it over our objection?
You got it. No, I can grant it over your objection.
Sorry.
Good, Freudian
I
slip.
meant grants. Yes, sorry.
Okay.
Can we get some direction for the arguments that they're allowed to make on closing on that, Your Honor? Because I don't think that's appropriate for them to point to a lack of evidence when they didn't allow Mr. Waldman to testify.
Pointing out that instructions are not evidence is not to say there's no connection here between these issues, Your Honor.
No, I'm not going to do that. So we're going to do Depp 32. I just need to clean up the top part of it. Okay. All right. Over objection. Be offered. All right, then I have instruction JJ, which is the model.
Right.
So why would I not give the model?
We believe you should. I think the only, looks like the only substantial difference is that they, rather than saying, as it's written, it says clear and convincing evidence that Mr. Waldman's statements, it's confusing and misleading to say that if you found by clear and convincing evidence that Mr. Waldman's statements were made by Mr. Depp, that you already have a principal agent instruction.
Right, if they find principal or agent, I mean, that would be the only basis for it.
Well, first of all, Your Honor, if liability is entirely vicarious, which I think is the position of the counterclaim plaintiff in this case, I don't think there's any evidence of direct liability. If liability is entirely vicarious, then I don't think there's a basis for a punitive damages instruction at all against Mr. Depp, because vicarious liability generally doesn't result in punitive damages as to the principal. Punitive damages are only applied where the person against which punitive damages are being assessed actually engaged in conduct that was wrongful, and that's not the way they've pled and sought to prove their case. I think that's the first.
So they're correct, okay? They're saying you're not entitled to a punitive damages instruction.
Well, I disagree with that, and there's no case law that they've cited in here on that, and I think that's going backwards. That's an argument that we are, and I just think that Mr. Waldman's statements were made by Mr. Depp. I mean, I'd be okay with something that said that Mr. Waldman, while acting as an agent for Mr. Depp, made statements with knowledge. I'd be okay with that.
Is that okay?
I think we would maintain our objection on that. On the basis previously asserted, Your Honor, and then what's the other? I'm sorry, could I have counsel's language again one more time?
Sure.
Yeah, if you have found by clear and convincing evidence that Mr. Waldman, while acting as an agent for Mr. Depp, made the statements with knowledge that they were false or so recklessly, I think it's so reckless. There's a typo there, sorry. We'd be okay with that.
Yeah, I mean, we do maintain the same objection, Your Honor, the principal liability, and we do have case law for that proposition.
I'll overrule that objection. We'll go ahead and, can you type that up real quick for me?
Sure.
And get that to me. If you email it to Sammy, we can print it out.
Yep.
Okay, you're in charge of that one. Okay. All right. That's fine. I think that was it, correct, as far as?
I think it was, other than the verdict form.
Perfect. Let's go to the verdict form. Look at this. Do you have the other ones for you, Sammy? If you can print those out.
Yeah.
All right, let me get the verdict form. All right, I think with the verdict form, it was just the first page. Am I correct with that?
In the punitive damages.
And the punitive damage, you didn't have a response, right? Do you have?
I think there was a comment in what we got from them that we changed.
Okay. All right, well, in the,
here.
oh, thank you. All right, I think it was in 1A, the statement was about Mr. Depp. I think the plaintiff wanted that out because we already have the statement has a defamatory implication about Mr. Depp, and the defamatory implication was designed and intended by Ms. Hurd, which I think is.
If you look at the, I think it should track the finding instruction, which is jury instruction C on page 4 of the jury instructions, and that's what the verdict form does.
Okay, let me take a look. And that was C, okay.
Yeah.
Okay.
So the way it's been written tracks the finding instruction.
Don't have a strong objection here, Your Honor. I thought it was maybe cumulative, but
it does match the finding instruction, which would be clear to the jury. So we'll keep that in.
That's fine.
And then the punitive.
And so that would carry through all of that.
Oh, you withdrew all those?
We'll withdraw that, Your Honor. Their proposed language is
All
fine.
right, so the verdict forms as written are the verdict forms good to go, correct?
Well, I'm sorry, did they withdraw the punitive damages? Okay.
So we're good with the verdict forms. What I have is the verdict forms, correct?
Your Honor, I think yes, but I do just want to make sure, and I understand we don't go back, but I just want to make sure that for the record, we do maintain that the verdict form should state that the defamatory implication was false and not that the statement was false, because under the Pendleton case, that can, a facially true statement can still have a false defamatory implication.
And I think we had that on the record on Friday, but thanks for putting it again. It's fine. All right, so verdict forms are good. So we'll keep the verdict forms. Did you print out the other? No, you can print it out. That's how, yeah. So which ones are we missing then? We're missing with jury instructions. You're working on 2 of them, right?
32. I have 32 in FF.
32 in FF, and you have 1 jury instruction for me, right?
Yes,
All
they're
right.
editing it right now. It's JJ.
Okay, JJ is coming in, and did you do the other one yet, or no? Here, could you guys do? Michelle, or could you, on Depp 32, could you take off disputed and send that to us too?
Yes.
Thank you. And that would just leave us, we'll get those 2 printed out, and then I'll tell you the order that I'm gonna do them. While I'm doing that, I do have the laptop, if both sides would like to look at the jury evidence on these. We'll stay up here at the bench, but all we did was we put 2 files on here. There's no password for it. As soon as you open up, it doesn't have any internet, and there's just 2 files. One's plaintiff, one's defendant. They just click on those 2, and then they can watch all the audio and the video, okay? So if you want to take a look and make sure it's been downloaded to everything that we put on our website, which is all the evidence. We didn't receive any new evidence today for audio or video files, so that it's everything on there. But if you want to take a look and make sure that everything is there, you can do that. Also, all the tangible exhibits Jamie will have, except we need to get those other ones. So you have them? Perfect.
Yes, if I may approach, I have
Okay, sure.
1301.
Okay.
And then, Your Honor, I just would like some clarification.
Sure.
I understand that defendants exhibit 712 and defendants exhibit 713 were initially moved into evidence in redacted format.
Correct.
Today, we offered them and put them in an unredacted form, so that's the
712A and 7.
And then
713A.
713A.
Yeah.
I believe Your Honor should already have those in unredacted form. I believe that's how they were provided to you.
Oh, they're in our
all
binders
by-
down here?
I believe so. I will. Yes, so I believe you should actually have those in unredacted form
All right.
from defendants.
All right.
Um,
We have a few binders down here. Hold on.
Yes, I think they would be in the binders. That's correct.
712 and 713. All right, we'll take a look at those. Yes.
I can give you a copy. I was gonna make a proffer for the ones that.
Do you want to go ahead and make a proffer now?
Yeah, but it included 712 and 713, so I can give you copies of that.
Oh, you can? Well, that would make Jamie happy since she's down here digging through binders.
Right. So I can give you copies of that.
Okay, perfect. All right, now we have those in evidence. Okay, so are we missing any more from over here? Or did you find out about the one that you thought was in evidence?
So, Your Honor, defendant, I believe, it's plaintiffs exhibit 120D. I believe actually Sammy and I had a number of back and forths about this exhibit. I believe that defendant's counsel provided a redacted version of that exhibit to the court, but based off of our reading of the transcript, that exhibit was not actually offered into evidence.
Okay, so it's not in evidence then.
It's not in evidence, Your Honor. I thought, and I believe believe I emailed it to Sammy, last week.
I'm gonna take disputed off.
If you don't have it, I'm happy to bring it tomorrow, but it's not in evidence, so we can go back to the jury.
Okay, all right, so I just want to make sure, because it was checked off on somebody's list that it was in evidence, and I just want to make sure. I don't know, but it's not. We're good.
And
We're
then I heard the exhibits 711 A and B. I'm not sure.
No, I think
Is that
711 was
an
wrong.
error?
It was 712 and 713. So we're good.
All right.
So Jamie, are we missing anything else? Sammy, did you print out the ones that they sent you to? The email, did you email Sammy the?
He's just double checking right now.
Oh, okay. We'll get that in a second. Let me just put these in the order. All right. Get that one without disputed on it. Okay, sure. What publication? It wasn't in the one that I gave you. Let me see. Yeah, that stays in. Yeah, that stays in. You want to go and print that out? Yeah. Just print out 2 copies so we can share them. The one that Sammy printed off on republication, I'm just going to give you copies to make sure they're right, okay?
Yes, and you should receive in your email soon, FFJJ and 32.
Okay. So if you print those out too, Sammy. Let's print those out. So you're sending FF? Okay. Did you take the disputed off the top? Thank you. All right, let me just get this printed. Could you print me out another one of AA? There's a mark on this one. Or at least email that one to Sammy. Something in the paper and it just doesn't look right. send them to Jamie so she can print them out.
Your Honor, will we be getting just a paper printout or an electronic copy from the court?
All I have is a paper.
Okay, so we can
So
scan it.
You can
and-
scan
okay,
it and
that's
do,
fine.
if you want to do electronic, that's
Um,
fine.
And will these be posted on the,
Not until after I can.
not till after, okay, wasn't sure. And then they're read before closing.
They're
is that
read
what you're
before
saying?
closing. All right. So we have
Thank you. Okay, so I guess we just replace.
Thank you.
Okay.
If you want to take a look at that instruction and make sure it looks okay before I add it to the stack. Do you have the actual malice one? Was that sent to you? Michelle, you said the actual malice one.
Yes.
Okay. Oh, never mind. Jamie already did it. Sorry, Jamie.
And Your Honor, was it,
Is there?
no, I think it's fine. Does the court want, to leave the, herd C, Depp 7
No.
sort of things in there? Cause otherwise we could,
Oh, no, well, yeah, the numbers at top can stay. I just
Okay.
don't want, I just want to say disputed.
no, I don't think any of them say dispute.
Okay. No, the numbers, I tell the jurors to disregard the numbers and the
Okay.
heading. That's better for the record if we keep it that way. Okay, so are you still reading the publication? Okay.
Your Honor, can we get, sorry to bother, Sammy, can we get one more printout of the actual malice instruction?
Sure.
Thank you.
Jamie, can we get another actual malice?
A. So these are only copies.
All right, any objection to the republication then? As typed?
No, Your Honor.
Okay. Put that in there.
Hold on.
Is there a typo?
Nope, it's okay.
It's okay?
Yep.
All right.
Your
Okay.
Honor, I just have a very quick question regarding
Sure.
closing arguments, if
sure.
we may. Does the court have any objection to us playing very small clips
No,
of,
as long as they're in evidence, you can play anything, show any picture.
well, that's my question. So
Okay.
obviously depositions were by video, many witnesses, especially from Ms. Heard. Do you have any objection to us playing video depositions, portions
If
of?
it's not in evidence, it doesn't get.
No,
played.
of course, just what's in evidence.
But there's no video depositions in evidence.
Oh, I see what you mean. Okay, so,
The only thing that can be played to them is what is in evidence.
but their testimony, it's witness testimony.
Well, yeah, but depositions are witness testimony that you have during trial. That doesn't go back to the jury as evidence. And video depositions are the same. That would give more weight to video depositions than witness
Well, so
testimony.
my question is a follow-up question to that. Obviously, this trial was televised, so there are videos of witnesses testifying.
No,
So-
none of that comes in.
Okay.
No, the four walls of this courtroom is what the jury decides this case in,
Okay.
period.
And just so we don't have a problem tomorrow, also, we can't put in front of the jury written deposition or
That's
trial
correct.
testimony.
That's correct.
Understood.
Only things that are in evidence. But
Understood,
you
Your
can
Honor.
show pictures in evidence, you can show video that's in evidence.
Or audio that's in
Or
evidence?
audio that's in evidence,
Okay.
all of that's fair game.
And
You just-
no display of written transcripts either.
No written transcripts, just only items in evidence. And,
No, I'm on the same page.
okay, all right, just want to make sure.
Thank you, Your
And-
Honor,
and
for
you
that
have-
clarification.
And you have 2 hours, right? 2 hours each, and you, 2 people over here and 2 people over there, is that what's going to happen?
Yes, Your Honor, we're going to split our closing, and then only one of us will do the rebuttal.
Okay, and that has to just be on the rebuttal case, correct?
Right. Right,
We have that down, right? We've gone through
Understood.
that a few times.
Understood.
Mr. Chu, do you have something on that?
Yes, I just wanted to make sure we were all on the same page. So plaintiff goes first,
Correct.
then the defendant,
Does-
counterclaim plaintiff.
Right, they do
Then-
their defense to your claim, and also they do their offense to their claim.
And then plaintiff,
Plaintiff gets to do their defense to their
and they
claim and
respond
rebuttal.
only with respect to the.
Rebuttal.
To the
To their
rebuttal.
rebuttal to their counterclaim
counterclaim.
only.
And so it goes 1-2, 1-2, and plaintiff gets 2 hours, they get 2 hours.
Total.
Is it fine if it's not exactly 1 hour
Oh,
for each?
That doesn't
That's
matter to
up to
me.
us.
No,
Okay,
as
thank
long as
you,
your
Ron.
time is just 2 hours, it doesn't matter how much anybody does. with
Thank
it,
you, Ron.
Okay?
If you wanted to shorten that to about 15 minutes apiece.
I would want to short it to 2 minutes, but that's not my take. I
We
gave you
got
2
pretty-
hours. I thought
We
that was
got
good.
pretty efficient at the end of this
Well,
case.
it's amazing how that happens, It's kind of like the physics, you make a circle and the people will fill that circle. Well, that's what happens. I made a circle. Okay, so let's go ahead. Let me just go ahead and read into the record the order that I'm going to give the jury instructions. I'll also read in the record the instructions that were denied. And I will read the instructions that were withdrawn, just so we have a complete record, okay? All right, here we go. All right, so for the jury instructions, I'll read them in the following order. Number heard I, number 3, number 10, 1, B as in boy, C as in Charlie, D as in Delta, E as in Echo, F, G, H, 12, 13, Y, FF, AA, BB, DD, that's David, DD, TT, CCC, 20, Z as in zebra, T, U, V as in Victor, K, L, 5, 6, 7, 32, 8, 9, 16, I, 30, KK, and JJ. All right, those are the ones that will be read to the jury in that order. Okay. The ones that were denied was instruction 22, 23, 24, CC, NN, both as in Nancy, OO, PP, RR, SS, S as in Sam, SS, 28 and 29 were the ones that were denied. The ones that were withdrawn for the record was instruction A, 2, 4, 11, 14, 15, 7, 19, 21, 25, 26, 27, X as an X-ray, 31, W, EE, GG, QQ, DDD, Q, 18, J, M, N, O, P, R, S, HH, LL, UU, VV, WW, XX, YY, ZZ, AAA, and BBB. All right. So I will get you copies now. I'll get you hand copies of the jury instructions I'm going to read in that order, so you'll have copies when you leave here, okay? And I'll give you copies of the verdict form as well. And you can have those while you prepare for your closing arguments. Other than that, if you could come up to see Jamie after I leave the bench, just to make sure you go through the exhibits and everybody okays the exhibits, so we don't have to do that tomorrow. And also if you can have a look at the laptop with Sammy, just to make sure all your exhibits are there that are gonna go back to the jury, okay?
Your Honor, one quick question
Okay.
about closing to make sure
Sure.
we don't have any issues tomorrow. Understand the jury only sees evidence
Yes.
that they've seen in the trial. If that evidence is displayed through like a PowerPoint or whatever, are headings allowed, or do you not want the jury to see any written text or anything other than just evidence?
I mean, I've seen PowerPoints in cases before in med mals where they have their other items up there, but I think in this particular case, I'd rather just have no writing and just have your arguments orally.
That's fine. I just wanted to, make
Okay.
sure that there wasn't
Just try to keep it clean.
or paraphrasing of witnesses or anything like that.
Okay,
It's just,
that sounds fine with everybody. Does anybody?
that's fine with me.
That's a good question, though. Are you gonna have a PowerPoint?
Probably with evidence.
Okay.
You know.
Did you want me to have the big screen up as well? For the
I think
PowerPoint?
so. Yeah, I think that would be great.
Thank you,
Okay.
Your Honor. Yes.
Okay,
Thank
good.
you.
We'll do that as well.
And starts at 9.
Starts at 9. Closings start at 9.
So, Your Honor, Mr. Nadelhaft has a proffer still on some
Oh,
things.
yes,
'Cause
okay.
Do you want to do that now before we?
Sure.
As does
Yeah,
Ms.
everybody
Myers.
wants to hear your preference.
As does Ms. Myers at the end of Mr. Nadelhoff's.
Yeah, okay. All right, they have one too. So, that's all right. Go ahead.
Yeah. This will
If
be
you could just get to
shorter.
the microphone
Yeah.
so I can hear you better. Or the quote where I can hear you.
This will be shorter than the other day.
Oh, good.
Okay, this is for metadata. On May 16th and May 17th, 2022, the defendant attempted to introduce into evidence photographs from May 21st, 2016 that included metadata on the photographs. Ms. Hurd testified that the metadata was included on the photos by pressing a button on her phone. The metadata demonstrated the pictures were taken on May 21st, 2016, along with the times they were taken. The exhibits were defendant's exhibits 700 through 726 and are exhibits A through AA of the proffer. Tabs N and O of the proffer are now blank as defendants 712 and 713 were admitted. with the metadata on May 26, 2022. Mr. Depp objected to the metadata on the document, stating that the metadata was hearsay and there was no foundation for the hearsay. The court sustained the objection on the ground that the metadata was hearsay and that there was no foundation, and admitted the exhibits, but redacted the metadata. And then separately, we have a proffer for Stephen Duders. On May 20th, 2022, Ms. Heard moved to designate certain portions of the deposition testimony for trial of Stephen Duders, who was Mr. Depp's personal assistant. Mr. Duders testified that he was on the Boston flight and sat in a seat facing Ms. Heard and Mr. Depp. He further testified that the day after the flight, Mr. Depp told him he wanted to, quote, smooth whatever issue, end quote, existed with Ms. Heard. Mr. Depp asked Mr. Duders to, quote, write a text, end quote, to Ms. Heard and to say, quote, whatever she needs to hear, end quote. Mr. Duders then sent a text message to Ms. Heard about Mr. Depp, stating, quote, when I told him he kicked you, he cried, end quote. The testimony is contained in Exhibit A, Mr. Duders' deposition. Ms. Heard moved to admit the text message into evidence, arguing it was not hearsay under Rule 2:803, which provides for the admission of statements of a party opponent and his agents. Ms. Heard argued Mr. Duders was acting as Mr. Depp's agent when he sent the text, and the text message was therefore not hearsay. The text message is Exhibit B to the proffer. Mr. Depp objected to the text message as hearsay, arguing that although Mr. Duders was Mr. Depp's employee, sending text messages to Ms. Heard was not within the scope of the employment. The court denied the motion to admit the text message and testimony, finding that Mr. Duders was not acting as Mr. Depp's agent when he sent the text message. And I have copies to provide.
All right, fine. We can add it to
The
the
list.
list. We have a box for you. All right, we will add that.
Oh, sorry, Eric.
I think he has more.
And this is the other one.
All right, we'll make them part of the record. Thank you, sir.
Thank
All right, yes, Ms. Myers?
Thank you, Your Honor. On May 25th, 2022, plaintiff intended to call Dr. Kim Collins as an expert witness in forensics pathology. Defendants objected on the basis that Dr. Collins had not been designated as a defensive witness and was designated only to rebut Dr. Jordan, which was defendant's forensic pathologist who had not been put up at this trial. Dr. Collins intended to testify as to whether Ms. Heard's descriptions of violence and injuries allegedly sustained by Mr. Depp were consistent with the photographic evidence at issue in this trial. She also, for incidents where there was no photographic evidence, she would have testified as to what injuries she would have expected to see based off of the violence that Ms. Heard testified to. And finally, she would have testified as to her opinion as to the cause, or as to Mr. Depp's finger injury and what she observed, consistent of which was similar to what Dr. Gilbert testified to today.
All right, thank you. Any other proffers? Okay. All right, so just don't leave here until you check the laptop and you check all your evidence and make sure we get your checkbox on that and everybody's happy with it, okay? Anything else for the court?
Thank you.
Really?
No, thank you.
Thank you very much.
Thank you. Okay,
Thank you, Your Honor.
we'll see you in the morning.
All right.
All right. All right. I'm glad I stayed. All right. So court is now closed. So that was jury instructions and all of the objections that were disputed, apparently, or whatever, whatever they call, because I'm not an attorney, so I can't really speak on kind of exactly. It was very interesting to hear, though. And that's one of the reasons I'm fascinated with LobTube. I won't ever stop watching LobTube moving forward, especially just with, I think a lot of the LobTube is talking about keeping up with the Manson case. So that'll be very interesting. I am behind as well on the stream. So my stream was lagged. So if any of you guys stayed, then you, sorry. Wait, sorry. Where is it? Okay, wait. Oh, stop it. Stop. Woo. I'm so sorry. If I blew your ears away, I am so sorry. Man, I can't get over RIP for
Ray Liotta. I'm very sad. He was engaged, man. He was engaged. Anyway, sorry about that. Well, if anybody was tired, they sure aren't now. Um, so I wanted to go ahead and stay with that. I did see Ian Runkle in the bleacher in the audience or whatever. I forgot what it's called. So I definitely will be watching for Ian's live stream. I really like Runkle. I really do. He's a criminal attorney, I believe. I'm telling you, we have such an amazing community of LawTube. I think all of them deserve the growth that they're literally embracing. I mean, they're just skyrocketing, all of them. Like I said, I'm a big fan of Rob and a big fan of Emily, and I do like Legal Bites. I did watch them a little bit yesterday. My eyes crossed like 3 times yesterday. As soon as I got done with the stream, like I said, I went ahead and got off the computer, did some personal stuff, and then worked on the audio a little bit because I had that 5-hour audio. It is on the channel now. If you're watching this on Twitter and you managed to, if you were interested in the tail end of court there, then I do want to say that I will be posting the audios everywhere. That's my next task today. So I won't be staying on the stream for very much longer, you guys, because I definitely want to, I want to get the best of my day today, since I wasn't held up until like 1 or 2:30 in the afternoon on my time. Right now I've been streaming 5 hours, and I want to take those extra 4 hours that I normally hang out on, stream for court, and get some of my audios done. And I want to research some of that website we talked about. So, tomorrow will be closing arguments, as you heard, first thing at 9 o'clock. It will be 2 hours apiece. It was very interesting. I don't know if you guys saw that, but it was very interesting to see Camille talk about the rebuttal cross. I thought that was very, very interesting. But if it's not in evidence, she said, which I don't know. That was hard to understand, though. I mean, I'll have to watch LawTube, and hopefully someone will bring that up. I'm sure they will, but I feel like not a lot of people stayed to listen to the jury instructions. Maybe some people did. I don't know. A lot of people don't have the patience to sit through something like that, but I'm telling you, I am a sponge when it comes to any kind of seminar, webinar, lecture, classroom type of thing. I mean, I love surgery seminars and stuff like that. I just love them. I absolutely love them. That's why I went over Sam's interview. I may do Sam's a second time just because I think it's important to go over that one more time. Sometimes people don't catch streams, when they first start, and so I may go ahead and chop that one up. I just don't know. I'm trying to understand if I do a live stream and I do a recording. I'm trying to figure out how to repost that on my channel as a video. So what I have to do is do another live stream, go through Sam's interview, and then I have to um try to curve some of the conversation in the live stream, if that makes sense, to make it a repost on video, if that makes sense. So in other words, you do a live, it goes live as we are now, right? I'm audio. I understand that. Here, let me go ahead and just put this on me. Let me go ahead and put the camera on me so I'm not rude. I just been keeping up on Twitter. Here, let me see. Hold on. Let me turn on my camera. Okay. So what happens with the live? I mean, if you guys aren't aware, what happens is you actually run the live stream, right? And it's live, real time, as I am right now. Once I end the live stream, it will upload as programmed through YouTube or StreamYard or whatever, and it will post on my channel as is, with no cuts, no edits, no anything. I have the option, if I want, to alter that live stream either through YouTube or so this is kind of a quick YouTube lesson if you don't know. I have the option of either downloading this video and re-editing it in any way I want, or I can take the recorded stream from StreamYard and chop it up however I want and then re-download it to YouTube. The only thing I'm a little leery about that is because then it throws my streams out of whack. So in other words, since I've now have this court kind of sequence thing on my channel as a new streamer, I now have the sequence of court that I can add as a playlist, if that makes sense. So if I do my point being of getting into all these details, which probably nobody cares, but the thing is when I do a reaction on a long interview or video, such as Sam's, if I do it again, then I would in turn download that video, chop it up, and then just put my reaction to the video, if that makes sense. In other words, so all the conversation thereafter in the middle, whatever, I would chop that up and, curve that, edit it, slap it together, and then put it on the channel. So that was my point with that. But it takes things out of sequence when you're doing it real time live, because then it just becomes this library that's in sequence every day. That would be 1 day, 2 day, 3 day, 4 day, So if you revise that video at all, then it takes it out of whack. And so my audios right now are the next thing that are going on my channel. So today I'm doing several audios that I have available now to release on my channel. If anybody wants to go through, because this week people, what I think is going to happen is once the jury is let loose, to deliberate, I think some of the public, honestly, will go back and try to revisit some of these audios. That's what I think. And I think you should. Because if you haven't heard the audios, as long and painful as they are a big part of this evidence. The photos and, experts and, PDFs and all this stuff and transcripts and whatever, I think the audios play a key role because there's more audios than there is video, if that makes sense. And these loop conversations that they have are very long and lengthy, and they are almost redundant and repetitive. But in these audios, I think that will be a key factor for the jury, because I think Amber is leading those mostly, and you hear her just kind of loop. You hear the aggression in her voice. You hear the manipulation. You hear her kind of changing personalities, if that makes sense. You hear her getting combative. You hear her even break things in those audios. And I think they're very important. I think if you, I'm not sure. I'm not sure. I mean, it's very, very touch and go at this point. I feel like I don't know where the jury's going to stand. And after listening to what's being actually, being put in as for the jury in the laptop and stuff, and the way that it was, that's why I really, really enjoyed watching that, because I really wanted to know, when we don't see things like that, as the public, you don't really know what they determine behind after the cameras go away or whatever, and they're all in there by themselves and they're arguing this or arguing that. So you really don't know initially what the jury's going to see, you know what I mean? What's really going to go into evidence in terms of how it's going to be revised or whatever. So that was very, very interesting, especially when it comes to the op-ed and the tweet, what they were talking about in terms of the tweet. Is it going to be considered malice in terms of, if you heard that part, remember where they were talking about the hyperlink as republication or something, and to reach a bigger audience or something like that. And I think that falls into malice, if I understand the law tube correctly, but I'm not an attorney. So if you have a better way of conveying that, put it in the chat so someone that visits the stream later will see that. But I do think the audios are I think they're a big part. They're only a fraction of it, honestly, but I mean, they are a big part. And I think people are visual, and I think audio, has a lot of impact. Paperwork is paperwork, if that makes sense, and like I said, people are visual and we're very audible, right? So like audio, listening to the tapes and stuff like that, and they have days of it, so who knows, maybe they'll come back in 1 day, as I think Candy said, or maybe they'll come back in a week, who knows. But either way, they've heard a lot of audios in court as well. But it's like anything else. It's like you go through training. Let's use an example for a job. You go through training for 6 weeks, and then you're let loose by yourself, right, to do the job. And then you forget half the things that you learned until you actually practice what you've learned, right? So I think that's kind of what it's going to be. I think they're going to remember parts of the audio. And I think, they're not going to and remember the way that it was presented in the beginning of the case was to benefit each side, right? So until you hear the audio in its entirety and you piece it together and you understand the context of the audio and the way it impacts you or has an effect on you, I think that's when you really kind of understand and you form somewhat of an opinion. You have to factor all those other things, but at the end of the day, like I said, at the end of the day in their deliberation, it's about defamation. It's about defamation. And did she deliberate? I mean, and did the allegations that are relevant to the op-ed, did they really happen? Did they really occur? Can she really, I don't know I don't know what they're going to do about the title, but I guess that falls into like, why didn't she bring it up in the UK case? All of a sudden now here it's been brought out in the US, as many people have stated. There's so many people that have so much, so much information about this case and stuff like that. So let's see. This will be said by the Amber supporters. Oh wait, they both are guilty of both abusing each other. This will be said by the Amber supporters. Not that push will come from people. Not that push will come from people's social media. Some of the people that were very vocal in support of Amber Heard will not be able to admit that they were wrong. It happens on every case I've ever seen. Were you an attorney? I'm just curious. Like, do you have some background in legal? I'm just curious. Yeah, I mean, like I said, I'm not an attorney. I'm just trying to learn from LawTube and, trying to like I said, I think this has been a learning experience for a lot of people, not only content creators, but also just, the way that the legal system works in terms of defamation. I've always heard, I mean, because Emily has covered a lot of defamation cases on her channel, even for YouTubers. I don't know if you guys know, or if you've been following Emily for a while, but she was covering the Tati James Charles case when that was a big deal. And, she just covered the Kardashian defamation case with Black China. She also covered, there was another defamation case that she was talking about too. So she's been covering a lot of defamation. I guess it happens a lot in the entertainment industry, but I know that I know the bottom line of defamation is it's very hard to win. I mean, that's kind of been a given, but this is just, I don't know. I feel like there's been so many things that so much of LawTube and everyone says they've never seen before. So it's going to be very interesting. And this is going to be one of those things I feel like a lot of jurors are going to come out and talk about later. You know what I mean? I just do. Their experience with this. I mean, it seems to me very, very similar to the experience of the OJ Simpson case, as much as it was televised. It's going to be very interesting the way the public reacts to whatever the verdict is. That's one thing I'm so glad I'm getting Twitter established now, and I'm building a following, and I'm so glad I'm streaming now. And, I'm just really happy I'm kind of a content creator in this sense at this point, in terms of doing opinions and in terms of, doing reaction or commentary. I think it's, I guess I'm very excited about doing this and building a following as I go. But yeah, it's going to be very, very interesting. A lot of people are still talking about it on Twitter. Twitter's still going on as we speak. And we will be back at regular time tomorrow. It's going to be interesting. Now, if you guys heard, I don't know how many of you are watching me on Twitter or if you stopped in, but they did say that there's going to be a screen up tomorrow for closing arguments. So that was kind of interesting to hear. I'm sure Ian will probably talk about that, which is Runkle, when he has his live stream. I did not see Larry, the DUI plus guy, the DUI plus guy, I think it is. I didn't see him in the gallery, they call it, I guess. And I didn't see James, the court guy, in there. I only saw Ian. So I think it's going to be very important for you to catch up with Ian's live stream later on. Make sure you're subscribed to Runkle's channel. I'm sure he'll invite Rob into that, and to probably discuss it. Maybe he'll have multiple people in there. I don't know. Or maybe it's, Queen Camille is Queen Camille is actually trending right now for her rebuttal. Right? Did I say that right? Did I say that right? Rebuttal. Did I say debuttal? Oh man. Anyway, she's trending right now for her recent cross. But anyway, just make sure that you are subscribed to these LawTubers, because I think it's very important. You learn a lot. I mean, unless you were I have experienced court several times in RL. I don't know what RL means. Oh, okay, I see. I have followed many cases. I'm not credentialed. Are you a reporter of some sort? I mean, I don't mean to pry. I'm not trying to, I don't have any business asking you that, but I was just curious because it seems like you know a lot. You have a lot of experience. It seems like, or the way that you're understanding everything. I think. What's my other viewer that comes in and out? Ace. I think he has the same kind of experience. I don't know. It's interesting to see the people that observe things on YouTube. You never know really who's behind the handle, if that makes sense. But anyways, I think it's going to be a very interesting and anxiety week. Tomorrow I think it's still going to be an anxious, sort of high anxiety day. To watch the closing arguments. I think that all eyes are going to be on tomorrow. I think there's going to be a lot of sitting on the edge of your seat, wondering how their closing arguments impact the jury. So I think that's very important to consider. But I really, really enjoyed watching those jury instructions. I really enjoyed watching the judge in action, and the two teams kind of talking about this and talking about that. And it was also very interesting to see the other attorneys that are, part of Depp's team. And as you could see, Camille was asking for something. She was asking for part of the crop. Did I say that already? She was talking about audio and deposition. Another witness that didn't get to appear or something like that. So that was interesting. But as you can see, I want to show you one thing. Amber Heard today on the stand. I've silenced and I want my voice back. So I want to show something really quick before I close this out because I do have to go. I have other things on my account I have to do today. I just want to really get caught up because I want to get some releases out. I want a video to go out every single day today. So, I mean, every single day. I've dropped my first audio video today, but I need to work on my stuff because I've been kind of sidetracked with this, and I haven't really had time to do a personal live stream other than streaming with the court. But and as I said, me and Candy will get together this weekend, and I'm trying to get my brother to come in on there, and my son also on that panel. So we'll see. I also have another person that is interested in coming on the stream to talk about the trial. So I will be having more, if I can hook up with different YouTubers that are interested in coming on my stream. I have to learn how to collab. I'm not that far yet in this community, so I have to keep trying to promote myself and see if I can hook, see if I can get connected with other content creators in the commentary and reaction community to see if maybe I can get together with someone that has a voice when it comes to this as well, especially once the verdict comes out, because I would love to have a deep conversation with somebody. Anyway, oh, I wanted to show you something on Twitter. Hold on one second. Let me re-add this. Let me re-add this to the stream. So I'm going to put this kind of close to me just for a second. Actually, no, I need to do this. I need to do myself smaller, huh? Let's see. So someone just posted this Lily Jane 916. If you want to follow her, she's been posting some really good stuff in reference to Amber and the case, really just in general. But she posted this examples of a lot of people have a lot of 2016 information. So she says, Amber Heard today on the stand. I've been silenced and I want my voice back. Examples of Amber Heard from 2016 to present being silent. So these are all the headlines that came out: USA Today, Glamour, Entertainment, Bizarre, Variety. So she's had Speaks Out, Amber Heard Says, Amber Heard is Nobody's Victim, 2018, Amber Heard Speaks Out, Bizarre, 2017, Variety, Amber Heard reads letter about Johnny Depp allegation, Me Too, 2018. So she's had plenty of time to stand in. Here's another one, 2020. Check out why oh my God, she just never stops. And she wasn't really a victim. That's the problem. She just wasn't really a victim. I don't believe a damn word that she says. I'm just saying that, in my personal opinion, I do not side with Amber at all. That's just me though. So Amber Heard pens powerful open letter on domestic abuse. People. This one was 2016. Amber Heard speaks up, 2016. So she just wants her voice back. Yeah. Okay. Well, she's been, talking about this nonstop year after year after year after year. So, um, no, just a guy who has received a lot of, oh, wow. Geez. I'm sorry to hear that. It's an insult to ever suggest her voice was silenced by anyone or the law, so insulting to everyone. Yeah, I mean, like I said, this is one of those things where we're right down in the knit and grit of what's really going to happen and how this will actually go down in history, if you will. So, the trial itself and all the evidence that's been presented, but, it's the verdict and what really happens at the end. So, the real Laura B just posted this an hour ago. If you're not following the real Laura B, please do. She's been following this case since 2012 or 2013. But Amber Heard said that's why I wrote the op-ed about him. Did you hear that right? So a lot of people have picked up on that in her cross, that she said that's why I wrote the op-ed. So here is Camille leaving the courthouse, which must have been just minutes ago, because this says 3 minutes ago. Sometimes you have to just love the Daily Mail. Camille Vasquez eviscerates, right, Amber Heard for perjury of tipping off paparazzi. So who knows how this really will affect everything. This was in the Daily Mail. So yeah, I mean, I think we're kind of, at the mercy of waiting to, oh, look at this. What a capture. She does not like her. That's so funny. Joining with everyone else, so proud of Johnny Depp, no matter what the world listened and heard your voice. That's kind of touching. Um Gosh, I feel bad for him because he's aging, and he spent the better part of his prime time of life, going through this. And whether or not, a lot of what they were accusing him, a lot of people were affected by, that he called the studios and that. I don't know. I'm just not affected by all that. Really. I'm not affected by all that. It doesn't affect me the way that I don't believe Amber Heard. I just don't. I don't. I'm not saying that, like I said many, many times, I'm not saying that there wasn't some kind of mutual stuff going on. But as far as the initiator, as far as the one that took it there, if you will, it was her. Because he does not seem in any of those audios as a person that likes to be in that particular space. I think she provoked a lot of it. I think she liked to stir up things and push his buttons. I think she did it on purpose all the time. I think she was very upset about him not spending as much time with her, or I think she was very, very envious and jealous of him working more than her. I think she expected to get a boost out of this, immediately from being with him. I think she expected more out of her career. I think she expected it to blossom much faster than it did. And like I said, I don't believe that at some point in the relationship, even in the honeymoon stage, that he didn't express that he was hoping to have a partner that was this or that or the other. But then on the flip side of that, though, it's hard for me to think that he did that he felt that way either, because of because of all the women that he'd been involved with that are in the industry, such as Winona Ryder, such as all of the actresses that he's hooked up with, over the years, and the long-term relationships he's had, in reference to Kate Moss, who was a model, and in the spotlight all the time, in fashion. That's what they are, they're paid to be looked at, that kind of thing. We've got Victoria's Secret and all that kind of stuff. And even in the 90s, that was like when, what's the girl with the mole? I always forget her name. But there's been a lot of in documentaries about photographers and stuff, and the way that the modeling scene was, the way that scene kind of appeared in the 90s. And there's a good documentary out there about that photographer. He was super famous. I want to say her name was Christy something. I don't remember. Anyway, there was a lot of famous models right around that time. Even the girl that played who's the girl that played the video game? Remember, she played the video game girl, Jovakovich or something. Who did she play? She plays. Oh man, she plays a superhero kind of thing. Like it's kind of like a zombie movie. I can see her right now. Her name is Javakovich or something. She was in Independence Day. I can't remember her name. But anyways, she was a model too, So anyways, all I'm saying is all his past partners have been in the industry, and he's never been I don't know. It's just hard for me to believe that he was that like. I don't know. I wasn't there, so I don't know. But he just doesn't strike me. And I don't think that Kate Moss just came out to defend him because he can persuade her. I don't know. I think that reflects poorly on Kate Moss too. I think if she came up as a witness, she wants to be heard like that. No, that this rumor that everybody talks about, that's been talking about over time, it wasn't a rumor. It happened to me, and this is what happened. So, and she was very stoic. You know what I mean? Like she wasn't. I love the way she just answered the question. She's very soft spoken, also. Yeah, he talks to some friends and he vented and got it off his chest about Amber. Yeah, Johnny said that some raunchy stuff about Amber, but for anyone to hold that against him as is, well, that's a bit of a strong. um, uh, then they never encountered a person like Amber. Those people would become irate over Amber just the same. Everyone has a breaking point. It's so fake to act like they don't have a breaking point. Well, I think the jury's realistic. I think like Legal Bites was saying yesterday about anyone that's had a bad breakup or anyone that's had a sort of a messy divorce or anything like that has always, or anyone that's even been in a fight, with a partner or a loved one. The point being is realistically in real life, everyone says things they don't mean. Everyone has, everyone gets into a space in disagreements or exchanges with their partner when they're upset or angry and says things they don't mean and says ugly things or has shared, frustration and agitation to their friends or family or whomever, So, I mean, without that, you don't have a way to really communicate your true feelings to the people that you love and trust. So for him to expose himself, like he said up on the stand, he said, it's like, who splits themselves open in this manner? I mean, he's been stripped of everything at this point. So I mean, he wouldn't put like she already drug his name in the dirt and he wouldn't have exposed. I mean, he literally stripped himself in this. I mean, he took the chance, he was bare. He was 100% exposed. You know what I mean? Like there was nothing. He just he was transparent, in my opinion. I mean, that's what's changed my opinion about him, that he humanized himself and, and took accountability for all of his faults and ailments. But the one thing he stood true about is that he did not do what she's accusing him of doing. And I believe him. I just believe him. I believe him. I think if he was out to hide, anything, I think he wouldn't have been so eager to tell the truth, because he's been like suppressed and shushed and hushed and, legally and all this stuff. He couldn't say anything. And, and hopefully the jury can take that into consideration if they have means to see the transcripts from the UK as well, to see and learn that he could not provide this type of defense for himself in the UK. They have different laws and different ways. So I just feel that we still have a big mountain, we still have a big mountain. I mean, but the arrogance and her attitude, man, this last couple of days, yesterday with that smirk and that smile, and yeah, I mean, that's what makes her. I really honestly think she's psychopath. I think she's a psychopath. There's no doubt about it. I'm serious. And even in that interview with Sam, which I will go over again, I think is he talks about there's a very small percentage of psychopaths that actually are intentionally out to deliberately hurt people. Like there's a certain class of psychopaths that actually are out to literally obliterate and destroy a person until they're literally on the ground and have nothing. So that's pure evil and hatred. I mean, you have to have a lot of hatred in your heart. So for her to say, I love Johnny, this and that, I don't believe a word of that. I don't believe a word of that. Amber Heard makes tearful return to tearful. Where's the tears? Denies leaking photos. Tearful? Is the New York Post for real? Because I didn't see a tear. I didn't see not one tear. Oh, God. Anyway, what did Christina say? Let me see. What tears? Oh, my God. I got to retweet this. Anyway, so that's all, you guys. I'm gonna go ahead and close out. Thank you so much, Eve, for being here. Thanks for hanging out with me and thank you, Candy, for checking in, and anyone else. I know, is it Geesey, who came in? We haven't seen Marilyn in a couple of days, so she must be busy working or something. Um, I know, we've had a few peaks, if that makes sense. So we've had a few people that have peeked in and kind of and gone, come and gone, if that makes sense. Oh, I'm sorry, the New York Post. What did I say? Oh, yeah, that's true. That's true. Um, so anyway, thank you so much for hanging out. I'm going to go ahead and wrap at this point. We'll leave it on that. We'll leave it on this note here. But yeah, I'm going to work a little bit on my channel. So if you're subscribed, there's going to be some videos that, come out if you haven't heard any of them or you want to support. I'm going to work a little bit as well in the description box. And I've taken into consideration the Venmo thing, the PayPal thing, the Patreon that I built. I don't know, I'm thinking about connecting back to Twitch. I have to have patience with Twitch cuz there's a lot of young gamers and I don't know. I mean, I've never been in that community before, but what I had to put up with before, and when I use StreamYard even to connect to Twitch, I don't have any way to pull those comments when these young kids come in and start talking things that I'm not fond of at all. You know, just little kids. I'm talking about preteens or teenagers. I want to keep my channel. And if I do turn this into podcast at any point, I want this to be grown up and mature audio. So anyway, but yeah, so that's what we're going to wrap on the the New York Post, which is kind of funny, but I will return tomorrow at 6 a.m., 9 a.m. Eastern time for closing arguments. We'll definitely have a live stream. Tomorrow's Friday, which is an unusual thing because we don't normally have court on Friday. So this is going to be interesting because we're not used to going 5 days in a row. So Saturday, we will have a live stream. I'll probably live stream on Sunday as well. I got to put some material together for that and then start planning on what's next for my channel. Yeah, I'm going to catch up on a little bit of LawTube, and that'll kind of incorporate with the conversation. I will check with my son and my brother tonight and see if they want to join the panel when Candy comes on. I think the more the merrier kind of thing. And like I said, do expect more panel discussions on different topics as the weeks go by if you're peeking in at this point, because I do intend on having good commentary on here. But yeah, so that's it. I hope that you have a great day, E. I hope that you can catch up on your sleep and, get some sunshine or whatever and enjoy your day. And I will see you tomorrow at 9 a.m. or 6 a.m. my time. But actually, I think I'm gonna program. So you'll see just in a few minutes, you're gonna see the new post program for tomorrow. So I'll probably come in at 5:30 because it's the wrap. So I'll come in a little bit early, and we'll talk and see what's going on Twitter and stuff like that, and then we'll be ready for closing arguments. So thanks so much. I hope you take care, and I will see you guys tomorrow. Take care, y'all. Bye.